Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, January 28th, 2025. We have 10 bills on the docket, and we'll start off with Senate Bill 84. Senator Quarterman, welcome.
Thank you, Mr. Chairman. Vice Chair Wall-Striker, members of the Judicial Proceedings Committee. For the record, Senator Paul Quarterman, District 2, representing Washington and Frederick counties. Thank you today for the opportunity to present Senate Bill 84, Department of Public Safety and Correctional Services study on location of individuals prior to and following incarceration. Most of you are familiar with this bill as we had it last year, but obviously we know we have some new members here as well, so we'll go through it here pretty quickly. As of last year, there are around 16,000 individuals that were incarcerated in Maryland correctional facilities across the state. Washington County is home to 3 of those correctional facilities that houses around 4,600, roughly 30% of the incarcerated population. Obviously, while there are many schools of thought regarding reentry and recidivism, we can all agree that finding the best and most successful path forward for these individuals is something that we should always strive for. Without the proper support systems in place, a disservice is being done to these individuals being released from our state correctional facilities. The Senate Bill 84 would require the department to conduct an annual study that examines and compares certain data regarding an individual's residence prior to incarceration and or release from the state correctional facility. Communities need to know where individuals are originating from and where they are subsequently returning to, so we can make sure that we have the proper support systems that are in place to provide success. Because if we're not providing those services or the support necessary as individuals are being reentered, there's a far greater likelihood that they will not be successful. And obviously when that occurs, we have failed. We've not only failed that individual, but we failed our communities. And so we need to obviously be working toward having a successful path to reentry. So we want to be able to set individuals up for a better life in the future as they move forward. It's important to understand more about the reentry process. And I guess basically to kind of sum it up, why I mentioned at the beginning that I know a lot of you guys have heard this in the past. I do appreciate some of our new members are here today because the cross-file passed out of Judiciary last year unanimously. It also passed the House floor unanimously last year as well. And so we appreciate your support and thank you for the consideration and look for a favorable report.
Excellent. Thank you very much, Senator Quarterman. Questions from the committee? All right, seeing none, thank you very much.
Thank you.
With that, that'll end the bill hearing for Senate Bill 84. We'll now move on to Senate Bill 75 if Senator Benson is here. Welcome, Senator Benson. Come on up, Senator.
Good afternoon, everybody.
Good afternoon.
Thank you very much. Thank you very much, Mr. Chair, Mr. Vice Chair, members of this committee. Before I begin my testimony, I just want to provide for you just a little history regarding how this bill was born. I head up in Prince George's County what is called the Greater 202 Coalition. And one of the concerns that they have had was what has happened relative to our teenagers getting into trouble in Prince George's County, the great state of Maryland, the metropolitan area. And this has been a constant concern of people in the 202 Coalition. We have a membership of about 1,200 people. And we talk about it all the time. So they asked me to please put a bill in because we have become gravely concerned about what is happening with our young people in the middle of the night who are out on the street carjacking and doing things that are very illegal and not right. But it's not just that. We also have a problem with youngsters not going to school. The absenteeism is a problem. And so as a result of the conversations that I have had, not only with the 202 Coalition, but with my church and with many of the homeowners associations and civic associations, I was asked to put this bill in. So, Mr. Chairman, Mr. Vice Chair, and esteemed members of the Judicial Proceedings Committee, I'm here today to express my strong support for the Parental Accountability Act, a crucial piece of legislation aimed at fostering greater responsibility and involvement among parents in the lives of their children. As a resolute public servant, an advocate for education and community well-being, I have witnessed firsthand the profound impact that parental involvement can have on a child's development and behavior. And by the way, for those of you who don't know, I have been involved in the Prince George's County Public Schools, Calvert County Public Schools, and for 50 years, and I'm hoping I don't look that old. The Parental Accountability Act seeks to address the growing concerns about juvenile delinquency by holding parents accountable for their children's actions, thereby encouraging more proactive approach to parenting. This legislation is not about punishing parents, but it's about empowering them to take an active role in guiding their children toward positive behavior. By allowing judges to levy fines or mandate community service for parents whose children repeatedly engage in criminal activities, we are creating a framework that promotes accountability and responsibility. This approach not only helps in addressing the root causes of juvenile delinquency, but it also fosters a sense of community and shared responsibility. Moreover, this bill includes provisions for wrap-around services, particularly fostering on mental health and related support services. This comprehensive approach ensures that families receive the comprehensive support they need to address underlying issues that may contribute to delinquent behavior. By providing access in mental health services, case management, family counseling, and educational support, we are equipping parents with the tools that they need to create a nurturing and supportive environment for their children. It is important to note that the parent accountability legislation also includes provision for community services as an alternative to fines, recognizing that not all parents may have the financial means to pay. This flexibility ensures that the legislation is fair, equitable, providing opportunities for parents to contribute positively in their communities while addressing their children's behavior. I believe that this legislation will have a significant impact on our communities by reducing juvenile crime rates and promoting a culture of accountability and responsibility. It aligns with our shared values of community, family, and education. Gathering specific numerical statistics on the effectiveness of parent accountability laws can be challenging due to the variability in how these laws are implemented and measured across different states. However, I have provided some general insight based on available data and studies. Reduction in juvenile crime. You all have my testimony, so I'm not going to go through all of that. Recidivism rates, the impact, school attendance, parental involvement. That's what the status shows. And we have looked at every state in this country where parental accountability laws are in place. Finally, the Parental Accountability Act is an important legislative step aimed at promoting responsible parenting and ensuring accountability by holding parents accountable for their children's criminal offenses. The act provides a mechanism to encourage better supervision and guidance. While some may argue that it can unfairly target working parents with limited resources, the provisions of the community service as an alternative to fines offers a balanced approach. Overall, the Parental Accountability Act seeks to enhance community safety and support the well-being of children through greater parental involvement and responsibility. I am strongly asking this committee for a favorable vote and support of the Parent Accountability Act legislation to encourage vital family and community engagement by promoting responsible parenting and accountability. This act not only helps guide our children toward better behavior, but also strengthens the fabric of our neighborhoods in fostering a collaborative effort toward parents, schools, and communities. We can create a safer, more nurturing environment for all. So let's work together to ensure every child has the support and guidance they need to thrive and succeed. I thank you so much for your time and your attention, and I am therefore respectfully asking this committee for a favorable vote. I thank you all so very much.
Excellent. Thank you very much, Senator. Questions from the committee? All right. Seeing none, we'll move on to the, there's a witness signed up for informational purposes, and then we have an opposition panel. So we'll hear from informational first. Is Chrissy Costel here? Excellent. Welcome. Come on up. Thank you, Senator.
Thank you.
Thank you. Good to see you.
Good afternoon, Mr. Chair, Vice Chair, and members of the committee. My name is Chrissy Costel, and I'm here on behalf of my fiance, John Berardi, who just underwent surgery last week due to a brutal attack, and post-surgical recovery requires him to lie face down 24 hours a day, even right now as I speak to you. John was violently assaulted by juveniles last November in Federal Hill while walking home with pizza. Despite handing over his pizza, he was struck in the face with a metal pole, fracturing his nose, splitting open his forehead, and causing permanent vision loss in his right eye. Since then, we've endured countless medical appointments and even spent Christmas in the hospital. Although we remain hopeful, and despite undergoing surgery with more to come, doctors have confirmed his vision damage is permanent. John's story shows how Maryland's juvenile justice system is failing to protect residents or hold violent offenders accountable. The recent study on the DJS presented here found that 54% of repeat offenders are caught and released, and 70% of referred juveniles receive no rehabilitative services, leaving them without the tools to change and emboldened to commit more crimes. The juveniles who attacked John remain free to this day, shielded by laws like Maryland's Child Interrogation Protection Act, which makes it nearly impossible for police to question them despite their senseless violence. They left his phone and wallet behind, then reenacted and boasted about the attack on video. This wasn't desperation. It was a crime enabled by a system without accountability. Across the city, a clear pattern emerges. A wife's hair set on fire. A 66-year-old man stomped unconscious. Numerous residents carjacked at gunpoint. A baby's life threatened. Just a few of the countless violent acts committed by juveniles who were all released the same day. Without public safety, the walkability, community, and convenience that define city living vanish. Law-abiding citizens are left with medical bills, trauma, and the knowledge that those responsible face no meaningful consequences, while others leave Maryland, taking vital tax revenue with them. How is this acceptable? Please do not overlook these stories and patterns, and please correct these injustices as you consider solutions in current and future legislation. Thank you for your time.
Thank you very much, Ms. Kostel. We have a 2-minute time limit, but you give a little bit of grace to folks that share their personal stories, so that's why I went a little bit over. Thank you for sharing your story, for coming up forward, and we obviously wish John a speedy recovery. So thank you for lending your voice to the debate. We have a few questions from the committee. We'll start off with the Vice Chair, Senator Wallstreicher.
Thank you so much. I'm so sorry to hear what happened to your fiance. Do we know if the boys who were involved in your fiance's attack had previously interacted with the Department of Juvenile Services?
The detective told us he believes that he knows who they are because they have committed previous crimes and were involved in the system, yes.
Thank you, Mr. Chair. I know it's difficult to come down and stand in a public forum like this with cameras on you. I just want to say I admire your courage in doing it. You've suffered a terrible problem in your life, and your boyfriend is going to be marred for life as a result of this. I really appreciate your interest in coming down and sharing the story with us. Thank you.
Thank you so much. I appreciate that. It's changed our lives forever, so we want to do anything that we can to prevent this from happening to anybody else, because no one should have to suffer like he's suffering like right now, like his whole family is suffering right now.
I want to echo my appreciation. It's so hard to come down here. It's very, not a normal setting, and then to have your personal situation and the anguish and the pain that you and your fiance have been going through. Yeah. So I know how hard it is. If you know, the juveniles that were involved, do you know their ages, and has anything come of it in terms of, if not prosecuting them, getting them into the juvenile services system to, face accountability? Just a little bit that you might know, and it's okay if you don't.
Yes, I'm not aware of their exact ages, but they are juveniles. And as far as the current case, the detective knows who a couple of them are. However, with current laws, he is unable to do anything. So they are roaming free and fully able to commit more crimes. We would need a parent, teacher, somebody to come identify them, because police, despite knowing who they are, they're unable to question them.
And I assume because of the condition of your fiance,
Yeah.
he can't or isn't able to, I don't know, identify them or, from pictures, or give other evidence. I don't know if there were any video. We do have some video around the city. You're not aware of that kind of evidence yet being collected, is that correct?
Well, so we actually, I was told by the detective we have excellent evidence, and we do have multiple clear full face shots of them.
Okay.
But we just need somebody who personally knows them to come forward and provide their identity, because right now with current policies and laws, there's nothing else that can be done despite having full, very clear shots of their faces.
Yes, I can imagine how frustrating and awful.
Yeah.
Thank you very much.
Of course, thank you.
All right, thank you very much, Senator James. Further questions for the committee? All right, Ms. Costello, thank you very much.
Okay,
you.
thank you all.
Thank you.
Appreciate it.
All right, we'll go to the final witness for this bill. It's Robin Salter from the Office of Public Defender, signed up in opposition.
Good afternoon, Chairman, members of the committee. My name is Robin Salter. I'm the Regional Director of Youth Defense for the Maryland Office of the Public Defender. Today, I ask you to find an unfavorable report for the Parent Accountability Act. Clearly, in our opinion, SB 75 is duplicative of laws that we already have codified for how the court is to proceed. Specifically, in codifying parties, the code already says that the parties are the child, parent, guardian, or custodian, and other agencies involved. When we talk about delinquent children, the child and the parent is already part of the proceedings. There is a treatment service plan that is codified. That codification includes the implementation and what happens when it fails. Also, the juvenile court has broad discretion in the authority of the court, for which the judges already take inquiries into parents' actions. The court can hold show cause or contempt hearings against any party, including the parent. And when it does hold show cause and contempt hearings against parents, they do issue orders for parents to participate, and they do hold sanctions. When we talk about children who are truant, I live in Prince George's County and I work in Prince George's County. The schools make the referral for truant children. The parent is prosecuted, not the child. The penalties for that parent not participating in the diversionary efforts, not ensuring their child going to school, includes jail time and a monetary fine. It is up to the court. But the efforts are still to get the child in school. And when we talk about children who are not part of the delinquency system, we talk about children who are in need of services or in need of assistance and part of the foster care, there is already a treatment service plan. There's a case manager social worker who ensures that all barriers are removed so that parents can participate and that child. Parents who do not participate are at risk of losing their children, and the goal is always reunification. But when it's not, then that child and that family moves on to other punitive damages, such as removal of that child, long-term foster care, or adoption. So I'd ask you to find an unfavorable report. Thank you.
Thank you very much. Questions from the committee? We've got, I saw Senator Fulton first, and then Senator Muse.
Hi, thank you for coming down. So I just have, you're with the Office of the Public Defender?
Yes, sir.
Are you representing just Prince George's, or are you representing like all?
I'm representing the office. So when I spoke about the remedies or that's how it happens in all counties.
So, you know, it's interesting because we just had the Secretary of Juvenile Services down here a week or so ago for a hearing. And we learned that we have a program that really fails. And you're up here talking about, you know, that juvenile court has broad discretion, and that, you know, did you realize, I mean, are you aware that if the parents don't show up for a hearing with the child, that they're dismissing these cases in juvenile court?
So I don't want to burden shift. The only person who can dismiss a case is the prosecutor has to make a recommendation, and the judge. That wouldn't be on the defense, that wouldn't be on the parent, and that certainly wouldn't be on any other party.
I understand.
Yeah.
But what I'm saying is, are you familiar, are you aware that certain jurisdictions, probably the jurisdiction potentially where this assault that we heard about today occurred, has cases against juveniles being dismissed because they don't show up? So there's zero accountability.
So clearly we're speaking about the parental accountability, right? And so I think clearly the court has permission to either hold out the abeyance of the dismissal, order the parties in, issue a writ, but that's still all codified. This bill
Right.
doesn't change any of that.
Well, actually, I mean, the senator is bringing forward a measure that's going to help. She's trying to facilitate another method because the program that's in place that you're speaking of apparently is failing. And the secretary came in and basically tried to say, well, we have such low recidivism rates, and then tried to argue about what recidivism really meant. I mean, recidivism is, it's in Merriam-Webster's, is the same action repeatedly occurring. It didn't matter about conviction. If you're stopped and met with the law enforcement and you're having these issues, you're committing the same type of offenses, that would be recidivism, that they're doing the same type of offenses that get them involved with law enforcement. So for the last thing, and I just wanted to ask you is, the programs that you're speaking of, are you familiar also that as DJS has programs that are nice and shiny, and they have zero outcomes for them? We get zero reporting on the success of these programs that you're talking about.
So in reference to the Parental Accountability Act, I don't believe that the parent will be producing the report. You would still want to measure. That still isn't changing what this is here for. If certainly the agency wanted the parents involved and then measure that and how it's evolved, how it's efficient and efficacy, you could get that data. But just because it doesn't exist doesn't mean that you don't have parents that are participating, that are doing the things they're supposed to do, and judges that are issuing orders when necessary to hold parents accountable.
So to be clear, you're the one that brought in that there was already law that allowed for this.
Yes.
I didn't bring that in. So I want to be clear that when you're saying going back to the Senator's bill, the Parent Accountability Act, you came up and testified that there's already measures in place. That's why I'm saying the measures you're speaking of they're failing across the board.
Well, I would say respectfully, if you don't have the report to show that, how do you know it's 100%?
You know why we don't have the
Or we're
report?
not talking about a marginalized number of people that it's failing for. So I would disagree that there is complete failure, because I also am a litigator and I am in court with clients and their families daily, and overwhelmingly parents are showing up with their children. Overwhelmingly parents are participating. Certainly when we talk about certain instances of kids, you will have that. But that doesn't mean it's a parent. We still have to take into account that this system have children in it, delinquency and otherwise, that are foster children or do not have traditional families or other reasons. And so when we have to look at that data and not just say it's always parents. What happens when you are dealing with a child who DHS is the parent? Is the foster parent supposed to show up, or is the agency supposed to show up to ensure that? I'm saying that in the law that we already have, it is codified for how that is supposed to be handled, and the judges have discretion to handle that. And judges do inquiries all the time to figure out why this is failing and if not, and when it's not happening in accordance with the law and there's no justification. Judges do hold parents accountable, and they do issue orders. Parents are, in the truancy world, in different counties, being jailed when they don't. But I can speak to you from what I know in terms of what's happening and what I see daily in court and what I know is happening in offices in our interagency meetings. And so I'm not disagreeing that there should be a measurement to. I'm saying overwhelmingly parents are participating, or you would see more judges issuing orders against parents for not participating when the child is found delinquent. A dismissal is not a delinquent. That means we're not prosecuting this child, but we're talking about delinquency when they are being held accountable before the court.
Okay. I would be curious to see the numbers of the number of parents who are being incarcerated for just something as simple as delinquency, like you're saying, or truancy. And that's a separate discussion, but obviously we're not going to agree on this, but I appreciate you coming forward, and I thank you for your time.
Thank you.
Hi.
Hi.
Welcome.
Thank you.
Let me first say respectfully that I agree with almost everything, if not everything, that my colleague said. I think that DJS is miserably failing our kids. Having said that, you said that you're already doing everything that's in the senator's bill. Is there anything that's in her bill that's not being done? And if so, what would it be?
So I would say the way Maryland charges children, we charge children on two paths. We charge children on the path of if they are charged with certain offenses, they go to juvenile court.
No, I understand.
And we charge children with other offenses in adult court.
Right,
Okay?
right.
When you charge a child in the adult court arena, you cut out all parental, I'm not gonna say support, I'm gonna say accountability, if that's the best word, because that system is set up on rule following. So when a child is charged in juvenile court, the parent is automatically on notice, right? But when we place them in an adult carceral system and we do other things and we charge them with the adult process, there's no room in that process for parents to be involved unless that child is waived down to the juvenile court.
I got that. I understand the process very well, how it should work. But my question is, what you said that her bill was duplicative, which makes me believe that everything that you all are doing is in her bill. Is there anything that's in her bill that you all are not doing, or you see any difference at all, or is her bill not needed because it's nothing in the bill that you all are not doing?
I'm going to say that this bill, for parental accountability to be attached to the parent, the processes must be in the juvenile court. I would say that in order for this to attach to all the children that we're speaking of, we're talking about 14 to 17, then I would suggest that the policies require that all children be charged in the juvenile court, and then you can attach parental accountability at the beginning. That's what I would say, because the Department of Juvenile Services can only monitor the children that are within their control. And if we're speaking of children who are charged as adults, if and until they are brought into the delinquency system and being managed by the Department of Juvenile Services, there is no role for the parent in the adult process.
I understand. If you think of anything that's a better answer, would you get that to me? Because I don't think the question has been answered, but thank you. Okay. Thank you, Mr. Chairman.
Thank you. I'd like to go back to the witness, and I thought you provided a really powerful data point. I know obviously you can't identify them, nor would we want that, but does your office represent the boys who were involved in the incident that was testified to about this legislation?
I have no knowledge of such incident, and also we can never speak on individual cases regarding children.
Okay. Is it possible that their matter at the DJS level didn't come to you because it was either disposed of at intake or informal through the department?
If I'm speaking hypothetically, the way that I heard the prior witness describe the attack, depending on the child's age, it sounds like something that would have them charged as an adult. If I just say a first-degree assault, especially if they're at least 16 or older. I do not believe that the Department of Juvenile Service has discretion to inform of such a serious felony. It must be, regardless of their decision, it must be forwarded to the prosecutor's office.
Okay, thank you.
Further questions from the committee? All right, seeing none, thank you very much.
Senator, just kindly may I add that I did file a written opposition for you all to review.
I'm sorry.
I did file a written opposition for you all to review.
Excellent, yes. It is in our bill file on the laptop, on our laptop system.
Thank you.
Thank you.
Thank Senator Benson for meeting with me prior to this.
Say it again?
I'd like to thank Senator Benson for meeting with me prior to the hearing.
Yes,
Thank
yes,
you.
that's great.
Thank you.
Excellent. With that, that'll conclude the hearing for Senate Bill 75. Thank you, Senator Benson. We'll now move on to Senate Bill 181. Is Senator Hedelman here? Senator Heldman, would you like me to call up your panel? Do you want to bring up
Please.
folks? So we've got Ms. Lila Meadows, Ernest Eli, and did you want?
That's it.
Oh, that's it? Okay, great.
We only have two, right?
Oh, that's right. The other one signed up unfavorable. All right. The floor is yours. Welcome.
Thank you. Thank you very much, Mr. Chairman, Mr. Vice Chair, members of the JPR Committee. My name is Shelley Hedelman. I'm Senator from District 11 in Baltimore County, and I am very pleased to be here today with my panel of experts. I would like to introduce them before I get into the guts of the bill, if that's okay. This is Chairman Ely. He is the chair of the Maryland Parole Commission. And this is Lila Meadows, and she is an attorney with the Office of the Public Defender and represents a number of clients who go before the commission and seek geriatric and medical parole. Many of you have heard this bill before, and we are very pleased to be before you again to talk about this bill that seeks to reform our geriatric and medical parole system. And this is a piece of legislation that we have worked on very closely over a number of years with the Department of Corrections and with advocates and with the Parole Commission. And there is consensus that this is a way forward to ensure both public safety and humane treatment of people who are incarcerated. And I'm very pleased to say also that this bill is a top priority for the Legislative Black Caucus. And there are a number of people who are not able to testify today because this is a bill that you have heard before who have submitted quite extensive written testimony. So I would urge you to take a look at that written testimony as well. Our current law allows both medical and geriatric parole, but the system is broken, unfortunately. We have experienced increased numbers of people who are incarcerated, but that is mostly due to their sentences being longer and longer. Back in 2017, Justice Reinvestment, where we took a deep dive into looking at our criminal justice system and making a number of very significant changes, lowered the minimum eligibility age for geriatric parole from 65 to 60. And that is very important. And unfortunately, geriatric parole is seldom approved. We have about 439 people who are currently incarcerated right now who, under the requirements of the bill, meaning that they have spent 15 years behind bars because of their sentence and are age 60 or older, would be eligible for geriatric parole. This bill is not a get out of jail free card. It really is not. It is relying on the expertise and the experience of the Maryland parole commissioners who take these decisions very, very seriously and have the responsibility for balancing public safety with humanity and meting out justice. The committee, so I just want to emphasize that we do have this system. It is pretty broken. In fact, just last year, only 14 people were released on medical parole and 4 died right after they were released. We are talking about people who are very, very ill, who do not and cannot physically hurt anyone. I don't think that it is in the interest of justice to make them spend their dying days behind bars. And I want to point out just one example compared to our federal system. Some of you may have heard in the news lately that Daniel Hersel, who was recently who is sentenced to 18 years in our federal system for the gun trace task force and did some pretty, convicted of some pretty awful things, was just released or is about to be released on medical parole because he has metastatic prostate cancer and is given a very short time to live. If the federal government, and he's going to be able to live out his dying days with family supervised probation, and that is our federal system that is certainly no less concerned with public safety than we are. The bill, so in terms of medical parole, somebody has to be extremely, extremely debilitated. The bill goes through the definitions. You have to have a terminal illness. You have to have a visit with a doctor, have to be able to have the parole commission consider all those factors when they assess whether somebody is appropriate for parole. Regarding geriatric parole, I want to bring us back to 2012 when the state in State versus Unger, because of that decision, we released a number of people who were incarcerated. The average age of the people who were released under the Unger decision was 64 years old, and they had an average of 40 years behind bars. Those people were released. Out of the 200 released, 97% of them did not recidivate, despite all of them having been convicted of violent crimes. This demonstrates that as incarcerated individuals age, and research supports this, evidence supports this, that the risk to public safety is minimal. Most people age out of criminal behavior. Finally, the bill removes the governor from parole consideration process. This is something that this committee and this body did a number of years ago, and this was frankly an oversight that we didn't do it in these cases. So we have a lot of work to do here. You're going to hear some testimony later from some groups that oppose this legislation. I just wanted to highlight that I have a letter here, and you all should have a letter too, from State's Attorney Ivan Bates from Baltimore City, who is fully supportive of the bill as it is introduced. And he is somebody who spends his life and spends his career with the interest of public safety at the front of his mind and prosecuting individuals who are alleged to have engaged in criminal behavior. And if he says that he believes that this bill takes a balanced approach to humanity and to public safety, I think that says a lot. I just want to read a little bit. Here in his letter, he says, as a state's attorney, it is my job to ensure public safety is upheld and those who go astray of the law are held accountable. Make no mistake about it. I am all about ensuring that those convicted of crimes are held to those standards and held responsible for their actions. However, there also comes a time in a person's life when we must recognize that they no longer pose a threat to themselves or others due to their elderly age, chronic medical condition, or mental incapability. I think that says it all. And with your permission, I'd like to turn it over to my other panelists. Thank you.
Here? Good afternoon, Chairman Smith, Vice Chair Wallstreicher, members of the committee. My name is Ernie Seeley Jr. I'm Chairman of the Maryland Parole Commission, and I'm here to express our support for Senate Bill 181, Geriatric and Medical Parole. We have worked with the bill sponsor, Senator Hedelman, as she crafted this legislation. We are in full support of this legislation as written. The Parole Commission is charged with determining on a case-by-case basis whether incarcerated individuals are suitable for release into the community under supervision by the Maryland Division of Parole and Probation. As part of that responsibility, we consider a number of factors as laid out in Correctional Service Officer 11, but our focus is on public safety and victim impact. Public safety and victim impact. There are 9 other factors we consider. I'm not going to read those based on the time. Senate Bill 181 does not lessen our obligation to consider those same factors when someone is reviewed for medical parole, but makes us more vigilant as we consider incarcerated individuals who present as chronically debilitated or incapacitated by a medical or mental health condition, disease, or syndrome that to be physically incapable of presenting a danger to the community. The current construction of geriatric parole statute has allowed us to consider very few candidates, as noted by Senator Hedelman. We estimate over the last 10 years, we considered 11 individuals. 1 person was released on a geriatric parole. Despite the population of incarcerated individuals over the age of 60 exceeding 1,100. Of that number, 760 have served approximately more than 15 years thus far. The proposed legislation allows for us to review those aged 60 and over. The Commission is prepared to carry out this responsibility, and though the legislation does not call for it, as with the medical parole provisions, nothing in the legislation will compromise our ability to put public safety at the forefront of our decisions. Senate Bill 181 does not create any new avenues for parole consideration, but it does significantly strengthen and clarify existing law, and I urge the committee to give Senate Bill 181 favorable consideration. Thank you.
Good afternoon. My name is Lila Meadows, and I'm an assistant public defender and a faculty member at the University of Maryland School of Law, where I've represented individuals seeking parole for over 10 years. I want to speak to some of the more technical aspects of the bill, starting with geriatric. You heard the chairman talk about how few individuals have even been considered, and the reason for that is this is the only parole provision that we see in the criminal law article. It's currently housed under 14101, which defines crimes of violence punishments and penalties for subsequent offenses. I cannot for the life of me figure out why that's there. And I've spoken with other people on the committee who it's not clear for as well. I have to think that this was a drafting error. But the effect of it has been you can only be considered for geriatric parole if you've been convicted of multiple crimes of violence only. That could not have been the intent. And so what we're asking is that that provision be moved into the Correctional Services article with the remainder of the parole statute to give it the meaning that I believe the General Assembly intended. With respect to medical parole, the bill does a number of things. The Maryland Parole Commission, you heard the chairman say their primary concern is public safety, and appropriately so. To my knowledge, no one on the commission now, no one on the commission in the 10 years I've been working with it is a medical professional. And yet they are charged with deciding whether someone's condition meets these standards. And that's why you see language in the bill that clarifies what the standards are. I have represented clients who are confined to wheelchairs, who cannot feed themselves, who are wearing diapers, waiting hours for someone to come by in the infirmary to change them, developing bed sores, who have been refused medical parole because the standards are unclear, despite the fact that their condition will not reverse. These people are not a threat to public safety, and continuing to keep them in cages is frankly inhumane, and it's a waste of taxpayer dollars. I urge a favorable report.
All right, excellent. Thank you both very much. We are now going to turn to the committee for questions. Senator Muse is first.
Thank you very much, and any of you can answer this. In your opinion, why is it that so few persons are released? Is it, and I understand that this is a clarifying bill, or it's a bill to make it clearer as to who should be released, et cetera. But looking at these things, it's still, for me, no excuse as to why so few persons are released since 2016 when we passed this law.
So with respect to geriatric parole, the Maryland Parole Commission does not have the legal authority to consider and release more people. With respect to medical parole, I think part of the problem, as someone who's represented these clients, is that there's no hearing required. And so a lot of times these decisions are being made on paper. And frankly, there is no substitution for walking into the prison infirmary at a place like Jessup and putting eyes on someone and seeing that they are wasting away in a bed. And part of what this bill does is provides an avenue for someone to request an in-person evaluation of the case. And then the last thing I'll say is you're not entitled to an attorney when you request this type of assistance. And I think a lot of times the Maryland Parole Commission is just not receiving the information it needs to make these decisions from the Department of Corrections. And this legislation also, I think, gives better direction to the DOC about what they need to be providing MPC.
Okay, thank you. Thank you, Mr. Chair.
Thank you, Mr. Chair. Parole Commissioner?
Yes, sir.
If you would come to the podium, please. I'm sorry, sir. What was your name again?
Ernest Ely?
Okay. Thank you, Mr. Seeley.
Yes.
How long have you been the Parole Commissioner, sir?
For the last 8 months.
Okay. I find it interesting that the Parole Commissioner is coming here after being in place for 8 months, giving a note of support when most of our state agencies give a letter of information on taking on more cases and more hearings for your agents when you're already short agents, as I understand now.
Well, you talk about two separate agencies. The Maryland Parole Commission is a separate agency. You're talking about Division of Parole and Probation.
No, I'm not.
You're not?
I'm talking about the Parole Commission.
Okay.
I already talked to Secretary Scruggs about that.
Okay.
I'm familiar with the difference, sir.
We don't have agents. The Parole and Probation.
Commissioners. Your commissioners.
Yes.
That have the hearings.
Yes.
How many do you have right now?
Sir, right now we have 7. We have several people
many
being
vacancies
vetted by
do you
the
have?
governor's, 3 vacancies being
3
vetted by the
vacancies.
governor's office.
So you have 7 people who are having these hearings, and you're coming in. I mean, why wouldn't you want to get these out of the way? I mean, that's a great thing for you.
What's your question?
So my question is why was there only 1 released out of the 11 that you saw?
Because the requirement's so stringent the way it's placed right now. Over the last 10 years, 11 people were reviewed for geriatric parole, 1 person was released.
And of the other 10, but you don't know the specifics on why that 1 was released then?
Yes, because he met the definition, and he had good conduct.
So the other 10 that were put in didn't meet the definition?
I can't speak to those.
But you just said that 1 met the definition, so that's why he got released.
They all met the definition. 1 was released.
So why was 1 released and all 11 met the definition, the other 10 were not?
In all probability, because he met those other factors, those 11 factors laid out in Comar in
Okay.
terms of consideration for parole release.
Okay, so it wasn't that your agent or that your commissioners thought that it would be better not to release that person?
I don't know how to answer that question because you're giving me 2 different, like a contradictory type. I don't understand your question. Could you restate it?
Sure. So of the 10 that were not released?
Yes.
You said they all met the same standard to have a hearing?
They might have. I don't know. I have to go back and look at that.
Okay. And I'm asking of the 10 that didn't get released, if they didn't meet or if they met the same conditions, what was different about their case that your commissioners didn't release them?
I would have to provide that in follow-up.
So you don't have that today?
I do not.
Okay. But you felt comfortable? Okay.
I'm the chairman of the Maryland Parole Commission. The Parole Commission has a history, the last few years, supporting this bill from Senator Hedelman. I'm the chairman, so I'm representing the commission.
I understand that, sir. Are you familiar with why in the language of the bill it's been changed that someone that would go from a hospital or hospice setting, that it just says that they'd be under the care of a medical provider?
I think Senator Hedelman might be able to speak to that.
Okay. I guess if Senator Hedelman, then if you're available to come up.
I'd like to address your first point, too,
Sure.
because Chairman Ely, while he is new, is the new parole commissioner, and prior to that, it was Commissioner David Blumberg, who was a long time,
Sure.
I believe, Republican-appointed commissioner, who also supported this bill,
That doesn't have
also
anything
submitted
to do with it.
testimony in support of this bill, and also was very intimately involved in negotiating a number of years ago when we hammered out some of the details here. With regard to your question about medical, and could you tell me what page you were looking at?
So I'm looking at, the first thing I was looking at was on page 7, line 9. You struck, it was taken out that in a hospital or hospice care or other, and then it was just changed to under a medical provider. I found that interesting because then later somebody came up and said that somebody with just a mental health condition could also qualify for this.
Well, 2 things. One is someone with a mental health condition, I would be hard-pressed to find them eligible for this kind of medical parole, right? Because we're talking about people who physically also don't have the capacity to do harm to others. Somebody who has a terminal illness. I could be wrong, but I have not heard of mental illnesses that have
Somebody on
terminal
your panel said it.
illnesses, and no, I don't think so.
Okay.
But, so I think there were a couple of reasons of putting this in there. One is that somebody may be more appropriately cared for in a home setting with medical professionals that would, and frankly, in a less expensive manner, to be able to get the care in home rather than an institutional setting. So, if the final days of somebody who has home hospice wouldn't necessarily could qualify as we changed it.
So here's my concern, Senator, is that when we're entrusted with upholding, being a part of the legislative body that creates the laws, and we want to make sure we're doing our part for our citizens. And I understand your intent behind this bill. My concern is that we have offenders who go out and have murdered people. They would be eligible for this.
Correct.
They would be eligible at 60 and 15 years to get out.
After they've
service.
served 15 years.
Yeah, look, I've always been told
after
60 is the new 50, so I'm not really sure how that qualifies one for geriatric parole. Having met that number that had murdered somebody. And if they are dying, maybe this sounds really callous, but that's why they have a life sentence. They're supposed to die in prison because they killed somebody. why should they get to go home to their loved ones or their family members and be surrounded by them to feel great in the twilight of their life when they literally took somebody else without giving them the same privilege to go home to their loved ones one last time?
So we're talking about two different things, right? We're talking about geriatric parole and we're talking about medical parole. I hear what you are saying, and that is a value judgment we make as a society and as legislators who get to change the law. We can say that somebody who is in their last days and dying and committed murder should die in their prison cell. And that is a value judgment that some people would make. That is not one that I would make. If somebody has spent 15 or more, most of the time, these are more than 15 years, and we have entrusted a lot of these assessments to the Parole Commission to determine whether someone has cooperated with their sentence behind bars. I do believe that people are better than the worst thing that they have done, and if they have paid their...
But they haven't paid their debt to society.
If they
Their debt
have
to society was a
15
life
years
sentence.
of it, if they have, and I want to be clear here too, that victims have an opportunity to provide their views to the Parole Commission. We are not changing anything about that. And I don't want to minimize the role that, and the atrocities that people who have, you know, the effect of crime.
Because this re-victimizes those families. You understand that also?
I don't believe that to be the case. And in fact, we had somebody here a number of years ago who was a victim and was a family victim who supported this legislation.
Are they here today?
They are not here today because we have two witnesses.
So if we had someone, so you don't believe that's the case, if someone's mother, for instance, Jerry's Law, which is coming up, was murdered, her daughter's been here now 31 years advocating to go against all these diminution and all these early out programs that we keep doing, that this body, I won't say we because I voted against them every time, that this body keeps passing and it dies. Her mother's bill, Jerry's Law, will never get a vote in this chamber because we keep doing things to hold less accountability for the wrongdoers, and we thereby re-victimize those victims and their families. Her daughter's here 32 years straight advocating for her mother. I'm going to bet she would not be in support of this.
I will leave that to you to make that determination, and I will also assert that there are some people who have been victims of crime who do support this bill.
Okay. But I just want to be clear, because you are correct. I did apparently, I guess, commingle the medical and the geriatric. I want to be clear. The geriatric provision does not require them to have an illness.
Correct.
Or a health, you know, life-threatening that they're going to expire.
Correct. And it does not require that they be released at the age of 60. It requires consideration. It's not a get-out-of-jail card for, you know.
Then it requires a hearing every 2 years.
Correct.
Which is not normally, I guess, afforded to them at that rate. Is that correct?
Sometimes they are.
They do now.
And I guess one last question then is, where's the 60 number come from?
2017, JRA. This body changed the age. And also there have been a lot of evidence-based studies that support the idea that people age out of crime, and that is the age.
Okay. Thank you, Senator.
Thank you.
Oh, actually, I'm sorry. I had one last thing. I'm sorry. What you said, you mentioned the taxpayer savings. That kind of piqued my interest. I apologize. I wrote that down. And the taxpayer savings, how is that a taxpayer savings from having them incarcerated to then putting them out and having them on like Medicaid or something like that?
So there are two things. If you're talking, are you talking about medical parole?
Sure, we can go there.
So prisons are not medical institutions. They are not equipped to provide the kinds of care that older, sicker people who are incarcerated need, any of us, right? Medical care is really expensive. It's really expensive, as we all know from the contracts that we have seen of the company that provides medical care behind bars. They're really expensive. Many times we have to take people who are very, very ill in prison and take them to hospitals and outside of institutions to be able to get that care. So in some cases, they might be able to access Medicaid and other kinds of public supports, but many times they would be able to get family support and other kinds of support that is far less expensive than the $64,000 that it costs to incarcerate somebody each year.
But we don't have any numbers to show that.
I don't have numbers
okay.
at this point.
And then you said that was for the medical side. What about, like, are the others that are then released early, are they eligible for Social Security at that point? Or, you know, we want to wait until 62 so they can get Social Security?
I suppose they would be like any of us.
Yeah, I was going to say, did they get their quarters in? I was like, all right, thank you, Senator.
Thank you.
Thank you, Mr. Chairman. And this may be to you, Senator Hedelman, I'm not sure, and it reflects that I didn't get to read this file last night, so I apologize. So I just want to clarify. The bill addresses geriatric release and adds this at 60, you get to automatically ask for and get, I guess, a parole hearing every 2 years. Is that correct?
That's correct.
Is that the sum total of that part of it, really?
Yes.
And what is the current, what's the current situation? What would be, what did people normally get, how many times they get to go ask for parole? Sorry, it's, you know, I'm not familiar. So do you get to a parole hearing every 5 years, every 10 years, or just how does that work?
Sure, I can take this. So right now, once you become eligible for parole, you have the initial parole hearing with 2 commissioners, if it's the type of crime, the type of conviction that requires a 2-commissioner hearing. At that hearing, those commissioners have discretion to set the next parole hearing date. And Maryland law doesn't tell them what that interval has to be, which makes us unique compared to other states. And so this would set that interval at 2 years.
So if we change the law, would it mean that people who are not otherwise eligible for parole, as it's currently understood, would still at 60 begin to automatically have, so they have to be eligible for parole and at age 60 to then get a hearing every 2 years. Is that correct?
So with respect to people serving life without the possibility of parole sentences, they are still excluded from parole. You have to have a parole eligible sentence.
My question, because I really want to understand this. Currently, you have to be first eligible for parole, right? And then you get to, and then you go before the system. This would say at age 60, whether or not you're eligible or not, you will get a parole hearing, which implies that you could be paroled.
That's right. You have to have a parole eligible sentence, but you don't have to have otherwise hit the statutory eligibility. So an example is somebody who's serving an 80-year sentence would, for a violent crime, would have to serve 40 years before becoming parole eligible under the current statute. The geriatric parole, as it's already written in 14-101, would give them a parole hearing after 15 years.
Okay, so there's a little more than just your age. You then get to be eligible for parole a lot more quickly.
After serving 15 years, day for day, yes.
And so, and the justification for that is, again, the Unger decision. Is that where everybody's sort of hanging their hat because that involved people that were 60 years or older?
Well, Maryland had geriatric parole even before the Unger decision, and Unger was playing out during the Justice Reinvestment Act. I think that's certainly part of the rationale for why there's such strong support from the Commission, from the AG's office, in feeling comfortable to release people at that point. You know, put another way, the Unger statistic, at the 10-year mark, people released under Unger were more likely to have died than reoffended. So I do think that that's a strong rationale here.
And I guess for anybody that's in court, when a trial is occurring and sentencing is occurring, it's almost as if they ought to all be told, if we pass this, no matter what the judge is doing, if this defendant is convicted of some crime, might be given a certain sentence, but the judge ought to say, but really that sentence is not accurate because if the person reaches the age of 60, they're going to be eligible for parole, even no matter what my sentence is. So there's really the public-facing court and sentence, and yet under this bill, there will be in some sort of it won't apply for people that are 60.
Well, I think that's true anytime someone is sentenced to a parole-eligible sentence, even when you're sentenced to life. If it's life with the possibility of parole, there is a chance that person will leave prison before they die because there's an opportunity for parole.
Okay, I didn't say people to die. I'm just saying whatever the judge is saying, most of the public and the victims of the crime are going to hear one sentence, but later on they're going to learn that that sentence doesn't really jive with a lot of what we're doing here, because a sentence could be longer and the person wouldn't be eligible for parole the way the sentence was handed out, and yet this would kick in and someone would become eligible for parole at 60 and every other year. So the people in the courtroom and the victims wouldn't know that, and I guess it'd be a little bit of a surprise afterwards, wouldn't it? They wouldn't know this.
I think that it's the state's responsibility to ensure that everyone understands the law with respect to that.
Yeah, maybe the courts should explain that when they're sentencing. I guess the other thing that I'm worried about is this is a very wordy bill, and the law of unintended consequences sort of says that the more you write things down that are elaborate and complex, the more you have unintended consequences. So I'm reading the current law, and I really am no expert in this area, so I'm just reading what currently the parole board does. This is on page 3 at the bottom. And so I need to understand why the current law isn't working, because it looks like the parole board looks at the crime, the physical, mental, and moral qualifications of an individual. I'm not sure what that means, but I guess they could look at their physical and mental condition, which is sort of what this bill's getting at, and then the progress of incarceration, I guess if they've rehabilitated and you have some more language relating to their time in jail. Okay, and then the last thing, not the last thing, is this will remain at liberty, and I'm confused as to why that language needs to be deleted for the new language. I guess I don't know the import of whether they'll remain at liberty without violating the law, why that language has to be deleted to be substituted with not recidivate.
I'm sorry, can you tell me where you are now? I don't see that on 3.
I'm looking at the current law and the fiscal note description on page 3, and I guess it dovetails with page 2 of the bill, where we are deleting language, if released on parole, will remain at liberty without violating the law. That language is being taken out. So first of all, I don't even know what that language means, but I'd like to know. And then it's being replaced with not recidivate.
Honestly, I think they mean the same thing. I think we're talking about making a finding that someone's not going to commit a future crime.
Could you all confirm that with me, follow up, because I don't know. If that's the case, I don't think we need to change the language at all. And if we are changing the language, then I have to worry that it has an unintended consequence. So I'd like somebody to follow up with me, because I don't expect you to do that here. That would be helpful.
Sure.
And then the last thing that the current law says is whether release of an incarcerated individual on parole is compatible with the welfare of society. And I'm assuming welfare of society is the public and safety, but also the kind of the gist of this bill, which is what is good and fair. So I guess what I'm struggling with is it seems to me, in less words, under current law, the parole board can certainly take into account what is spelled out in elaborate detail with a lot of words and perhaps extraneous words, this process. So why can't we just, I always like to change things incrementally and as closely to the wording that exists, because that's what everyone understands. Why can't we just do a mild, or I don't know, a small change just to make sure and emphasize that, you know, the health and condition and some of what you're saying here, but why isn't the language that exists now sufficient for them to take into account medical parole?
Well, I think to your first question, that change from the welfare of society to public safety, there is a question. What exactly does the welfare of society constitute? And the focus really ought to be, and already is, we heard that from the chairman, public safety. And so I think that's the reason for the change in that language. With respect to the other...
Well, you could just say the welfare of society, excuse me, including, you know, the welfare of the incarcerated individual and their medical condition. I mean, I don't think you have to write a dissertation level bill. But anyway, so I just think so that's kind of an easy fix. But we do have these 5 criteria in the law, and I'd like to hear, perhaps it's to the parole, the parole commissioner, what is the impediment with the current language that you all cannot, release people for medical reasons?
We are.
I just don't understand. I think you have that discretion. I think you have that latitude. I think the language is fairly broad. I think if that's your value, you could do it. So I'm really not understanding why we need this elaborate bill when I think you have this authority, and you could certainly, announce that this is a goal of yours, to use this language to allow for medical parole with regulatory or certain principles that you all put in.
Well, as noted by Senator Hedelman, we are releasing people on medical parole now.
Okay. So if you are, then why do we need this bill?
Because it kind of moves things forward. As Senator Hedelman said, 14 people released on medical parole last year. 4 of those people died. Previous year, same kind of thing. So the bill is, and also the governor is involved. When we approve somebody for medical parole, it has to go to the governor. He has 180 days to act. And I think this bill kind of cleans that up. So it won't take the governors out of the bill.
Well, we could easily do that without this. I just think, I guess I would ask you, because I don't want to put you on the spot or make the hearing longer. So you can follow up with me. I would like you to, you or people that you work with, to clearly articulate in detail why the language, take this language of the current law and explain to me in clear, detailed language why this language does not give you the latitude to grant medical parole that is envisioned by this bill. I do not see that your language currently doesn't allow you to do this, so I need to understand what the impediments are in detail, and then why this language, new language, is being suggested. That would be what I need. We can do it after the
I think
hearing.
Senator Heldman might be able to comment on that as well.
Well, I really want your group, because you are the people in charge of this. I'm not looking to the bill sponsor. I'm looking to you all. I want to know what the problem is, all right, with data and explanations of the language and cases. I want to understand this. So maybe there's already a report, but that's what I would really, thank you very much. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. My questions, I think, are for Senator Hedelman. So, Senator Hedelman, I'm sure you were here a couple of years ago when Chairman Blumberg was here before us.
Yes.
I remember his testimony quite well. He was under some constraints because of the administration he was part of, and therefore could not publicly voice an opinion. But I went up to him afterwards and said, so do you think that we should change the medical parole provisions? He looked around carefully and looked at me and said, yes. I took that to heart. So I'm with you on the medical parole.
Could I just add one thing?
Yeah.
Later on, he did say it very, very clearly and publicly and said, I think I can quote this, that the system was broken, and he used the term broken.
Yeah.
So that
when
made it
only
in the
one
first
person qualifies for medical parole over the course of 10 years, it's clearly broken. And when
Yeah,
I'm sorry.
geriatric is the one person. There were more, but very few people who
14 was
qualified for medical.
Even so, when you have
So few.
prison hospitals such as they are, full of people, we need to do something about that. So I'm with you on the medical parole. The geriatric parole, though, is not too dissimilar from my Senior Restoration Act bill from last year, which we didn't get a vote on last year. I introduced it again this year and was persuaded, rightly or wrongly, to withdraw the bill. So that's not going to be before you this year, but this is not too dissimilar from that. You may recall a couple of years ago, I passed the Juvenile Restoration Act over the veto of my own governor, but I passed it, and the Senior Restoration Act was going to be similar to the Juvenile Restoration Act in that it relied on 2 standards. Number 1, you had been in jail for 20 years. I thought the 20 years was important because if you commit a serious crime, first-degree murder, for example, I wouldn't want someone to be in jail less than 20 years. It seems to me you ought to be in jail the full 20 years. Your bill goes for 15 years. Why do you think it's appropriate that someone only be in jail for 15 years if they commit a particularly heinous crime?
Well, again, this doesn't automatically say at 15 years you are out, right?
No, but it says
It's the
you're
first
eligible.
consideration, right, your eligibility. That is the job of this committee, and I will leave that in your hands as to what the appropriate age is.
Okay. So, but is it fair to say you just selected that date because it seemed 15 years seemed appropriate to you? There wasn't any magic to the 15-year date. I will tell you there was no magic to my 20-year date, but consulting my conscience, my thought was somebody who commits a particularly egregious crime ought to be in jail at least 20 years before we consider releasing them.
Lila, do you want to come?
Given when the geriatric parole statute dates back to, here's my best guess for where 15 years came from. And it's a little bit of speculation, but I think it's well-grounded. At the time, parole eligibility for a life sentence, the mark was 15 years, minus diminution credits. And so you could actually go up even earlier than 15 on a life sentence. And so if I had to guess when geriatric parole was created, they took the 15 from there. That's my best guess for where that came from in the statute. This is 15 day for day, no dim credits applied.
Okay. Well, thank you for your guess. It's helpful. Senator Hedelman, I need to talk to you again briefly. So that's the time. There are three elements of my senior parole. Number one, 20 years. Number two, you're no longer a threat to society. So I was looking in your bill to find something along those lines, and I think I found it. It's on page 8 of your bill, lines 22 to 27. It says the commission panel shall consider and give weight to the age of the incarcerated individual and the impact that the age of the incarcerated individual has on reducing the risk that the incarcerated individual will not recidivate. Seems to me that's a fair substitute for the language of my bill, which would no longer present a threat to society. But then there's the third element of my bill, which I just don't see in your bill. I'd like you to comment on it. The third element of my bill was, and the interest of justice would be served by releasing the prisoner. Interest of justice refers to all the circumstances surrounding the crime, the number of people who have been injured, the families who remain behind from the people who have been injured or murdered, and the interest of justice in terms of communicating to people at large that if you commit a crime like this, you will pay a serious penalty. I'm thinking, for example, of the snipers some years ago. I would not want that sniper, well, one of them was executed. I would not want the other one ever to get out. He showed a total absence of moral conscience when he did what he did. So is there anywhere in your bill that I can find this standard of the interest of justice would be served?
So we don't use that terminology?
No, you don't.
I have a question. Did you include interest of justice in the Juvenile Restoration Act?
Yes.
Okay.
It's one of the two standards. Again, same standards. The no longer a threat to society and the interest of justice would be served by reducing or eliminating the rest of the sentence.
Again, it's your bill.
Okay. Thanks.
Thank you.
Further questions from the community? I'm going to just ask. Go ahead, Senator Fulton.
I'm sorry. I apologize. Thank you.
Because I've got a couple as well.
So whoever would like to address this, I just want to point out that we're having this discussion while the Secretary of Parole and Probation, or not you, sir. I know you're not the Secretary of Parole and Probation. While we're not doing any home visits right now on sexual predators across this state or our most violent offenders. Not since May 31st, when that slain parole agent has been killed, have we done them. Is that in the best interest of our communities? I say it's not, but we still aren't doing them. And that person that killed that 31-year-old agent, rolled him up in a carpet and stuffed him under a bed and fled, was a mandatory release at 53 years old. Thank you. Isn't that so?
Thank you, Mr. Chairman. My question is for the chairman of the commission. I want to start where kind of we started, which was with Mr. Herschel, who's obviously—
I'm sorry, sir, I can't
I wanted
hear
to
you.
start with Mr. Herschel, who's obviously not in our system, in the federal system. I feel badly for his family, but I feel even worse for all the people he victimized. We don't have a representative from Baltimore City here anymore, but he terrorized that city for years. And people lost their liberty. People went to jail because he framed them. And I'd be curious as to what his victims and his victims' families feel about his release from federal prison. And that kind of leads me into the question. We kind of heard anecdotally earlier about how victims may feel about this bill. But I was curious as to the data point. So of the people, so you said 12, 14, how many people applied for geriatric parole last year?
Well, what Senator Hellman quoted were the number of people who were released on medical parole last year.
I'm sorry, we knew that there was one released on geriatric. Right?
Yes, in the last 10 years.
In the last 10 years, out of
Yes.
how many were eligible?
It was 10.
10, okay, so 1 out of 10. I guess my question
One
is,
released.
so I know you're seeing a full file, and I know one of the factors that you determine under COMAR is the position of the victim,
Absolutely.
where I imagine in this case, I don't know the data, I imagine perhaps the majority of these folks were in for murder, so it would be the victims' families, not the victims themselves. They are victimized, of course, in their own way. I guess my question is, of the 10, how many had victims supporting the release of the inmate under existing geriatric parole?
Say that again, sir? I'm sorry.
So of the 10 inmates who were eligible the past 10 years
Okay.
for geriatric parole, one of whom was released, how many in those cases was the victim supportive of the release, or the victim's family, in the case of the murderers, supportive of the release?
I will get that information
Okay,
and get back
thank
to
you so much.
Thank you.
Further questions from the committee? All right, I have a few just to wrap this up. So the questions I'm about to ask, I'm not adopting the positions that, that the questions are coming from, but I think these are going to be issues that the committee is going to have to wrestle with as we move forward. I like, so Senator Hedelman, thank you for bringing this bill forward. I think I'm very much interested in putting energy into this. I think we're very, very close, but there are a couple things that I want to have give you all an opportunity to address before the opposition comes up, and then you don't have a rebuttal time. So I just want to kind of put things up front. One is, so we'll start with the technical piece, and I've already put a request into the library to figure the kind of the legislative history of this. But Ms. Meadows, you mentioned that obviously for geriatric parole, it's still under the Section 14101, which is the crimes of violence. You spoke a little bit to this. What is it seems like that's a mistake, but do you know anything? Can you offer us anything about the legislative history as to why that's there? It should certainly be in the correctional.
No,
circle, but yeah.
I've looked at this and I can't figure out why it was placed in 14101.
So that's one thing. I mean, that's a technical fix that's an easy one to knock off. Second is, people have kind of danced around this, but I'm going to give you an opportunity to kind of answer this in a less adversarial way. So, whenever I go in community talking about this bill back home over the interim, the age thing always comes up. So why 60? And people will invariably point to the latest great athletic feat that has gone on. So the New York Marathon. And this past year in 2024, an 88-year-old ran the New York Marathon, and an 82-year-old completed the New York Marathon. And so I know age is different for everybody, and age is different certainly behind the walls. But can you just give us some of the history as to why 60 is the touch point for age?
So I suspect that you would find something in the legislative history when you look at the JRA, because there was an intentional move by the General Assembly to lower what then was the age from 65 to 60. I would just emphasize the point you made in your question, that 60 behind bars, especially for people who have already served 15 years in prison, is quite different than the people running the New York Marathon at that age. And by way of example, again, I think it's easy to laugh it off, but someone who goes into prison with a condition that's well managed in the community like diabetes, I cannot tell you the number of people I've represented who end up with amputations, who suffer strokes, because the correctional environment is not conducive to managing diabetes, especially what we call brittle diabetic addicts. I've had many clients like that. You can't eat when you want to eat, right? Med call is at a certain time. And so 60 after serving 15 years is quite different than 60 is for any of us.
Excellent. So then again, I'm not adopting this line of questioning, but I think it's important for you all to have an opportunity to address it before we switch to the next panel. One, when we went through JRA and some of the other parole reforms, a certain state's attorney has brought forth just the number of opportunities that a defendant gives to challenge the conviction and the sentence. And I'm going to walk through that list, just read it into the record, and Ms. Meadows, you're the perfect person to answer this question. So this certain state's attorney will say, look, you've got a motion for a new trial, a motion to modify or reduce the sentence. If the modification is based upon a legal sentence, fraud, mistake, or irregularity, there's no time limit for that. 3-judge panel can reduce or modify the sentence. The appeal to the Court of Special Appeals, you can ask for appeal to the Supreme Court. Post-conviction appeals, a writ of coram nobis, a writ of habeas corpus, a writ of actual innocence, motion to vacate judgment, post-conviction DNA testing, the parole system, which can review the sentence more than once. And then here, we're creating a mechanism after 15 years, at 60 years of age, you can go every 2 years. And so, as we go forward with all of this discussion, you've got all of this 13 steps plus one every 2 years in perpetuity. And so, to Senator Folden's line of question earlier, and Senator James as well, can you speak to there's a notification process that happens for the victim's family. And so the victim's family is notified each and every time the defendant exercises one of those appeal rights. Can you just address that dynamic?
Sure. So I suspect that the committee is going to hear about this next week when you have the hearing on the Second Look Act as well, because I know that's a major talking point. And the Office of the Public Defender's written testimony will address this, and I believe my colleague Linda Moyd will probably touch on it as well when she testifies. What I want to say, I won't go through every single one of those mechanisms for the sake of time, but it's completely disingenuous to suggest that every single person convicted in the criminal legal system is exercising every one of those rights, because they just don't apply to every case. Let's take a 3-judge panel, for example. 3 judges can review your sentence and then modify it if they see fit. Very, very few people exercise that right, because the 3-judge panel can also increase your sentence. So there's big risk there. And so we advise clients all the time not to file for a 3-judge panel. You're really only going to get someone sentenced to a sentence like life without the possibility of parole who exercises a 3JP. Coram nobis just doesn't apply in the vast majority of our cases. And so the Office of the Public Defender certainly isn't going to take the position that we should be rolling back anyone's rights to challenge their conviction. But that's what those mechanisms are about. They're about challenging the conviction, factual and legal errors at trial, whether or not someone's attorney provided ineffective assistance of counsel. And those inquiries are fundamentally different than the inquiry for parole, which is also part of someone's sentence. And the inquiry at parole, the whole premise of parole, is that if you go into the Department of Corrections and you do what you're told to do, what you're asked to do, and you can show that you are rehabilitated and not a threat to public safety, there is a mechanism for which you get to come home and finish your sentence under community supervision. And so when we talk about those mechanisms, it's frankly really apples and oranges. Not every person who's convicted is going to exercise those things. And I know that the Maryland Parole Commission takes its responsibility for victim notification seriously, and they do it. They do their job, as does the courts. But I think the idea that people are being notified 14 separate times and then for parole just isn't quite the case.
Excellent. I knew you're the perfect person to answer that question. We've had this discussion plenty of times before. Just continuing along that. So look, obviously, the governor out of medical, that was an oversight. I mean, we're all here with that. That's an oversight. We look forward to correcting that one. We did, however, adjust, the composition and the voting structure for the parole commission to make some of those decisions in wake of that process. And so, Ms. Meadows, you were right. You were there helping us figure some of this out. And so the question, one will go to Ms. Meadows and then one to the chairman. So to the regs, or to the law first, let's go to the code first. It says that the membership of the parole commission is 10. Your regs say 7. Your regs say 7. I guess one thing is, there's several layers of this thing. So you got to fix, how long does it, Mr. Chairman? I know you've been there 8 months, but they do say 7, and so it's incongruent with the statute.
It's 10. It should be 10.
It's 10, but it says 7. on the
Okay.
regs. How long does it take for you to promulgate new regulations?
That's hard. But we're going to fix that one immediately.
Well, so that's what I'm saying. For us to pass this bill, you got to do that.
So we will fix that
So
immediately.
that's got to happen. And then, so right now, the way it happens under the statute, so I'm looking at section 7-307, under the Correctional Services article, a commission panel consists of 2 commissioners, and they'll determine by unanimous vote. If there's a tie, then another person's required. So for this, Ms. Meadows or Mr. Chairman, so right now there are 10. How many vacancies do you have?
We have 3 vacancies.
So you have 7 members now.
Yes.
But these decisions can now be made by 2 members. Is that right?
So what the section that you're referring to is for a parole hearing that requires 2 commissioners. And so at that hearing, the 2 commissioners need to be in agreement. However, for folks who are serving a life sentence, there's a different set in the code that says that commission needs to be voted en banc by the entire commission.
Right,
So
the majority.
So walk us through that process then. So the initial review is 2, and then it goes to the entire commission.
Yes.
Which is of seated. Right now there's 7. So that'd be
7,
yeah.
whatever the majority, 4. The Senate to the governor.
So is it the majority of impaneled, or a majority of what's?
Majority of those in panel.
So right now, if you have 7,
Yes.
it's 4.
I'm sorry? I said majority would be 4.
Majority before.
Yes.
So 4 people could make this decision.
Yes.
Okay. So we will have to review that as well. I think that warrants discussion. And so I'd like to have a, work group with Ms. Meadows, you, Mr. Chairman, the state's attorneys as well.
Okay.
And, we'll figure out who else might be necessary to kind of rework. We did the same exercise when we got governor out of parole.
Okay.
Before. I had one other question, but I forgot what it was now. I don't know what it is. This other section, page 3. Senator James was on this, actually. Yeah, so so look, the current law says you have to have physically incapable of presenting a danger to society. So you repeat that, but the modifier is or instead of and you add the new language. This is on page 3, lines 22 and 23. You require extended medical management or healthcare needs that would be better met by community services. And it's an or, not an and. Or has been rendered physically incapable, which is the current factor. Just, can you talk to us about the policy rationale and the discussion for those 2 sentences? Because that's going to come up in our discussion.
Yeah, if you can just give me a second to find where you are.
Page 3.
Yeah. Yeah, so, what we're doing there, again, you see 2 different standards. You have chronically debilitated or incapacitated, which is defined above at line 5. And the rationale for that definition and the level of detail goes into that we collaborated with Families Against Mandatory Minimums that did a 50-state survey and also looked at the federal system as to sort of what the standards were for this. But this is also informed, I think, creating this standard because there are folks who are physically incapable, right, because they are chronically debilitated. But the way that the law was written, and specifically the inclusion of the Karnofsky score, what we saw was that the Maryland Parole Commission was basically requiring you to be terminal. And so this language, I think, really clarifies that somebody with dementia who isn't even aware of where they are anymore. I had that client who believed that he was in a halfway house in Virginia, had no clue as to his surroundings, would meet the definition of chronically debilitated. Again, his condition didn't necessarily turn on physicality, but he had no awareness of his surroundings. And so that's the reason for that definition.
Excellent. And then finally, just for the commissioner, so you've got 3 openings on the commission. How close are you to filling those?
Very close.
Okay.
We have names at the governor's office being vetted right now.
Excellent. So they'll come through. They'll come through exec noms?
I'm sorry, sir?
Will they come through exec noms?
They come for confirmation.
Yeah, that's excellent. Okay. So I think a fully impaneled parole board and the change to just a minor change to the regs, which is just a small thing, doesn't really affect the policy, would go a long way, I think, into helping expedite our processes here. Okay. Further questions from the committee? All right. Thank you all very much.
Thank you.
It's been great. All right, so that will end the testimony for the proponents of the bill. We'll now hear from the opposition, and we'll hear from, pardon me, ma'am, I cannot pronounce your last name, but Joanna, you're up. Help me out there.
Thank you. It's Joanna Mupenduki.
Very good, thank you. Welcome.
Thank you. Good afternoon. My name is Joanna Mupenduki. I am an attorney and the deputy director at the Maryland Crime Victims Resource Center. We represent victims all over the state of Maryland, representing hundreds every year, close to, well, actually it will be over 1,000 in 2024. And we look to be on track to have well over that number in 2025. I've been an attorney for over 17 years, working as a prosecutor in Washington State, California, and in Maryland. I've spent 3 years as a victim rights attorney at Maryland Crime Victims Resource Center, and now as a deputy director. One of the most difficult things in being a crime victims rights attorney is explaining to clients what a sentence means, and that what the judge in fact says in court is not what that person is going to actually go to jail and serve. It's difficult to explain that there are these diminution credits, that there are a grand multitude of them, that they will be eligible for parole, and now this will be yet another one. And I think it's important to note that although victims are sometimes notified of these hearings, they're often last minute. They are often notified of resentencings last minute. They are often, and sometimes they are not notified at all. And so these, every time it brings up bad memories for them, they have to walk through the worst situation in their lives. And these cases that are going where people are being sentenced to these long sentences, these are murders where they've lost a loved one. And so we think, and we would represent on behalf of thousands of victims in the state of Maryland, that there are crimes that are worthy of a life sentence, and that there are certainly more than, people should be serving more than 15 years for the loss of an innocent life. And so due to that, I would urge an unfavorable report. I did file a written testimony as well with more details. Thank you.
Excellent, thank you very much. Questions from the committee? All right, seeing none, thank you very much. Thank you for joining. Thanks for hanging in there. All right, that will conclude the testimony. I think there's no one else left, right? All right, that'll conclude the testimony in the hearing for Senate Bill 181. Thank you, Senator Hedelman. We'll now move on to Senator Salling here, Senate Bill 78.
I want to thank you, Mr. Chairman, Vice Chair, and members of the Judicial Committee. For the record, my name is Johnny Ray Salling, Senator of the 6th District of Baltimore County. I express my gratitude to the committee for permitting me to address Senate Bill 78, titled Juvenile Child Sex Offenders, Juvenile Sex Offenders Registry, and Prohibition on In-Person School Attendance. This bill holds significant implications for the safety and well-being of our children within Maryland education institutions. Last session, juvenile justice bill included the prohibition for attending public schools of any juvenile convicted of a sex offense that would constitute a felony if committed by an adult. This bill addresses critical oversight left by that bill. This bill would add the following to the reportable offenses and prohibition of in-person attendance. A person may not engage in sexual contact with another if the victim is substantially impaired, mentally incapacitated, or a physically helpless individual. Nor may a person engage in sexual contact with another if the victim is under the age of 14 years and the person performing the sexual contact is at least 4 years older than the victim. The urgency of this legislation was underscored during a meeting I had last year with two concerned mothers whose toddler daughters were sexually assaulted by a student within the Baltimore County public school system. Adding these two subsections would be specifically acceptable to their cases. I have added two amendments to this bill. The first ensures that a juvenile sex offender is put on the juvenile sex offender registry, they will not be able to be removed before the age of 21 years of age. The other amendment requires that the victim or the families must be notified immediately once the juvenile sex offender is removed from the registry. I would like to add to this bill that the bill is an expansion on House Judiciary Chairman Clipinger's amendment from last session, House Bill 814, prohibiting juvenile sex offenders for attending public schools. Chairman Clipinger's amendment was a already blanket amendment that was passed into law in 2024 and has continued to require juvenile sex offenders to seek education outside of a public campus. This means that every child on the juvenile sex offender registry has and had an opportunity to exercise their right to due process, has had an opportunity to be evaluated physically and has a comprehensive hearing as well. As amended, also allowing students to continue to attend state-funded programs such as Regional Institute for Children and Adolescents, known as RICA. This bill does not, and I want to emphasize, this bill does not deny a child's constitutional right to an education, as you'll hear my opponents, as this is already law. Whether on a school campus, an institute, or a juvenile detention center, every child in the state of Maryland has an opportunity to pursue an education. I pre-filed this bill, in 2024, the fall of 2024. There are many who have sent in written testimony for today's hearing. There are those who are going to show up today, okay, that has not contacted me, came to my office, emailed me openly. My door is always open. And my concern with that is this. If somebody is testifying against your bill, wouldn't you like to have the opportunity to sit down and reason with them and just talk with them? Maybe you can come to a conclusion of maybe there should be one or two more amendments and try to work it out. Just to let you know, not one person that's opposed to this bill came to me and even did that. And again, I believe all of us should have the opportunity to talk and reason with those who are opposed. And I have a problem with that, and I believe you should have a problem with that as well, Mr. Chairman. I'm going to thank you for this opportunity, allowing me to testify. And given the gravity of this issue, it's imperative to protect our children. I urge you to prioritize and review the passage of Senate Bill 78 and making sure that we do what's right and what's best for the safety and the well-being of our children. I want to thank you again for this opportunity, and I am more than happy to answer any of your questions. Thank you, Mr. Chairman.
Thank you. Questions for the sponsor? All right, seeing no questions, thank you, Senators. I'm sorry? Oh, Senator Sidnor.
I was just going to let my colleague know if it makes him feel any better. I have a bill that was being heard later on today that this video was put out on, and trust me, nobody who's opposed to talk to me either, so I feel your pain.
I want to thank you for expressing that because that's concerning.
No, I mean, we're half joking here, but it's an important point. We operate collegially here, and as a matter of courtesy, our advocacy groups, if they oppose legislation, it'd be appropriate to contact the sponsor and have a conversation. Sometimes that's not always possible. Late in session, we're still in January. It seems like it would be the appropriate outcome for both of your bills here.
And if I could, Mr. Chairman, right now as I stand here, as a senator, I am still open to having an opportunity to have the coffee office and to sit down and have a coffee with them and talk with them. That coffee will be on me. You just come into my office is wide open, and I would love to sit down and have an opportunity to speak with them, like I'm sure my good senator would like to do the same.
Absolutely. Thank you, Senator.
Thank you.
We'll now go to the opponents of the bill, Stephen Bergman, Alyssa Fio, Elizabeth Letourneau, Kelly Quinn. Whomever would like to go first, please.
Mr. Vice Chair, we have one other member of our panel. Would it be possible to bring up?
Absolutely. I think we're going to do 4 at a time just because of the seating arrangement here, and then we'll have the last member of the panel come up after questions. Ms. Quinn. I'm sorry. Oh, Ms. Berger.
Ms. Berger.
Yeah, she'll come up later.
Okay.
Hi, good afternoon. I'm Kelly Quinn. I'm the Managing Director of the Choice Program at UMBC, and today I'm here in the capacity of my chairperson role for the Maryland Coalition to Reform School Discipline. We bring together advocates, service providers, and community members dedicated to transforming school discipline practices within Maryland public school systems. We are committed to making them responsive to students' behavioral needs in ways that are fair, appropriate to the infraction, and designed to keep children on track to graduate. 10 organizations signed on to our testimony in opposition to SB 78. We're guided by facts, research, science, and the law. We draw from our professional practices and considered opinion to offer that we know treatment works for children with sex offenses. Professor Letourneau will discuss that. Involuntary virtual placement generally has negative impacts. Virtual instruction is often inferior and not appropriate for long-term placement. And this bill would run afoul of federal law and regulations. We already have 3 existing mechanisms to achieve this bill's goals. We have the courts, where judges possess facts in cases like these and are best poised to determine whether a child is safe to be in the community. Senator Saling mentioned HB 814 from 2024, and we also have the reportable offenses statute that ensures safety in our schools. Education is the #1 protective factor in preventing youth from recidivism. Our communities are not safer when children are denied structure and support that schools provide. All children deserve classrooms, not screens. We believe in facts over fear. For these reasons, the Coalition to Reform School Discipline strongly opposes Senate Bill 78.
Good afternoon, Mr. Vice Chair, members of the committee. My name is Alyssa Fio, and I'm an education attorney with the Maryland Office of the Public Defender with 30 years of experience representing children in school-related matters. I recognize that SB 78 raises sensitive issues. I also recognize that we all care about safety in our schools. But SB 78 will not make schools safer. It violates federal law and fundamental due process. It is not necessary, and it's in direct conflict with the statutorily stated purpose of the juvenile court, which is rehabilitation. As you heard, just last year, the legislature rejected this specific bill, but did instead incorporate a provision in HB 814, the Juvenile Law Reform Bill, which states that any student who's on the Juvenile Sex Offender Registry is not able to attend school in person and provides a list of alternative settings. SB 78 goes significantly further by permanently banning children from all public and non-public schools that receive state funding. And let me tell you, that does include RICA. This leaves students only with virtual instruction or home and hospital services. This is a broad and permanent deprivation of basic rights of education. No state in the country that we are aware of has such a harsh and punitive provision. You also heard that SB 78 is not necessary because we already have the reportable offense process, which is in the educational Article 7-303. This body amended that provision in 22. And as we sit here today, the Maryland State Board of Education is poised to accept regulations that even make that provision stronger. That provision mandates reporting by law enforcement, allows school systems to make individualized determinations as to whether there is in fact a safety risk. I handle those cases on a daily basis, and I can tell you that under this process, school systems do and can remove a child from school if they find that there's a safety risk. We are concerned about the basic due process rights. It provides a permanent ban. There's no process for a family to be heard, no process for review. We urge this body to issue an unfavorable report. Thank you.
Good afternoon, Mr. Vice Chairman and committee members. My name is Elizabeth Letourneau. I'm the Moore Family Endowed Professor at the Bloomberg School of Public Health, and I launched and direct the Moore Center for the Prevention of Child Sexual Abuse. I speak today in strong opposition to Senate Bill 78. The views I expressed are my own and do not necessarily reflect the views of Johns Hopkins University. Please also see my written testimony. For 37 years, I've led research on child sexual abuse prevention, policy, and practice. I advise or have advised the Maryland State Council on Child Abuse and Neglect, the National Academies of Science, the CDC, the European Commission, the International Finance Commission of the World Bank, the WHO, among other big tech companies, governments, and agencies. It's my professional opinion that this bill will severely harm the children and youth to whom it applies and will not improve the safety of other children. Children and youth who have sexually offended are not homogenous. They include children characterized by ignorance and impulsivity, traumatized children reacting to their own victimization, children imitating what they've been exposed to on the internet and in their own homes, among other factors. Despite this diversity, decades of research document that children and youth adjudicated of sex crimes are unlikely to reoffend, are amenable to treatment, and are harmed by one-size-fits-all crime policies. Children and youth who offend sexually rarely reoffend. 97% do not sustain new sex crime charges, adjudications, or convictions. Children and youth who have sexually offended are responsive to proven, community-based, family-focused treatments, which have reduced reoffending, improved educational and other outcomes, and saved states money. Children and youth who have offended sexually are harmed by policies such as juvenile registration and notification, which decades of research show do nothing to prevent crime or improve community safety, but do increase the risk that registered children will be sexually assaulted themselves and will attempt suicide. We can safely predict that the practice of barring these children and youth from in-person education will result in similar tragic outcomes. I respectfully ask this committee for an unfavorable vote. Thank you.
Mr. Vice Chair and committee members, thank you for your time. My name is Stephen Bergman. I've practiced delinquency law with the Office of the Public Defender for 23 years. I've represented many youth charged with sex offenses. Last year, the General Assembly expanded juvenile court's jurisdiction in sex offense cases to include children as young as 10 years old. This was because courts can effectively address these cases, ensuring community safety, accountability, and treatment for the offenders. The courts do this every day, and they do it very well. SB 78 takes the courts completely out of the decision-making process and creates a one-size-fits-all law that fails to acknowledge the effectiveness of sex offender treatment for children, the important role of the juvenile court, and the essential need for individualized determinations to be made on a case-by-case basis. I'd like to share with you 3 unintended consequences of this law if it passes. 1, fewer juvenile sex offenses will be reported, fewer youth will receive treatment, and there will be many more unnecessary juvenile sex offense trials. Many sex offense cases committed by children, sex offenses committed by children, take place within families. Parents want immediate help for the victims. They also want immediate help for their children who are the offenders. Parents will be reluctant to report these incidents and will be reluctant to seek that help once they realize that doing so will result in their child, again, perhaps as young as 10 years old, being precluded from attending in-person school ever again and from participating in school-based activities ever again. In practice, most juvenile sex offense cases end in plea agreements. This is a good thing. It allows the offender to begin treatment immediately and avoids victims, often younger siblings, having to come in and testify in open court against their siblings. If the bill passes, there will be no more of these plea agreements. The consequences of such a plea regarding school will be so great that every one of these will have to go to trial. This will be damaging to families and will negate the benefits of these plea agreements. I urge the committee to issue an unfavorable report. Thank you.
Thank you. Questions for this panel from our senators? Senator West.
Thank you, Mr. Chair. Let me go back and let's see. Let's talk to the public defender first. I'm looking at your testimony. Actually, the first representative of the public defender. Looking at the testimony, it says during the 2024 legislative session, the legislature already took the extreme step of prohibiting children on the non-public juvenile sex offender registry from attending public schools in person. I assume from your statement that you take strong offense or strong exception to the bill that we passed in 2024?
We did submit testimony last year, very concerned, again, for the same reasons. We have children under the age of 18 or compulsory school age. We didn't believe, and we do not believe today, that a one-size-fits-all. We believe that the reportable offense process is appropriate, and also very significantly, and you'll hear from Megan Berger from the Maryland Disability Law Center, Disability Rights Maryland, is that we also believe that it's a violation of the Individuals with Disabilities Education Act. Again, a federal law that requires individualized determination in terms of services and placement. We did raise that issue last year. We're very concerned. And I do also believe, if I might say, that I do think there was some perhaps confusion last year that in HB 814, it says that the student may attend one of the listed schools. And I think there was an understanding that may meant permissive, that school systems could, in fact, view a situation, determine that there was a safety concern, and select one of those schools. But if you look further up in 11-722, it specifically says that any child who is on the juvenile sex offender registry is prohibited, absolutely. And it's that kind of blanket treatment of children that we find very concerning. And those same concerns that we had last year are now even exacerbated here, because it's saying if you are ever adjudicated, no matter what treatment you've gone through, no matter what the court has said, which has more information about the situation, the treatment, the safety issues, no matter that, you are absolutely prohibited from attending school.
Well, let me ask you this. Do you think it's unreasonable for parents who have children in the public schools to want to make sure that their children are safe and that sex offenders are not attending the school and sitting in the class at a desk next to their children? Is that unreasonable of them?
Let me answer that as a public defender, but also as a parent of 3 children who attended public school. It is not unreasonable, and in fact, it is an expectation that every child is safe in the school setting, that has the opportunity to thrive and achieve academic success. Absolutely. Do I want safety in schools? Absolutely. Are there processes in place to help ensure that school systems are safe? Let me also say that if we are really concerned about school safety, as emotional as this issue is, this is not the area that's causing the unsafeness in our schools. If you look at the data, you will see it's school fighting, it's assaults. Those are thousands and thousands of cases. So I would encourage you to look at positive provisions that really will support our students and our teachers, such as the reportable offense bill, which Senator Brooks is sponsoring. I do agree that we need safety in our schools, but I also agree that there are processes in place to ensure safety.
The issue of fighting and things like that, that's a different issue. I think you would agree. This is a separate issue which we have addressed. We addressed last year separately by passing this bill. And you strongly believe that we were misguided in passing a bill which prohibited children on the non-public juvenile sex offender registry from attending public schools in person. But then you really haven't answered. If I had a child in a school, I would not want someone who is on the non-public juvenile sex offender registry from sitting in the class with my child at the desk next to my child and perhaps going to the bathroom at the same time my child goes to the bathroom. Can't you understand that?
So what I would say is that these cases, and I'll defer to Professor Letourneau, can say that they are all very different. And what the reportable offense process does is it allows us to look at the individual child, the individual risks, the individual concerns, and decide, can this child attend school? Does this child need a safety plan? It's what we do in all areas in the juvenile court system, in the special education system. We treat children as individuals, and that's all we're asking here. We are not asking that children who pose a safety risk be permitted in school. We're asking for an individualized assessment of every child. And that, to me, when the issue of education, the most basic right to education is at stake, that is due not only to that individual child, but to our communities as a whole. I would like to let our other...
Let me come to a final question.
Yeah.
And that is, it sounds to me as if everybody is upset in this bill because if a child can't attend school, it's permanent. The child goes through the entire educational career without ever being able to attend school again.
That is one point.
That's what everybody is focused on.
That's one point.
Suppose we added a provision to this bill which gave the opportunity for an individualized assessment of the kids who are not attending school periodically.
That's what the reportable offense process already does. It requires a review every 45 days. That's what I'm saying here, is that you have this. Now, if there are concerns about whether the reportable offense process is working, if there are concerns about whether law enforcement is notifying the school system, let's all come together. I've said many years that I sat in on the 2006 committee that developed the model policy for reportable offenses. And I would very much welcome the opportunity to sit with all the parties that are at play here to talk about how to ensure that the reportable offense process is adhered to appropriately.
And that triggers a final question. I
Yes.
thought that was my last one, but you
Yes.
heard Senator Salling complain bitterly that he introduced this bill early, and here we are now at the very end of January.
Yes.
And no one has ever had the courtesy to come to his office and say,
Yes.
let's talk.
Okay,
and so now in response to my question, you say,
Yeah.
what we really need to do is talk. Why didn't you talk previously with the
So-
senator who introduced the bill?
I would like to respond to that because I do consider myself to be a person who likes to collaborate. I think we can bring minds together and problem solve. We do not have access to pre-filed bills. I'm not sure if you all know that. We do not know in the public.
But we all saw them around the end of the year. About the first of the year, I think it was the week before
I'm not sure.
New Year's Day.
I'm not sure
they
about
all
that.
came up online.
But I can also tell you that not only do I do what I'm doing here today, I have a full caseload representing children every single day. There is an onslaught of bills this session impacting juvenile justice, and quite honestly, it is a little overwhelming in terms of how to manage. For example, there are several reportable offense bills. It would be helpful if the legislators came together and said, okay, we all want to address reportable offenses. Let's come together and see how we can manage that.
Okay.
I
So I understand you've been very busy, but let me ask one final question of the whole panel, and that is there anyone on the panel who thinks they had the time between when these bills went live at the end of December and now to call Senator Sallings and said, could I come down and sit with you?
We are
Is there
open to do
anybody on the
that.
panel who had the time to do that, or were you all too busy to do it?
I think we understand that.
We are open to doing that. We certainly are.
Thank you.
Senator Henson or Senator McKay, go ahead. Senator McKay.
Thank you, Mr. Chair. There was mention about being fair. I'm going to put in the word balance. I find it offensive. Offensive, number one, you don't have time to go meet with the senator? That's offensive. Ma'am, no, I've heard it. Okay? Second of all, we have a Department of Juvenile Services that is in complete disarray. They are pushing the blame on the judges, they're pushing the blame on the police, they're putting the blame on us, the legislature. It's about time that we stand up for the 99% of the kids that are being put at risk. If you are convicted, you should not be in the same room as your children, or my children, period. Now, we need to then collaborate and figure out a way that they still get an education. But it is so disingenuous, and it just is not fair to the 99.9% of the kids. Washington County Board of Education states in their support that Senate Bill 78 reflects a commitment to safety and rehabilitation of establishing notification to local school systems and keeping violent offenders out of school while ensuring educational options for the specific needs of the affected students. Whether it does or it doesn't, this seems to be, we're looking out for the 99.9. And we have heard a common theme already in this year, that it's not the poor juvenile who has been convicted. We've had not anecdotal, sad stories about these kids preying upon other kids being put in there. I was on a panel with the superintendent, and she was saying we need to go a little bit further to be making sure that the right people are communicated with.
Complete agreement.
Okay?
So, Senator, I'm sorry, go ahead, please.
I'm getting so tired of everyone going like this, and we're not solving it. And then to say, and I'll shut up after this, don't have the time to meet with him?
Senator, that was not what I was implying that the legislative session has just begun.
So ma'am, we can't record you if you're not on mic. Senator, if you want an answer, we're happy to have that, if that was just.
I'm just gonna leave it at,
Okay.
that it isn't that so, because we're either going to protect all the children, or we're going to take care and make sure that all the children are educated. But I'll be damned if we're gonna sit here and say that the 1%, because they have been convicted, that they should be in the same classroom as my kids, your kids. It's flabbergasted.
Senator, if I may respond.
I don't think a response was requested.
Okay.
Senator Folden.
I have a question. Whose timer went off? Was that on you? Thank you, Mr. Chair. So I've listened to your panel, and someone made the comment about it's time to face facts over fear or something to that effect. I believe it may have been you. Can you please tell me how you can come up in this committee room and in good conscience say that it's a time to put facts over fear when the facts are we have juvenile sexual predators who have been convicted, are then still unsupervised, whatever DJS does because they're failing, and then they're back in schools without anybody knowing. Can you tell me how that's not a fact? And what fear, like what fact, that is a fact, and that's way over your fear that you're expressing, because your fear is that they're not getting their education entitlement when we're trying to say, you've done wrong, we're going to protect the other 99.9% of those that aren't sexually preying, because that same student that I'm speaking about then went back into the school and he sexually assaulted a 14-year-old girl.
Senator, if I could just respond to that.
That's what this bill's about, by the way. This incident.
We want to keep 100% of the children safe.
That's what I'm talking about.
And the question's not the 99 or the 1%. The question is, having this case before the juvenile court, there are many different.
Sir, I want to, with all due respect, I hear what you're saying. I'm making a very pointed statement to have somebody answer as to how you're going to come in here and tell us that this is not facts over fear. And whoever said it, I believe it was you, whoever said that, I would like an answer to that.
Thanks for this opportunity. I am here, like my colleagues, because I lead with both my head and my heart. And I understand that this is painful and sensational and excruciating. I am a sexual assault survivor. It is painful to stand here today. And I want to tell you that those who hurt have also been harmed. And we're here for all of those children. And what Dr. Letourneau's What Dr. Letourneau's research shows us is that once children have been adjudicated, and when they get the proper support, including therapy and treatment, 97% do not commit another crime.
And that brings me
That's
to,
my
and that
fact.
brings me, and I appreciate that, ma'am. What I'm telling you is that as a career police officer, being involved and handling these incidents and seeing how the juvenile justice system fails our children, how the school system in protecting these children and not making the school board of, even this principal aware that they have this sexual predator in their building, so that at least the school resource officer can be aware to have some proximity to protect those that might be at risk, which ultimately led to this 14-year-old girl being sexually assaulted by someone that had been convicted already. That's a fact, ma'am. And I appreciate and understand and wish you didn't have the past that you've had to endure. But this is their reality in that school setting. So how is anything that we're saying here troublesome to you? And on that,
This is all troublesome to me. And I would especially like to support law enforcement officers.
and I wish we had more people that were thinking that way.
To inform the school when, and to follow the due process and to follow the notifications that are in place.
So how would so there's been a lot of talk since COVID, right? Everybody's kids got crammed at home, and we put them on these RVP programs, these remote virtual programs, right? How is that opportunity, if the state school board takes up the role of a statewide RVP for these type of offenders, how is that failing our children by not providing them with an education?
I'm so glad you asked that, because I think Megan Berger is going to speak a little bit more about that, about what is required when we need an individualized plan. What we know is that remote learning—
We don't need an individualized plan, ma'am. They're supposed to be in a certain grade. The grade is what it is, and you teach them.
To accommodate their learning needs. What we know is that remote learning can work well when families opt into it and when it's voluntary. When it's an involuntary blanket ban, it fails students, especially those with special learning needs.
So we failed everybody during COVID? We spent a lot of money and failed everybody?
I did not say that.
Well, it was forced.
I did not say that. I'm talking about this particular set of—
You said it was not voluntary. You said a voluntary versus, maybe I'm miss.
I think we're speaking at cross purposes now.
So whether or not it's voluntary or not, by their actions, it becomes a part of their educational paradigm at that point, ma'am. That's my point.
Yes.
Is they volunteered for it by their actions. So in an effort to keep the other children safe, I don't really concern myself with their feelings of, well, now I got to sit at home and log in and learn this way. And it should not be an individualized learning program. It should be set up based on the same criteria that the State Board of Education requires, that all these children have to meet certain markers by the end of certain grades to be able to move on. But even that's a failing philosophy, because we've got children that are graduating at an exponential rate in this state that can't even read beyond 6th grade. So that's a whole nother discussion. But I wanted to point out, because that facts over fear, I'm sticking with facts, ma'am. You call me Joe Friday all you want, but I'm not going to sugarcoat it. I'm not going to sidestep it. And I'm certainly not going to get drawn into the emotional pleas of facts over fear, because I'm basing my argument today on facts only, not emotional.
Yes.
All right. Thank you. Thank you so much. Senator James.
Thank you. Thank you. And thank you, panel. You know, I thought the hearing was going to be one thing, but it sort of morphed into something else, and a little observation before a question. I think what I've seen since my own childhood, which wasn't that long ago, it was a long time ago, when schools would readily expel misbehaving students, there was a lot of different ways of handling children that were problems, right? Much of that was rightfully too abusive, too strong, insensitive. We've come a long way, and I am a huge supporter of mental health services and interventions and all that. But in a way, what has happened, and I'm trying to speak for the larger public, because I may be a legislator, I'm a lawyer, so I'm in your group most of the time, but I'm also a mother, and I live in my community and really think about it. We have, for so long, and rightfully been trying to help the small subsection of children that are problems, right? Without the heartless expelling or paddling, which is allowed at one point, and all that kind of stuff. Of course, that did scare the bejeebers out of kids, and many of them responded by being well behaved. But I was not paddled myself. But in any event, but what you see now is that we have lots of services. So whenever we have a bill like this, lots of people like you come down, lots of advocates, lots of government people. We have Department of Juvenile Services. You come in, you're in your academic world, you've got studies, all kinds of stuff. And you believe that, you're bringing the whole story. But there's sort of like almost a silent majority of parents who are not in your world, and just because they're not here doesn't mean that they aren't the most powerful force that we ought to be thinking about. And if they don't trust your judgment, which many of them rightfully do not, and by you I don't mean you personally, I mean you in the larger sense, government swooping in, telling everybody they're gonna fix everything with just this kind of service and that kind of support or wraparound. And these parents are sitting here, I don't want people to hear these hearings and go, well, there was nobody speaking for the parents. It must be okay. You all are right, and everyone else is wrong because they're not here testifying. They're not testifying because they're busy trying to protect their children and families, but it's lopsided, and in a way I wish we did have big groups, victims groups and parents groups, to come down here to express to you all and regularly speak to you about the fact that all these protections we're providing for a minority of students is very disquieting, doesn't strike the right balance, and particularly when you ask parents to forego their own good judgment in protecting their children because that you say you'll protect them. Law enforcement cannot tell the schools anything about these children, but don't worry, we're gonna protect your children from this minority of bad behaving children. A lot of these services are failing. So you can't both ask that the parents remain blinded and ignorant of which children are risky, and also because you say, well, we will take care of the children, we're going to protect them, the misbehaving ones, and tell the parents to butt out, basically, don't worry, and we're not going to give you any information because we got you covered. You don't have them covered. Department of Juvenile Services is failing. Many other aspects of government are failing, and it's hard to, you can kind of see why. Government is not a parent, a family, a solid upbringing, things like that. So I would kind of bring that to you all because I know you're coming with the right heart. Your heart's in the right place. You work with these children, but you can't be insensitive when you come down here with your testimony and not realize why there is so much anger. It is not irrational. It is fact-based. It's experience-based. And these parents, like you all, only have one shot with their child, one shot to avoid harm from the beginning until they're emancipated. So that's the struggle we're having. So, and the bill represents that frustration. So what I'm really hoping, and here's my question, please go meet with this sponsor. There are a lot of us that may not be on this bill, but are very sympathetic to the problems that this bill and others this year are expressing in different ways. So I'm hoping, can you all sort of commit that you will work with the sponsor, and you hear what I'm saying about this?
Yeah, and if I may, thank you for that. I am also a mother and, one of those people who has one shot to get it right with her kids. And I want to say that, the work that I do at the Moore Center at Hopkins is informed by many of us. Most of us are, in fact, parents. And we include parent advisory boards in our work. We are not divorced from the concerns, nor are we ignoring the concerns of parents. So I think that is absolutely critical.
That's not well known by any parent that I know of. So you're not doing a good job of communicating their participation and the fact that they are representative. So I would question, glad you have them, but you better communicate that to the parents. That
at the Moore Center.
You have advocates there that absolutely represent their concerns.
I also do think we can be careful and caring of all of the children, including children who have caused harm. Most of them don't cause harm again once they've been caught. Most of them respond very well to treatment. Again, 97% don't go on to reoffend. I think that a blanket, there's no single child that represents an entire class of children. We know some kids cause harm, there's no question, but most of these kids learn the lesson once they are caught and held accountable. That's those are also facts. We rely on judges to make determinations about supervision and treatment for individual youth. Blanket, one-size-fits-all policies like this harm children. We do not have to harm some children to keep other children safe. That is not what we're
I
tasked
didn't
with.
bring any of that up, and I want you to respond to me, all right? Yeah. I think you're responding to other criticism, then that's fine. My only criticism of you all is you didn't mean to do it, but you came in with this, sounded a little tone deaf to me about the fact that, one, you sort of are all-knowing, as if the parents that are not here today and the many, many thousands of parents that aren't here today testifying about their worry. And it's not your problem, but the many state agencies and wraparound services are failing kids, right? So what I'm saying to you all is, I didn't ask you to go support this bill. I'm not sure I support this bill, but I do know that you should be collaborating with the many legislators that are putting these bills in to express what parents are feeling and experiencing in their own lives. And one incident of harm to a child, I'm glad you agree there's not, you lower recidivism, but the first incident is the harm too.
I agree. I would love for there to be effective prevention programming in our schools, and we have developed that. We've tested it. We would absolutely love to see it available in all of our schools.
It's needed at home
We still
too,
have
because schools are not
one more witness on
omnipresent
this.
parents either. Thank you.
Thank you all. I think Senator James is exactly right. It sounds like there's a desire in the committee to do something here, and I'd ask that you meet with the sponsor and find the path forward. That concludes this panel. We do have one more person scheduled to testify. It is Megan Berger from the Disability Rights Maryland. Ms. Berger, you have 2 minutes.
Thank you. Good afternoon. I am the legal director at Disability Rights Maryland, and I wanted to come today to talk about our concerns about the bill because it violates 3 federal laws that protect students with disabilities. That's the Individuals with Disabilities Education Act, Section 504, and the Americans with Disabilities Act. So for students with disabilities, the most problematic part of this bill is the blanket prohibition. You've heard other members of the panel talking about it. The blanket prohibition and the denial of an individualized determination of a student's academic and special education needs. And this is a problem because one of the most fundamental principles of the IDEA and 504 is that each student's needs have to be evaluated, addressed in an individual manner. There has to be an IEP team meeting with parental participation. And SB 78 violates that principle because it allows for unilateral blanket removals to virtual school or home and hospital. The second problem is that it violates the law's least restrictive environment mandates. And those mandates say that there's a continuum of placements. Virtual instruction and home and hospital are on the most restrictive part of the continuum. And so this law, again, unilaterally stick students on that most restrictive continuum. And again, that just violates the process in the law because there's no individualized assessment, there's no evaluation before that unilateral change in placement. Lastly, because the bill provides no end date for the removal, and students with disabilities can attend school through their 21st year. So if a 14-year-old student with a disability was charged, adjudicated, convicted, and then sent to virtual school, he would be banned for 7 years. And for these reasons, we urge an unfavorable report.
Thank you. Questions for this witness, Senator West.
Thank you, Mr. Chair. I'm going to be quick. Are you telling us that a student who's a convicted sex offender qualifies as a student with disabilities and is entitled to all the protections the law provides to students with disabilities?
What I'm saying is that we're not going to be able to hear you. Oh, sorry. Okay. So I'm not saying that the offense qualifies them as a student with a disability.
That's what this bill's about. This bill's not about students with disabilities. This is about convicted sex offenders.
I appreciate that point, but part of the kids that get impacted by this bill will have pre-existing IEPs. They'll have pre-existing individualized education programs and 504 plans. And so because they have already been identified as a student with ADHD, a learning disability, autism, an emotional disability, they are coming with these plans and they have these federal protections.
Oh, wait a minute. You can simultaneously be in each category. You can be a student with a disability, and simultaneously, separately, you can be a convicted sex offender, correct? And this bill only is directed to the fact that that particular individual is a convicted sex offender. I don't understand this bill to be directed at a student with disabilities at all. Am I wrong?
So a convicted sex offender can also be a student with a disability with a pre-existing IEP.
Right. I can be a student with I can have a disability, and I can also commit first-degree murder. And if I'm put in jail, it's not because I have a disability, it's because I've committed a first-degree murder. The two are separable, aren't they?
But the federal laws aren't separable. I mean, you have to have an individualized determination when you're determining the placement of that child. It can't be a unilateral removal. And so the reportable—
So if I'm a convicted first-degree murderer, just because I have a disability, I have to be put into a class with other students, and they have to exist in a class with me even though I'm a convicted first-degree murderer.
I'm not saying that.
Doesn't make any sense.
Okay. What I'm saying is that there has to be an individualized determination by an IEP team, and the reportable offense law that we already have that's existing, we've all been part of these school meetings where the school is dealing with a reportable offense, maybe a sexual offense. They have to get together, collaborate with the IEP team. They very well may say, this kid's moved to virtual education. The safety risk is too high. We're meeting the special education needs. We're developing a plan for FAPE, but it's individualized. There's parental participation, and they're taking into consideration the special education needs of the child. Okay. And so the decision could be virtual school. This child is not safe to be in this school building. We're not saying that's wrong, but we're saying it has to be individualized because there very well may be some kids, based on the unique circumstances, based on their educational needs, based on a lot of different safety concerns and academic concerns, where a safety plan could be made that would allow that student to remain in some type of school setting. And HB 14, which was passed last year, these students are already only attending RICA or non-public schools or virtual.
Okay, thank you very much for your answer.
Sure.
Any further questions for this witness? All right, seeing no questions, that concludes the hearing for this bill. Thank you so much for your testimony. Senator Kagan, you're next. While you're coming up for Senate Bill 322, let me thank you for your patience and flexibility as we are the Judicial Proceedings Committee.
Thank you, Mr. Chair.
Whomever you'd like to bring up with you.
I'm happy to have my witnesses come up. We just have two of them, and this one's going to be pretty quick, I think, and hope, and not nearly as emotional or controversial. No. For the record, Cheryl Kagan, very proud to be the senator for Gaithersburg and Rockville. It is unusual, but I'm actually going to read this bill to you because it is one sentence. On page 1, lines 15 and 16, this is about license plates. A person may not obscure or modify any vehicle registration plate in a manner that may prevent identification. Colleagues, as we know, whether it's speed cameras, red light cameras, amber alerts, silver alerts, the kidnapping of a child, a senior with Alzheimer's or something, we need to be able to read a license plate. We have computerized equipment to make sure that we can snap pictures of the plates, but again, sometimes whether it's on purpose or just the degrading over time, these license plates are no longer able to be read. MDOT, the Department of Transportation, asked me to put in this bill. It is a modification of what I came with last year, which was a little more complex. All this bill does, it takes out the need to have, to demonstrate intent. So Sometimes license plates are just old. I want to give a shout out to MVA Administrator Chrissy Nizer, who started the pilot program, you may remember, last year. And when a plate is 15 years old, when folks have either transferred or had a car for a long time, as we do now, because they're made better, the plates do get harder to read. And so you get a letter with the option of getting a new plate, which is sent. A lot of other states, 24 other states, have enacted similar legislation: Arizona, California, Florida, Georgia, Illinois, Indiana, Louisiana, Michigan, Minnesota, Mississippi, Nebraska, Nevada, New Hampshire, New Jersey, blah, blah, blah. You can hear that they are red and blue states. This is just common sense, and it's about safety. I'm very glad to have the Maryland Chiefs of Police here, as well as the department. And with that, I'm happy to take questions, but this is a really simple, common sense bill.
Thank
So
you.
thank you, Mr.
We'll take
Chair.
the rest of the panel, then questions after. if that's
Perfect.
Okay.
In order, go for it. Or you can use the podium.
Ma'am, if you're able to use the podium, that is our tradition, but.
Good afternoon, Vice Chair and members of the committee. For the record, I'm Heather Coberly. I'm the Director of Easy Pass Operations for the Maryland Transportation Authority. I have with me today Shannon Orange, the Deputy Director of Easy Pass Operations. I am here today to testify in support of Senate Bill 322, which would prohibit a person from obscuring or modifying any vehicle registration plate in a manner that may prevent identification. The bill would alter the intent portion of the law. The act of obscuring or modifying a vehicle registration plate is a moving violation regardless of a person's intent or to obscure or modify the plate. With respect to the operations of the MDTA, a motorist who travels through an MDTA toll facility with an obscured or modified license plate results in lost revenue due to either the notice of toll due not being sent to the incorrect customer or not being able to identify the vehicle owners at all. Advances of digital video imaging technology make all electronic tolling the most popular form of toll collection. All MDTA facilities now use all electronic tolling. The benefits of this electronic tolling it comes with a cost and challenges that we didn't have before. Fraudulent, obscured, or altered license plates challenge our system and impact our business practices to collect tolls effectively. The ability to capture license plate details accurately and reliably allows MDTA to process transactions for all road users. For the MDTA toll vendors identified more than 388,000 and more than 380,000 obscure license plate in calendar years 22 and 23, respectively. Unfortunately, the reality is not all Maryland motorists pay their fair share of their tolls. We believe that Senate Bill 322 will help to ensure that all Maryland motorists traversing state roads pay their fair share. I thank you for your time and respectfully request the committee issue Senate Bill 322 a favorable report. Thank you.
Thank you. Mr. Morris.
Good afternoon. Mr. Vice Chair, members of the committee, David Morris, I'm the Chief of Police for the town of Cheverly, here in support of this bill and Senator Kagan and the Maryland toll facility as well. With regards to this bill, we just asked for a favorable report. I think enough has been stated by the folks that have already spoken, but certainly here to take any questions.
Excellent, thank you. Questions from the committee? Oh, Senator Love.
Thank you, Mr. Chair. I remember this bill very well from last year, and one of the challenges that we had was, what about somebody who has a go Commanders, go Ravens, go whatever license plate holder that obscures part of the license plate. So we tried last year to work around that with the language that we had. Is there any reason why you didn't come back with the language that was passed out of the House?
So, Senator, in this last year's hearing, that did not come up, and we're not aware, I'm not aware of any problems with obscuring license plates based on a frame. It's not supposed to cover up the number and shouldn't, so that enforcement can still be handled by the equipment.
Okay, but the language that was passed out of the House last year, do you have any problems with that language?
We will look for it. I'm not aware of it, honestly.
Okay, thank you.
Thank you. I wonder
Thank you,
if we're
Mr.
thinking
Chair.
of a different bill, because I'm not sure whether the House crossfile moved last year, but I can totally look into it.
Yep,
Thank you, Senator Love.
Thank you, Mr. Chair. Senator, thanks for bringing the bill. I just want to say that if anybody has Go Commanders as an Eagles fan, I would say get it off. They should probably be stopped anyways. A little sus. But this bill just specifically, I'm sorry I had to step out for a moment, but this bill specifically is about the ability to actually see and identify or read the tags. Is that correct?
That would be right.
And I want to just say on the record, Madam Senator, that this is probably the first amazing kumbaya moment for Senator Kagan and I, that I will actually support your bill. Thank you.
Move favorable, Senator Folden. Thank you.
Look, a broken clock's right twice a day at least, so. All right, further questions from the committee? All right, thank you very much. Thank you, Senator.
Thank you.
Go Navy. There you go. All right, are we done? Is there opposition? Sorry, I think that'll close it. Okay, so that'll conclude the hearing for Senate Bill 322. We'll now move on to Senator Simon Eyre, Senate Bill 281.
Yeah, you want the mouse or do you want this? This or the mouse? Yep.
Okay, you can drive it from there. Excellent. Okay, great. All right, Senator Simon Eyre, welcome. You're up.
Thank you, and I apologize for being here, but it's try to make it through the 90 days. So anyway, for the record, I'm Senator Brian Simon Eyre, presenting Senate Bill 281. And what I wanted to do, we have two bills in this committee dealing with this package. So the first one, I wanted to give you a PowerPoint. I don't like a whole lot of PowerPoints, but there's a lot of information, so I wanted to share it with you. So basically what this bill has it has definitions in another bill that are incorporated here because we use the terms. So I just want to go over briefly what we have there. So this is a comprehensive updating of our military laws in Maryland. We're updating over 500 references, 230 sections, almost in every article, and I've organized it by committee, so we didn't have a 200-page bill and everybody was secondary to it. So what we have here is the 8-bill legislative package. The top one is the modernization of military laws, and that's the restructuring and the definitions bill. We had that hearing in EEE. We're going to work that. Any tweaks to it, we'll send over to this bill to incorporate into this bill. And then the other 7 support it. And the one in the bottom left is the transportation bill, which we're going to be talking about today. So what is the problem we're trying to fix? All throughout our articles, we have local definitions, whether it's in health or public safety or education. They all have their own little definitions and inconsistencies. So we're trying to address the inconsistent definitions, But we're also trying to deal with the undefined terms in Maryland law. Reserve component, active duty, military families, they're all undefined. We have some that are defined like veteran in the general provisions article, which has one definition, and then you go over to state government and it has another definition with two different scopes. So it's bringing consistency to all of Maryland law. So what are the negative outcomes of these problems? One is it creates confusion. It's inconsistent benefits across our service members. It's a nightmare to update, and we're out of sync with federal definitions. So 275 presented three things. I'm going to go over one part of it that pertains to this bill, and that's the restructuring of the military laws. So this just rolls off the tongue, so I'm going to do it. There's three things: standardization, centralization, and modernization. So the first thing we do is standardize the terms to federal terms. The second thing we do is centralization, which I love. And right now we have all these local definitions for all the different articles. And what we do is we centralize them in one location under state government where the department is, and then we have the other local articles point to that definition. Give you a case. Last year we updated Space Force. So we had to go to like 12 different locations and find out where we had to update Space Force. After this bill is passed, we will go to one location, we'll update that area, and then everything else, since it's only referencing, they get it all. So it's just very simple for future. The last thing is modernization. For example, military ID is no longer called military ID, it's called Uniformed Services ID. If you go to the National Guard, that will show you an ID, it says Uniformed Services ID. I had a delegate in my office who's a spouse, and so she pulled her badge out and she said, it sure is, it says that. So it's just updating terminology like that. Another thing is a couple years ago, we created another reserve unit in the Uniformed Services. A lot of places in our law don't have that, so we're updating that to modern terminology. So before we go too far, I would just want to start off with standard understanding. Most of you understand it, but just for the people listening and the millions on the YouTube watching us, uniformed services consist of 8 branches. You have 6 military branches, which most people are familiar with, and then which is called Armed Forces, and then they have reserve units, which include the National Guard as well. The 2 non-military branches of the uniformed services consist of PHS, which is your public health services, and then NOAA, which is the National Oceanic and Atmospheric Administration. They have commissioned officers, and it should be noted they're actually headquartered here in Maryland, both of them. One is in Bethesda and one is in Silver Spring. PHS, as I mentioned, has created a new ready reserve for their reserve unit. Many may not know what all PHS and NOAA does. They do a wide range of things, but how they interact with the military branches, NOAA was over in the Persian Gulf helping sweeping mines for the Navy. They also use their satellite data on almost every military operation for that. And PHS, they sent over, I think, around 800 officers over to the Iraq and Afghanistan conflict. Not only did that, they went over to Africa when the Ebola outbreak occurred to try to protect us from getting that here. So all the branches serve and protect just in different ways. And that's why they all deserve equal respect and treatment. I want to say this has been a collaboration. This is not something I did in my basement. I did sit on my chair a lot because I've been on a scooter, so I had a lot of opportunity to think about things. But I coordinated with all the departments that were involved. I coordinated with the military and the uniformed service branches, advocates, former JAGs, legal experts. DLS has been incredible. We have a few little amendments that we're going to be putting in. I'm working with the Department of Veterans and Military Families. One thing about that, you probably won't see a letter in here from the department, and I've been working with the governor and the department, and they want to see what the fiscal note is before they weigh in at that point. So we've been working very closely together. So far, this is our 3rd hearing, and all the budgets or all the costs are within budget. So just if something happens I don't know about and we get a $10 million fiscal note that I didn't anticipate, we've agreed basically to take that one little section out, and when we have more money, we can address it and pass the 98%. So just as far as strategy. So getting to this bill specifically, it pulls in those the terminology that I was talking about and the structure from Senate Bill 275, It provides equal benefits primarily by changing armed forces to uniform services, but it was not a simple find and replace. We went through every single term and saw if it applied. I have a bill hearing, I believe, next week with public safety and all that on this, and you'll find there are exceptions, like for gun qualifications, that armed forces gets an exception. We did not include uniformed services because they're not trained with handguns and so forth. So it's not across the board. We looked at every single term. And then the other thing, the provisions that are in the transportation article that applied to armed forces, sometimes it applied to armed forces and PHS, but not NOAA, and it was just a mix match. So we applied them equally across all branches so they all get equal services where it's appropriate. And then we simplified the laws where there was redundant terminology, especially with the new federal definitions. One area, just as you're looking probably for next week, if you see National Guard is struck from the bill, it's not because we're striking National Guard, it's because it's part of the reserve component definition now. So when you say reserve component, it incorporates them, so it just have to use that. And I'll close with saying the goal of this was not to change the underlying policy, but to make it equal across all branches. If we tried to put in the policy changes with this big of a bill, probably wouldn't go anywhere. So the goal is keep it equal, or keep it the same policy, but make it equal across the board. And then as I was talking to the uniformed services branches, they said this will be a model for other states. They said other states are going through the same thing where you saw last year, many times we put in uniformed services in bills. We're piecemealing it. This was a comprehensive way of doing it, and they see that going forward. And with that, I will stop. I could talk a lot longer, but I'm going to stop and let you go to the other panel if you want. The later it goes, I'm sure that goes down.
We'll try to be brief for those 75 people. Chair Smith, members of the committee, thank you for the opportunity to testify in favor with amendment to Senator Simon Ayer's bill. For the record, I'm Dave Dragic, a retired Army colonel and legislative director for the Maryland Military Coalition. We strongly support this bill's modernization of the Maryland Code, making it consistent with the U.S. Code and using key terms related to the uniformed services and making the use of those terms consistent throughout the Maryland Code. This is critical as a lower percentage of our population serves or has served in the uniformed services. 88% of the current 185 members of the Maryland General Assembly have never served in uniform. That's all the more reason to ensure that the usage of these terms in Maryland Code is clear and correct, leaving no opportunity for misinterpretation and for our position on the term veteran in SB 281. Our position is to make certain that those who have served in the PHS and NOAA continue to have the same rights and benefits as those veterans who have served in the armed forces and received a DD Form 214 that is other than dishonorable. Our position is to make certain that all federal and state legal references supporting that clearly indicate the same thing to all who will use these references in the future. That is why we have worked with Senator Simon Ayer in requesting this amendment to avoid any misuse of the term or misinterpretation of who is a veteran in any future legislation or policy making. So the Maryland Military Coalition strongly supports SB 281, asks for a favorable with amendment report from the committee. We would like to thank Senator Simon Ayer for sponsoring this important legislation and appreciate his leadership on this issue.
Thank you, Senator Simon Ayer. This is a lot of work. My dad was on the first, and I guess it continues, recodification of all the Maryland laws, and they told him it would take a couple of years. He was on it for 13, and that's why we have many of the better annotated codes that we have, and now we keep them up. I just wanted to get a little background. Did you just undertake this all by yourself to look across the breadth and depth of our code and work out and see where we had inconsistencies and then develop consistencies in collaboration with the various groups? This is sort of your project?
My
You were
wife told me
saying
I
we
needed to
lot,
get a
and I thought
life.
maybe there was it the universal we or the,
Yeah.
the royal we or there really was a group behind you, I'm not sure.
So basically, when I was sitting in Triple E, I saw inconsistencies coming across. So I was going to just update those sections. And the more I got into it, I found it just kept going further and further, and I just realized the whole thing had to be updated.
Well, I just applaud you because this is very detailed work, you know what I mean? And it's thankless work sometimes, so, and a great service. So my only suggestion is I hope that once you do this and we get it updated and we get the buy-in of everybody, that we can kind of, because you're not, none of us are going to be here forever. It would be good to kind of make sure that going forward, when we make legislation that affects these areas, that we keep that consistency. I don't know if you can collaborate with DLS and bill drafting and others to sort of give them a little manual on how to think about this, but it'd be great if you could leave behind some of your wisdom in this area, because you've done a great service, and there's no reason we couldn't do a better job going forward, do you think?
So I worked with DLS very closely, and I had one person, Jody Chilson, oversee all 8 packages, so she was wonderful.
Good.
And the way we've restructured it, it will
That'll help.
basically mandate that they have to go to one section now, and there'll be references.
Yes, that's great. All right, thank you, Mr. Chairman.
Thank you, Mr. Chair. I want to agree with Senator James. I don't often do that. I do it all the time. I do want to agree. I think this is a magnificent project, and you've done wonderful work. And maybe we should hope that more senators get confined to a scooter for a year.
No, I don't think anyone would do that.
Have time to spend on things like this. So I just want to also reaffirm what Senator James said. When I was a young lawyer back in the 1970s, the Maryland Code had numbered sections, Article 1, Article 2, et cetera. And starting just after I was sworn in as a lawyer, we began to recodify and put them into sections which made sense, courts and judicial proceedings, for example, corporations and associations. But the whole principle was we weren't going to change the substance. It was merely a recodification. And it sounds like that's exactly what you've done here. You're not changing the substance. You're just trying to recodify things and change language and update language. So
for the most part, the change is that we're making it expansive to all 8 branches. So the policy is not changing, do they get a discount on this or do they get that, but to make sure that wherever we do it consistently. So where they only did 6 branches or 7 branches, we make sure it's 8. But the underlying policy stays the same.
It's a commendable effort, and I want to congratulate you. Thank you.
All right, further questions from the committee? Oh, Senator Fulton.
Hey, thanks for bringing the bill, Senator. I was looking here at the 9-901 of the state government article, and is there an additional place where you expanded it? Because that talks about specifically U.S. Armed Forces. Did I miss that?
Yeah,
Because I'm talking about
that is the definition section, and
Yeah.
one of the definitions is armed forces in 10 U.S.C. 101. Then you have the uniformed services, which is 37 U.S.C. 101.
That's where I didn't go. All right, thank you.
And we got a Veterans Caucus letter, just got in a little late, and the American Legion are also supporting it, but they'd be a different place right now.
Okay, great. I was going to say that we have 2 witnesses signed up in favor from the American Legion. Are they
are they
otherwise
here?
engaged? Or, Joseph Pruden and Melvin Graves?
They may have had to leave.
Okay, great. Well, thank you, Senator. Thank you.
All right, thank you.
Mr. Dragas, thank you. All right, with that, that'll conclude the hearing for Senate Bill 281. We'll now move on to Senator Carrozza, Senate Bill 25. Welcome.
Good afternoon, Mr. Chair and
Senator.
Vice Chair, members of the esteemed Senate Judicial Proceedings Committee. For the record, I'm Senator Mary Beth Carrozza, representing Worcester, Wycomico, and Somerset counties. And I'm here to present Senate Bill 25, a child custody evaluators and training bill, and to respectfully ask for your support for this bill, which would help ensure the safety and well-being of children involved in child custody proceedings involving child abuse and domestic violence allegations. And I want to start by informing you of an appalling statistic provided by the Center for Judicial Excellence. Between 2008 and 2023, 21 Maryland children have been killed when divorce, separation, custody visitation, child support, or court involvement is a factor, including 5 of those children involved in family court-related proceedings. Each year, 58,000 children nationwide are estimated to be court-ordered into visitation or custody with a dangerous parent. Make no mistake, Senate Bill 25 is a child protection bill. Serving on the bipartisan work group to study child custody court proceedings involving child abuse or domestic violence allegations back in 2019, with our former colleague, Senator Susan Lee, and the Maryland Secretary of State, John Wobensmith. This was one of the most important public service assignments that I ever experienced, given the magnitude of the trauma that many children and their protective parents experience when child abuse or domestic violence is alleged during custody court proceedings. This legislative priority recommendation to require qualifications and training for child custody evaluators in cases of allegations of child abuse and domestic violence comes from the work group's final report, which was published back in September of 2020 and led to the first introduction of the Child Custody Evaluators Qualifications and Training Bill in 2021. That's right. This is the 5th session that the Child Custody Evaluators and Training Bill has been considered in the Maryland General Assembly, and that time's forever lost by not having these child protections in place. This priority legislation, co-sponsored by Vice Chair Jeff Walk-Stryker and Senator Chris West, would require that child custody evaluators have basic qualifications and receive basic training before being appointed or approved by a court to perform a custody evaluation. I know many of the members know this. Courts follow the recommendations of the custody evaluator in over 90% of custody cases. After hearing from parents, advocates, and legal child custody experts over the past 5 years, it has become clear that there is a distinct need for custody evaluators to have consistent qualifications and training before being appointed or approved to one of the most sensitive court cases. This bill is all about putting children first. 3 years ago, this committee and the Maryland General Assembly approved Senate Bill 17, sponsored by Senator Chris West, requiring training for judges and magistrates presiding over child custody cases involving child abuse and domestic violence. It only makes sense that child custody evaluators be trained along the same lines as the judges, especially given the heavy reliance of judges on the recommendations of the child custody evaluators. Now let me update the committee, since you have heard this bill before. During the interim, a bipartisan work group made up of Delegate Charlotte Crutchfield, Delegate Aaron Kaufman, Senator West, and myself, we met with Judge Dumais, representing the Maryland Judiciary, to work together on updating and strengthening Rule 9-205.3, which, as this committee knows, are the regulations the Maryland Judiciary follows regarding the appointment or approval by a court of a person to perform a child custody evaluation. We are grateful for Judge Dumais' leadership and her work to update this rule. We worked hard and we worked together in good faith. Senate Bill 25 before you today reflects the updated judiciary rule, including accepting the judiciary's amendments impacting 2 court custody evaluators. We are also working with the judiciary to include sexual abuse in the list of current knowledge and experience in dealing in the list that's in the bill, as this was an oversight that it was not included, and also amendments offered by advocates for individuals with disabilities. The Maryland Judiciary updated the Rule 9-205.3 on January 10th, and this updated rule currently is going through the Judiciary's approval process, but has not been implemented. A question has been raised in the past on whether the child custody evaluator's qualifications and training requirements should be in a rule or in a statute. The logical response is it can be and should be in both. Child protection advocates have been demanding for years that these qualifications and training requirements for child custody evaluators be put into law, just as the judge's training bill was put into law in 2022. Additionally, while Maryland recognizes that a rule, quote, shall have the force of law, end quote, without actually being law, it is unclear whether the federal government would share that recognition, and therefore any federal funding through Cadence law or other federal statutes could be in jeopardy and not available to the state of Maryland without passage of Senate Bill 25. And in this Maryland budget crisis, I think that's a key fact. Senate Bill 25 is a child protection bill, especially when you think about those 21 Maryland children who have been killed since 2008 and the thousands of other children that have been traumatized by a parent when divorce, separation, custody visitation, child support, or court involvement is a factor. Putting into statute that Maryland's child custody evaluators will be qualified and trained helps protect children in these most sensitive and potentially dangerous child custody cases involving child abuse and domestic violence. When we think about the many qualifications and training bills that this Maryland General Assembly has passed into law over the years, including those impacting animal control officers, yet we have not put this into law, dealing with our most precious responsibility and resource, our children. And I'll look at my colleagues and I'll look you in the eye. I believe we as legislators have a moral obligation to pass the Child Custody Evaluators Qualifications and Training Bill this session and ensure that it becomes law this year. It is simply long overdue. Over the course of being the lead author and sponsoring the Child Custody Evaluators and Qualifications Training Bill for the past 4 sessions, I want to also point to all the work of the proponents of this legislation over the years, working to advance this bill. I know this committee recognizes that child custody evaluators have an important role in assisting family law courts in determining custody outcomes, especially in these most sensitive, difficult, traumatized cases. I have heard testimonials from several protected parents and children who were put in danger due to an untrained, unqualified custody evaluator, some of which are included in your bill file. You will hear from Hara McLeod, whose story firmly shows why consistent qualifications and training for child custody evaluators are desperately needed. Hara McLeod is a protected parent from Montgomery County who separated from her child's father on July 17, 2011, case number Family Law 96093. The child custody evaluator assigned to her case understood that the father, Joaquin Rams, was dangerous to Hara and her son Prince, based on evidence presented by several witnesses in Rams' life who believe he routinely abused his older son and that he had already killed 2 people. Unfortunately, Rams' attorney was able to have the child custody evaluator's testimony disregarded due to the lack of training specific to the child abuse of that child custody evaluators that was not taken into account. In October of 2012, Prince was murdered by his father when he was 15 months old. In the opinion of Paul Griffin, Child Justice Legal Director, if child custody evaluators were required to have had training, Hara's case most likely would have had a different outcome, And Prince would be alive today, and I agree. Again, the purpose and essence of this bill is to protect children in vulnerable circumstances from further harm. And I want to point out that support for SB 25 continues to build. It includes support from child advocacy centers from across the state, family law attorneys from across the state, law enforcement, including the Montgomery County Sheriff's Office, which oversees the Montgomery County Family Justice Center, the state's attorneys, officers across the state and their special victims units, Greater Washington Society for Clinical Social Work, Maryland chapter of the American Academy of Pediatrics, Licensed Clinical Professional Counselors of Maryland, and the one I really want to highlight, the Coalition to Protect Maryland's Children. These are to name a few. Mr. Chair, Mr. Vice Chair, all members of the committee, I respectfully urge you, I urge the members for a swift and favorable report on Senate Bill 25. I thank you for your kind attention, and I'll ask if we can hear from our witnesses that will be appearing with virtual testimony.
Yeah, so I think our protocol is going to be, we're going to hear from Ms. Margolis, who's testifying in person. We'll then take questions, and then we'll move on to our virtual.
Her panel is one.
Good afternoon, Mr. Vice Chair, members of the committee. My name is Leslie Seid-Margolis. I'm a managing attorney and policy counsel at Disability Rights Maryland, the protection and advocacy agency for Maryland. Our mission is to protect the civil rights of people with disabilities. We are in full support of Senate Bill 25 with an amendment that specifies that child custody evaluators need training additionally in about disabilities and about how to make recommendations that are based on evidence, not based on assumptions about disability. Our written testimony has the specific language that we're proposing in an amendment. When the Americans with Disabilities Act was enacted, Congress found that people with disabilities face discrimination based on assumptions about them, what they can do, what they can't do. And Congress also found that discriminatory policies and practices affect people with disabilities in every aspect of their lives, including securing custody of their children. Back in 2014, the Maryland Commission on Child Custody Decision-Making issued a report that included a report and recommendations from the Disability Bias and Neutral Language Subcommittee. That subcommittee found a long history of discrimination against parents with disabilities in the custody determination process or custody recommendation process, based again on assumptions about what people could and couldn't do because of their disabilities. These recommendations were never fully implemented, and so our proposed amendment takes those training suggestions and proposes them as an amendment. Specifically, we are asking that evaluators be trained in neutrality, in the supports and services that are available to parents and children with disabilities, including accommodations based on disability, and that evaluators be trained in how to make decisions or recommendations based on evidence, not based on assumptions. So with that amendment, we fully support the bill. Thank you very much.
Thank you. I misspoke earlier, and I apologize, Senator. We're going to take Ms. McLeod virtually as part of your panel, and then we'll take questions after that, if that's okay, Senator Henson. Ms. McLeod, you're up.
Great, thanks. Good afternoon. My name is Hera McLeod. I'll spare you all the gruesome details of my son Prince's case. It's highly Googleable, and thank you, Senator Carozza, for providing the case summary. I'm here to testify in favor of this bill again. It should be common sense to ensure that the experts these judges are relying on for a professional opinion are actually required to be educated in the opinion they're being asked to render. And yet, sometimes the judges don't follow the rules, and sometimes they change the rules. We have evidence of this in Maryland. And the only way to stop them from doing it again and again is to put these protections in statute. Our children deserve to be protected, and for those protections to exist in statute. Because while I'm thankful that after several years of us requesting that Maryland judges stop waiving the standards that we all seem to agree upon, they're finally going through the process of removing that language from the rules. Pardon my skepticism, but simply put, removing the clause from the rules that could be added back tomorrow without a public vote doesn't ensure these protections persist. There's nothing I'm going to say today that's going to change your mind on whether or not you're for or against this bill. So instead, I'm simply begging you to push this forward to a vote. Push for the ability to publicly stand behind your view on this issue. Walk down the hall, across the street, or perhaps just turn around in the cigar bar and ask your friends over in the House to also push to vote for this bill. As an advocate for the protection of children for over a decade, I've witnessed many states across the nation contemplating similar legislation. Years ago, I testified for the judge's bill that required our judges to be trained in a similar manner that we're suggesting here today. That bill passed unanimously, and Maryland was seen as a state that was leading the charge to protect our nation's children. But we've stalled in our ability to make progress. Do we want to lead from the front or follow from behind? What will it take for us to simply make a public decision on the issue impacting the lives of so many children? Another year, another 10 years, because while we wait, more kids are dying. Thank you.
Thank you for your testimony here today. Questions for the sponsor or this panel? Senator Henson.
Thank you to the bill sponsor for what sounds like an incredible amount of work that was done during the interim and over multi-years of effort to bring some resolution here. You had a fair amount of unfavorable testimony that was submitted, written testimony. The judiciary, I understand, they want to self-govern. They'd rather not have the legislature tell them what to do, which we can have opinions on the propriety of that. You also have the Office of the Public Defender, which had some specifics that they wanted different in the bill. But the testimony I couldn't understand, I couldn't reconcile, was the Maryland Network Against Domestic Violence and then the House of Ruth. They came in unfavorable on the bill, and it sounds like what they were saying is that they'd rather have it exist in the rules as opposed to the code. Now, as a practitioner, when I have a pro se litigant on the other side, a table across from me, more typically, the code is more accessible to people. The code is labeled family law. You go looking there for the family laws, and if you're putting on your own case, you measure your standards, you figure out what to do based on what the code says. In my experience, the rules are a little bit more amorphous. The rules, the court rules, you don't necessarily know where to go looking for something in the court rules. It doesn't stand out as much as the code. So could you give me any insight on why these two really respected organizations favored, with this testimony, not having that be in the code?
Thank you for the question, and I really do believe, as I testified, the issue has come down to whether it's in the rule or in the statute. And as I said, it should be in both. By putting it in statute, then we will know that there are basic qualifications, basic training requirements that will be in law. We are not dictating to the judiciary how they do their training. We want to ensure, though, that it's in statute, that there will be qualifications and training. In response to your question about the one organization, I believe their resistance in the past has been based on the same issue, whether it should be in statute or in law. So that's where we are today. I have to say what's significant and why I'm encouraged this year that this will be the year is that this is the year, in this interim, we worked very hard to get to the point where the judiciary was committed to updating its rule, and your colleague Senator West was part of that work group, a bipartisan work group with Judge Dumais, and we worked through that. I was very clear. I had a lot of pressure on me to add additional protections or specifics on training to this bill, and I let Judge Dumais know that that's not where we were going with the bill, that we wanted the bill to reflect the judiciary's rule, and it does that. We've accepted the judiciary's amendments to grandfather the two court-appointed evaluators. I know we're working through we're working through the disabilities amendment that's been raised as well, and then just that one other change. So we are mirroring the judiciary's rule, but it needs to be in statute.
Thank you for your response. Thank you, Mr. Chair.
Thank you. Any further questions for this panel? All right, seeing no questions, we'll then move to further virtual testimony. Next on the list is Annie Kenny. Ms. Kenny, unmute yourself and go ahead. Ms. Kenny, we are ready for your testimony. Can you hear us, Ms. Kenny? Give us a thumbs up if you can. All right. I don't see you muted. If you can say a few words here.
Yes, I'm Annie Kenny. Can you hear me?
We can now. Please go ahead.
Okay. So, thank you. My name is Annie Kenny, and I am a protective parent of 3 daughters from St. Mary's County. Several years ago, I discovered that my now ex-husband was abusing our oldest daughter. He was indicted on felony child sex abuse charges and is now a Tier 3 registered sex offender for life. It took 7 months in criminal court for my children's father to be convicted. It took 4 years in family court for me to get a no contact order in place, protecting my children from him. I stopped having to communicate with and expose my children to my ex-husband in the spring of 2021, but not because a team of properly trained professionals recognized the trauma my children were being exposed to and opted to protect them. Our freedom came at the cost of other children, as my ex-husband has now been convicted of sexually abusing other non-familial children and is currently serving his prison sentence. I'm terrified of what will happen when he's released and starts his mission of accessing my daughters again. And I'm angered by the prolonged suffering experienced by my daughters. It's important to understand that the father of my children was already convicted and a registered sex offender before I ever stepped foot in family court. Our case involved complex issues of child sexual abuse, grooming, signs of childhood trauma, and the long-term effects of trauma on children, just to name a few. But not a single individual in the courtroom during our numerous hearings was trained on any of these topics. It wasn't until our 4th court appearance that the term abuse was even used, and to this day, the term sexual abuse has never been spoken in the family courtroom. My middle daughter, Nora, has suffered significant trauma, of which there is no official cure. She's endured numerous hospitalizations, missed out on major milestones and events with her peers, and continues to try to work her way out from under the weight of her father's crimes and the family court system's desire to preserve his parental rights to her. Having family court professionals who are properly trained on the significant topics related to abuse and child development would greatly reduce the ongoing trauma that many families are subjected to as they spend years stuck in family court. There's no clear path to undoing childhood trauma. Research shows that childhood trauma increases risks of mental illness, substance abuse, suicide, and even shortens lifespans. Resistance to properly trained family court professionals is concerning and certainly not aligned with the best interest of children. Please prioritize child safety at all costs. My daughter Nora is actually also testifying this year. Thank you for your time.
Thank you very much, Ms. Kenny, and we'll hear from Nora next. Are we ready?
Hi, my name is Nora Kenny, and I'm 15 years old. When I was around 8 years old, my family fell apart because my dad was arrested for abusing my older sister. My younger sister and I spent another year after that visiting him at my grandmother's house on certain days. However, my grandma didn't follow the given rules and allowed me and my sister to have unsupervised time with my father and even allowed us to sleep in the same room. The following year, me and my sister spent one evening a week at Burger King with my dad, but this time it was supervised by a nice lady. When I was 10, I told my mom I did not want to keep doing that and then I was finally free. I now know my mom spent 2 years after that battling in family court to keep me and my younger sister safe. That was until my dad was arrested for abusing other children. The court system did not protect me, my mom did. The person who knows how to deal with me best is my mom, and if she is not given that responsibility to make decisions about my life, I want that person who is given that job to be trained specifically on these types of situations. I want them to be trained on how children's and teenagers' brains develop, the facts about child abuse, signs of trauma and behaviors, and the long-term effects of childhood trauma. It makes me so mad to even think about the fact that the adults that could have been deciding my entire childhood have no idea how I feel, function, and what I do to heal and feel safe. I hate when people talk about what's fair to my mom, what's fair to my dad. What should matter in these situations like mine is what's fair to me. My childhood is made from so many small and large decisions. It feels insulting to know a complete stranger could be the one making one of those life decisions instead of someone close to me. But what makes me even more angry is that the person that is given the job to make my childhood decisions isn't trained on child development, child abuse, trauma, and other important topics. I hope I will be aged out of the family court system by the time my dad gets out of jail, but my younger sister will not be 18 before he is out. I'm scared for what could happen when my mom goes back to family court. The long-term effects of trauma, which happens when these decisions are made incorrectly before judgment, are so incredibly horrific. I have been hospitalized multiple times since everything happened with my dad, and I have struggled with mental illnesses such as anxiety and PTSD as well.
Excellent. Thank you very much for your testimony. We're going to move on to, is Tina here? Is Tina still on? Tina, we're going to go next. Before you start, I just want to say for Annie and for Nora, thank you. Look, this only works if, folks are willing to take time out of their day to share some of their stories, no matter how difficult they are. And obviously, we really do appreciate you all having the courage to testify. And so thank you for taking the time and for sharing your story. Tina, you're up.
My name is Tina Swithin, and for over a decade, my organization has supported child safety legislation across the country. And SB 25 is a very important bill for Maryland. Custody evaluators wield incredible influence over children's lives, and they strongly influence judicial decisions. Yet their training, licensing, and expertise varies widely and often falls short, leading to inconsistent and dangerous outcomes. Every single week, I hear stories of horrific abuse and children being murdered in preventable tragedies all across our country. And it's fundamental that anyone making decisions that impacts a child's life has training in domestic violence, child neglect, abuse, and trauma. This is common sense, and we need to raise the bar when it comes to the safety of our children. And you're likely going to hear opposition advocating for the inclusion of parental alienation, a pseudo-scientific concept rejected by major medical organizations. And in 2023, the UN Special Rapporteur urged a global ban on parental alienation, which is a legal strategy in family courts, exposing it as a pseudoscience used by abusers to discredit mothers' domestic violence claims. And the only people opposing child-centric legislation are those who are financially benefiting from the status quo or those exploiting systemic flaws for personal gain. This bill will strengthen Maryland's family court system, and I urge your support. Thank you.
Excellent. Thank you very much. Have we heard from everyone on this panel yet? All right, questions from the committee. Mr. Aikenbaum, did we hear from you yet?
No.
Oh, you're up next. All right, welcome.
Okay, just 1 second. Yes. Thank you, Mr. Chairman, members of the committee. My name is Jakob Aikenbaum, and I represent the Maryland chapter of Parental Alienation Intervention. We urge the committee to amend this bill by explicitly including training on parent-child contact problems. This will address the two concerns that are detailed in our written testimony and will ensure that the custody evaluators are prepared to navigate the full spectrum of issues. I'm going to deviate from what I had planned to say in order to address the accusations that were just made at this hearing about parental alienation. Fringe elements of the domestic violence community have unfortunately engaged in a public policy deception campaign against alienation. Ms. Swithin and her partner, Ms. Pollack, co-founded the National Safety Parents Organization to promote the passage of Caden's Law in all 50 states. Its website openly declares that a major focus of this law is to exclude alienation from the family court system. This science denial campaign contains research fraud, ad hominem attacks, misinformation, and more. It is harming innumerable children and families, and the legislation they propose will halt any hope that alienated children have of being safe from emotional harm. It is for this reason that the Department of Justice and Congress are currently investigating the research fraud that Caden's Law is based upon, a cover-up by the National Institute of Justice and George Washington University, and much more. Although advocates claim that alienation is pseudoscience and not recognized by professional organizations, the position of the DSM-5, the AFCC, the National Council of Juvenile and Family Courts, and more all recognize it as a serious form of psychological abuse. It's absolutely shameful that after last year's hearing, Ms. Swithin actually posted my picture on her Facebook page, a picture of this hearing, accusing me of being part of the, quote, alienation industry. It's time to stop this science denial campaign by acknowledging parent-child content problems in this bill. Thank you for your time and consideration of this critical amendment, and I'm happy to answer any questions you may have.
Excellent. Thank you very much. We'll hear from one more witness, and then we'll open it up for questions from the committee. So is this Lori, or it says Melanie? Melissa, sorry, Melissa. Melissa, I think you're on mute. Come off mute, and you're up next.
Hi there. Thank you. My name is Melissa Kropchak. I am from Jarrettsville, Maryland, and I am testifying favorable with the amendments. I do want to thank Senator Carozza. I know this has been a tireless and very long and frustrating process to get this bill through, and I commend that. I commend her work to try to protect all of Maryland's children. My concerns with the bill, as are mirror Rabbi Eichenbaum's testimony, that we want parent-child contact problems added. This is not just we want alienation recognized. We want both sides of the bill to be understood. Moreover, this is already in the Maryland guidelines under BIA and custody evaluator training. Asks for evaluators who comply with the American Psychological Association and the AFCC guidelines, both of which recognize parent-child contact problems as something that needs to be addressed by the evaluators. Moreover, Maryland's own custody and visitation-related assessments training guidelines states on page 2 that parent-child contact failure needs to be considered as part of the evaluation. Finally, I hold that just because people hold Maryland licensure does not mean that they understand these very difficult and complex family dynamics, including oral child abuse, domestic violence, and warranted and unwarranted rejection of the parent by a child. So I urge the amendment of adding parent-child contact problems, and I thank you for your time.
All right, thank you very much. Questions from the committee? All right, seeing none, that'll conclude the hearing for Senate Bill 25. Senator Carozza, thank you very much.
Thank you.
All right, we'll now move on to Senator Love, with Senate Bill 347.
Thank you, Mr. Chairman. Good afternoon, colleagues. It is my honor to be here to present my first bill in front of you as a member of the Judicial Proceedings Committee. Thank you, thank you. Very excited. Well, I guess that means my bill passes. I'm done. For the record, I am Sarah Love, Senator from District 16, here to present SB 347, Adult Protective Services, Investigation and Disclosure of Information. So this bill has to do with local departments of social services investigating cases against victimized adults. So vulnerable adults. And the law right now sets out the procedures when these departments are investigating these cases and who these departments can talk to. And specifically, the local department may work with and share information with the local state's attorney or a local appropriate law enforcement agency or the local department on, the local department on aging or Department of Aging and several other departments in that field. What it does not include is that the local department may request the assistance of federal agencies, federal law enforcement. So let me give you an example. If our local department is investigating mail fraud against a vulnerable adult, they may not request the assistance of the postal inspector. That doesn't make sense. So that is what this bill is seeking, that is the loophole that this bill is seeking to close. Just one quick footnote, we heard SB 205, which was a departmental bill. I have spoken with counsel, I have spoken with the department. These bills work hand in hand, they are not cross purposes. The department said you can pass ours with your language, you can pass yours with our language, so they do work together. With that, I'll turn it over to the experts at the table. Thank you.
For your maiden voyage, we always do this. So every senator looks like all the lights are up, all the lights are on. So we're going to do rapid fire questions with the senator here. No.
I even have my own question.
Come on, Sandy. All right. No, thank you very much, Senator. We'll hear from the panel, then we'll save questions for this.
Good afternoon, everyone. Chair Senator Smith and Co-Chair Senator Wald-Stryker and committee members, thank you for this time to discuss Senate Bill 347. My name is Mario Warzusin. I'm the Senior Administrator for Adult Services, Adult Protective Services with the Montgomery County Department of Health and Human Services. I'm also a clinical social worker. I've been in this field for over 30 years. Adult Protective Services in Montgomery County investigates hundreds of cases, and in the state of Maryland, there's over 7,000 investigations by Adult Protective Services of abuse, neglect, and financial exploitation. This bill would strengthen the ability of Adult Protective Services, I'm going to call it APS because I only have 2 minutes. It would seek to work with our federal partners so that we can enhance our partnerships and have the dialogue that's going to help the collaboration. Now, in Montgomery County, we have a terrific Elder Vulnerable Adult Abuse Task Force, multidisciplinary task force. You'll hear from Chair Debbie Feinstein shortly. And this is great, but when these type of crimes, these financial crimes, go beyond our jurisdiction, beyond state line, and even national lines, we'd like to have a strong partnership with our federal law enforcement as well. This is of utmost import as the Consumer Financial Protection Bureau, the Department of Treasury, and the Financial Crimes Enforcement Network all describe financial exploitation as one of the most common form of elder abuse in the United States. It takes a lot of money out of our clients' pockets. With financial exploitation widespread with older adults, such crimes cause immense harm to our victims and can also be deadly. Adding tools to the APS toolbox through enhanced partnerships with federal law enforcement would strengthen the ability of Adult Protective Services to share information, work in collaboration, and ultimately enhance investigations that often run into barriers when financial crimes are across state lines and even national boundaries. So with that, I request that you give a favorable report to Senate Bill 347. Thank you.
Thank you, Senator Smith and Senator Wald-Stryker, for allowing me to testify today. Thank you to the committee. My name is Amy Thomas, and I'm here on behalf of Montgomery County, Maryland, where I serve as an Adult Protective Services investigator with a specialty in financial exploitation, and I'm here to testify in support of Senate Bill 347. It would benefit Adult Protective Services to be able to share information with federal entities in general and the U.S. Postal Inspection Service in specific, because an important aspect of financial exploitation of seniors and vulnerable adults is that it can happen through the mail. I've had clients receive stolen properties, such as cell phones and laptops, and then they're directed by a scammer to send it on to people who are often victims in an elaborate shell game where the property is moved quickly so that the perpetrators avoid getting caught for the original theft. I've also had clients send checks and cash money through the mail. To give another example of how the mail is used to perpetrate crime, one of my clients responded to several fraudulent letters, which made it seem as though funds that she had provided to a scammer were facilitating the release of $4.5 million from a bank in Africa. Her husband was unable to stop her from giving away money, and she gave away an estimated $130,000. As with the vast majority of cases, none of that money could be recovered. The FBI has reported that scams targeting individuals aged 60 or older caused $3.4 billion in losses in 2023 alone. The state's attorney's office of Montgomery County does not have the resources to prosecute the great majority of scamming cases. The United States Postal Inspection Service would be an additional avenue for prosecution of these criminals who are responsible for causing so much damage. When recovery of assets is possible, it can make a vast difference in the lives of individuals. My client and her husband now have fewer choices about where and how they receive care at the end of their life. Because of this, I urge you to consider passing this bill.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, members of the committee. My name is Debbie Feinstein. I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office, and I am the Chair of the Montgomery County Elder Vulnerable Adult Abuse Task Force. It's a little bit of a mouthful. But what EVAT, which is our acronym for it, does is it brings together members of my office, the State's Attorney's Office, the Police Department, Health and Human Services, Adult Protective Services, the County Attorney's Office, to discuss cases and to be able to collaborate about best solutions for situations where older and vulnerable adults are victimized. And we're able to do that because of the way the law is structured with respect to information sharing between our agencies. That doesn't exist for cases where the federal government needs to be involved. And I'm definitely in favor of fuller collaboration, and there are certainly crimes that the federal government can pursue that my office cannot, just the way the law is structured. So I think that this is a benefit at the end of the day to vulnerable people in our community, to seniors, to vulnerable adults, and this is kind of a win-win because it just offers more transparency and more collaboration. I would urge a favorable report of Senate Bill 347. Thank you.
All right, thank you, Ms. Feinstein. Questions from the committee? All right, there you go. Excellent. Cold bench. Is Tammy here? Ranishan? Welcome. Good to see you.
It's good to see all of you. Thank you for allowing me to testify. My name is Tammy Bresnahan. I am the Senior Director of Advocacy for AARP Maryland, and we wholeheartedly support Senate Bill 347. As some of you may know, but not all of you, I did spend over 30 years at the Department of Social Services working in a variety of positions from the 80s until the mid-2000s. Protecting vulnerable adults is not merely a legal obligation, it's a moral imperative. Many adults who fall under the protection of Adult Protective Services lack the capacity or the resources to safeguard themselves from harm. We applaud Senator Love for bringing this bill. We also applaud the Department of Social Services in Montgomery County for testifying in support and hope the state supports it as well. The bill demonstrates a proactive approach to addressing abuse and neglect and sending a clear message that we are unified in our efforts to hold perpetrators accountable while prioritizing the safety of those at risk. We respectfully urge you to have a favorable report on Senate Bill 347. The legislation provides vital tools to enhance the protection of vulnerable adults. Thank you.
All right, thank you very much. Questions from the committee? All right, seeing none, thank you very much. With that, that'll end the hearing for Senate Bill 347. We're going to skip over Senator Sidman right now because he's got a lengthy witness list. We're going to go to Senator West, who is sponsor only, with Senate Bill 338.
Thank you, Mr. Chair. It's a pleasure to be here to present Senate Bill 338. It'll probably be the shortest hearing in the afternoon in that I'm the only one signed up to speak. So you've heard this bill before. This bill I brought last year, and this committee unanimously supported the bill, and it went to the floor, and it overwhelmingly passed on the floor. It just died over in the House because we didn't get it over there till crossover, and they didn't take it up until too late. It is a Baltimore County bill. The Baltimore County delegation of state senators met yesterday, and there are only 7 current state senators. One was absent of the 7. All 6 of us who were there supported the bill, and so it will be a delegation bill. The delegation letter will come as soon as I get the amendments that I'll talk about in a couple of minutes drafted and to the delegation so that they can pass the bill, send the letter over at the same time as they approve the amendments. So the bill came about when I realized that I'm driving along the Beltway too many times, and when I drive, I look in the front of the car. I do not look in the rear view mirror too often, unless I'm going to make a change of lanes, and cars were literally rocketing past me. And I'm not talking about speeding, I'm talking about really speeding, 80, 90, 100 miles an hour. It was scary. It's every time it's happened, and it's happened all too frequently, it's been scary. And I tend to jam on my brakes when that happens for fear that they're going to have an accident just up ahead and I'm going to run into the accident unless I slow down. And my jamming on the brakes, in turn, is dangerous. So there are double whammies of danger on the highway when it happens. A couple of years ago, we passed a bill to provide for a speeding camera on the Jones Falls Expressway. And I'm the first to admit I voted against it. I thought it was a cash grab. The city was trying to get money from mostly my constituents because my constituents live right at the end of the Jones Falls Expressway in Baltimore County. That's not at all what's happened. It has had its intended effect. It slowed traffic down on the Jones Falls Expressway. And because the traffic has slowed down, the city hasn't collected much money from the speed camera in the city. So I got the idea from that we should do the same thing on the Baltimore Beltway. And this is only the Baltimore County portion of the Beltway, by the way. The Beltway does go into Anne Arundel County on the southwest. That would not be covered by this bill. So that's why this is a Baltimore County bill. And it would allow 4 speed cameras in each direction to be erected on the entire length of the Beltway, from when the Beltway crosses over the Patapsco River on the southwest, all the way around to where it ends over in Essex and Dundalk. It would, the bill would say that the speed cameras would only operate and would only give tickets when you travel more than 12 miles an hour over the posted speed, which for most of the Beltway is 55 miles an hour. So, as I say, the bill was very popular last year. This year, there have been a couple of changes. During the summer, I got a number of emails from constituents who live up in Hereford, the Hereford zone in the northern part of Baltimore County, and told me that they never travel on I-83 north between the Beltway and the Pennsylvania line because it's too dangerous. There are cars rocketing along that road, and they say they're so scared that they take York Road, even though it's twisty and turny and slow and lots of traffic lights, if they want to get down to Towson, because they think I-83 North is too dangerous. And so I decided to add I-83 North to this bill. It's also entirely within Baltimore County. For that, again, the permitted speed over the speed limit before you get a ticket would be 12 miles an hour. In that case, there would be 3 permitted cameras going each direction on the entire stretch of I-83 North between the Beltway and the Pennsylvania line. Now, let me talk about the amendments to the bill. So the first amendment is, as originally drafted, it permitted people to drive 16 miles an hour over the speed limit on the Beltway, unlike last year when it was 12. My cross-file sponsor, Delegate Stein, took exception to that, and so I deferred to his better judgment, and so the amendment will take this bill back to 12 miles an hour over the speed limit on the Beltway. Well, last year it was 12 miles an hour over the summer. I thought maybe we should make it 16 miles an hour over, which would permit cars to go up to 71 miles an hour. Delegate Stein said no, he really thought we should stick at 12. So I'm amending the bill to take it back to 12. Secondly, the cost in the bill as drafted by the drafters only provides the money to be raised can be used to maintain the road. Because of the, for one reason, because of the fiscal note, I decided that it made sense to allow the cost to be used to defer the cost of running the speed camera program and to maintain the road, but to pay for the program cost first. So it would reduce the fiscal note. And then finally, there are 2 other changes. I had a conversation with the State Highway Administration. They indicated that they thought it would be better to only have the State Highway Administration identify the locations for the cameras and take out the Maryland State Police and the Baltimore County Police Department, and I'm doing that in an amendment. And then the last amendment is something I didn't even realize was in the bill last year, but it was, and it provides that the speed camera must be operated physically by a policeman sitting in a car. And there's no reason to do that, and I believe that's largely attributable to the large fiscal note. So my amendment will eliminate the requirement of a live human being to be sitting next to the speed camera while the speed camera is operating. So with that, let me turn quickly to the fiscal note. First of all, I've indicated that the amendment's going to provide the money to be collected will cover the cost of the program. Secondly, it's going to eliminate the requirement of live human beings to be sitting in the cars next to the speed cameras. And finally, it's going to change it's not going to change. I just want to emphasize the fact that the bill uses the word may. It is an enabling bill. This is not a requiring bill. So that if the Department of Transportation does not have enough money in this next fiscal year to install these speed cameras, there's nothing in this bill that requires them to do it. They can wait until they do have the money and then can, at their leisure, to install up to 4 speed cameras each direction on the Baltimore County portion of the Beltway. I believe that should take care of all the concerns about the fiscal note in the bill. And with that, I would request the committee to give the bill a favorable vote, and we'll be happy to take the several questions which I see awaiting me. Thank you.
Sometimes brevity is the, anyways, all right, Senator Folden.
Yeah. He kept running it.
I did.
He kept talking.
I knew. I see you kept going. I was like, that's gonna happen. That's gonna happen. That's gonna happen.
So thank you for bringing this very important piece of legislation forward, Senator. So I think everybody kind of knows where I land on.
You voted on it last year.
Yeah, not in this format, because you've changed it. You've made changes. You just talked about the changes you made.
Yeah, okay. You're right.
Yeah,
You're
okay.
right. No, there were a few changes.
So I'm just, are you familiar or have you looked at, so I just learned something really fascinating. And that is that these vendors that set up these speed camera programs get paid on every citation, whether the state actually recoups the funds or not. So for example, and I'll put this out there for an upcoming bill we're going to discuss. I don't know, you have tags issued to another, or tags that aren't valid, or tags out of state that aren't issued to that vehicle. Because it doesn't come back to the proper person, the vendor still gets paid, but the state does not. Did you know that?
I didn't, but I suspect it's determined by whatever contract the State Highway Administration executes with the vendor.
Oh, well, State Highway's here somewhere, I think. Could they come up and answer that?
I'm not sure.
Yeah, I thought I saw State Highway here somewhere.
I'm not aware of the particulars of the contract the State Highway Administration signs with the vendors, but there's no reason that they can't refuse to enter into that kind of a contract.
Well, that's what I would have thought, but I just wanted to check. And then the other concern I had is, why is, another change you made was like not a live person there, obviously. This isn't a construction zone.
Why do that? The Jones Falls Expressway camera doesn't have a live person.
I understand, but it's a different format than last year. Like, this isn't a construction zone. This is purely a speed camera.
Well, I frankly think if I had known that last year's bill required a live person, I would have changed it last year.
Okay.
I don't think we need a live person. The speed camera can do its own job. Nobody has to sit there and monitor the speed camera.
Okay. Is SHA up there?
She's here, yeah. If she's willing to step up.
Oh, there you are.
Come on up.
Do you know offhand, I'm sorry to call you up like that.
It's okay.
I just happened to see you there, so.
No problem.
Do you know offhand if that's the language of
Unfortunately, I do not.
Okay.
So that definitely is something that I can reach to my team and get that information for you quickly.
I'm sorry, I guess you're supposed to introduce yourself too, I'm sorry.
Hello, everyone. I'm April King, Acting Director for Government Affairs for State Highway Administration.
Thank you for coming up, Ms. King.
You're very welcome.
So.
Happy to be here.
And was it your all's or the senators to decide the locations? Like, is that one over the state police?
It's always in the bill. Certainly was not my decision. I left it up to the State Highway Administration, but the bill provided that it would be, I guess, a joint decision between the State Highway Administration, the State Police, and Baltimore County. And my conversation with State Highway Administration said, just let us do it. We don't need the State Police or Baltimore County to be involved. And so that's why I'm amending the bill.
Okay, thank you. I wish you'd kept the brevity at like, this is what unanimous last year. Thank you.
Yeah. Sorry.
I can respond to that.
Yeah, go ahead.
So in our discussion with Senator West, that he did mention when he discussed it with MSP and the county and so on, they actually referred back to the State Highway Administration. We mentioned about we could make that decision based on our data that we have. So instead of having 4 hands in the pot, we could just use our data.
Yeah, that's excellent. Thank you.
You're very welcome.
Yeah, I think it makes the bill better. Sorry.
Thank you, Mr. Chair. Thank you, Senator. Couple of questions. Sure. First, I'm sorry, at some point, I'm sure I will stop referring back to last year and the bills, but in my role as chair of the Motor Vehicle Subcommittee, we had tons and tons of speed camera bills every year. And we had specific criteria, one of which was that when somebody was seeking to place a speed camera, they would come forward and explain why. What problem are you trying to solve here? And one of the things that we asked for was specific crash data.
I've got that here. I've got it here. If you'd like it, I'll make a copy and give it to you, but I can quickly summarize it. This is.
That actually was. Thank you, Mr. Chair. Yep, thank you.
Yeah, so this shows I-695, which is the Baltimore Beltway, and I-83, which is the north segment up to the Pennsylvania line, crash reports for the years between 2018 and 2024. It shows overall there were 20,506 crashes during that period. 6,697 of them were attributable to speeding. 94 fatalities occurred. And there were 27, I'm not sure what this means, crashes by segment, speeding and fatal. So I guess fatalities along with the speeding offense in the same instance.
Great.
That's a lot of crashes.
That is a lot of crashes. And so my next question following up to that is, it seems as I read this that SHA can put them sort of wherever they want to.
Yes.
And one of the things that we were very specific about was making sure that the cameras were placed at the hot spots, that the cameras were targeted towards the behavior in those specific spaces. So you and I can follow up offline about that piece, but that's a really important component, I think, of where you place speed cameras, that you're making sure that that you're making sure that you're targeting the place where the behavior is the most dangerous.
Yes.
So if we can follow up with that offline.
If you think we should do an amendment to that effect, I'm happy to do it, but I'm confident that's what the State Highway Administration is going to do. They wouldn't put cameras where there are no crashes and there's not a problem. I'm sure they will choose the most accident-prone places to put the cameras.
Great. And Mr. Chair, if I may. So my second line of questioning is something that I asked you last year, and that is, right now, there are no statewide standards regarding the use of, the access to, or the retention of any of this data. Would you be amenable to having such standards in your legislation? Yes, I do have my own bill that's coming up. But in the case that doesn't get through, would you be amenable to having that in yours?
Let's talk. I haven't read your bill. Let me take a look at your bill. So if a citation is sent out, then that's, I think, a matter of public record.
I'm talking about the data right now.
What kind of data?
The data that's captured by the
photographic data of cars going past?
There's absolutely no limitations on who can access that data and what that data can be used for.
Okay, let's talk. I'm happy to talk to you about the problem and how we might try to solve the problem.
Great, thank you.
Yeah, sure. Any more?
Excellent. Further questions from the committee? All right, thank you very much, Senator West. All right, with that, we're going to start the hearing. So that'll end the hearing for Senate Bill 338. We'll now go on to the last bill today, Senator Sidnor with Senate Bill 292.
Hey. I guess if I start talking. How you doing? All right. The officer here?
He had a conflict, he had to leave, but he did provide written testimony.
Okay. All right, Senator Sidnor here for Senate Bill 292. Before I get into some of my written testimony, I wanted to make certain that I thanked Harford County's sheriff for highlighting this bill in his video, which has caused a number of us to get a whole lot of emails, and for my office and me to be called all sorts of things except for a child of God. So, but you know, it's all good. So, in 2019, some of you may have read a story in an op-ed that I wrote about me and my entire family being pulled over during a vacation we were in Virginia. And as the officer's lights flashed and I pulled over to the shoulder with my wife and 3 girls, my children had asked, "Why did he stop you? What did you do wrong? Are you going to jail?" The entire family shared my anxiety as I rolled down the window. I couldn't help but think about a number of people who were shot and killed during traffic stops. One name that came to mind then was Philando Castile. And like I said, the countless of others who did not survive routine traffic stops. I've been pulled over before, and it is certainly very stressful. But good officers can usually put a driver at ease with clear communication and respect. In fact, a number of years ago, I was stopped by one of our Maryland State police officers, and I was in a rental car and didn't realize that certain lights weren't working in the back, but he did what an officer was supposed to do, and he shared everything that he needed to share with me and kept me at ease. But this particular officer was harsh, he was condescending, and I felt as though he was attempting to emasculate me in front of my wife and girls. And it was for what? Driving too slow in the left lane. I explained to the officer that I saw a speed limit sign that said 45, but he rudely told me that that was only when the lights were flashing. This distressing experience left a mark on me. Not only did this unnecessary interaction have no public safety purpose, but it made my entire family feel unsafe. That same year, after receiving a tip from a concerned citizen regarding traffic disparities in Baltimore County, I set out to uncover the traffic stop data within my county. After some effort, the data was made available, and it was stark. The data showed that black drivers were 73% more likely to be stopped by Baltimore County police than white drivers. Black drivers made up 56.25% of the traffic stops in 2018, while making up just 26.1% of the population. It was this revelation that led to the creation of, in my service on the Baltimore County's Equitable Policing Work Group in 2020. Our work group was organized to analyze available traffic stop data in Baltimore County and to make recommendations on policies and practices on how to ensure equitable policing and to bring greater transparency and accountability to the department. In the work group's 2023 Traffic Stop Deep Dive report, Baltimore County's Police Chief Robert McCullough has recognized that through the implementation of training programs, including implicit bias, fair and impartial policing, active bystandership for law enforcement, de-escalation, and mindfulness, he felt progress was being made. Now, these programs may have had an effect in conjunction with some public scrutiny, considering that bias could be inferred in data between 2017 and 2019, but could not be inferred between 2020 and 2022 after their implementation. However, the disparities after traffic stops occur continues to persist. And I can be almost certain that Baltimore County is not on an island to itself. One only has to think back to the 1990s and the early 2000s when the ACLU sued the state of Maryland and its Maryland State Police Department for what was then coined driving while black. So this report, this Baltimore County report, stated that black drivers are far more likely to have their person or vehicle searched for probable cause during a traffic stop. Even these stops are less likely to find contraband for black drivers compared to white drivers. It also stated that we also found that Hispanic drivers are issued citations at a higher rate than both black and white drivers. Now, while I can appreciate our chief's efforts, and I believe that he and his police force are likely the rule rather than the exception, it are these disparities that spurred me to seek and introduce a legislative remedy. Today, I'm here to testify in support of Senate Bill 292, which would change the characterization of certain low-level traffic infractions from primary offenses to secondary offenses. Now, primary violations allow an officer to initiate traffic stops. Most traffic violations, such as speeding, disobeying a traffic signal, running a red light, for example, or tailgating, are considered primary violations. It can be extremely dangerous, and officers should be involved in dealing with drivers who are engaged in this type of activity. Secondary violations, in contrast, are not as serious as those particular violations and can only be investigated after a stop for a primary offense. An example of a secondary violation includes items hanging from a rearview mirror. Senate Bill 292 does a few things to ensure traffic stops are safer for all, both law enforcement as well as those in the vehicles. First, Senate Bill 292 adds what we've called non-safety related infractions to the list of secondary violations in Maryland. So under Senate Bill 292, the following types of violations would be recategorized as secondary rather than primary offenses. And they include the obstruction of vehicle registration plates in any manner, driving without functioning headlight, brake lights or tail lights, driving without a mirror with obstructed or damaged mirrors, window tint, failure to illuminate a license plate, driving in dedicated bus-only lanes, excessive noise, failure to signal a turn, as well as littering. And why were these all included? For a variety of reasons. And I will say that in working with the Office of Public Defender, when they had initially asked for my sponsorship on this legislation, and they can tell you I asked them to make certain that they talked with people, because these offenses, although not reckless driving and the like, there's still things that can cause issues when it comes to driving. And so we looked at different things that could take the officer out of this and to use technology. So when you're talking about these registration plates and driving without the functioning headlights and those types of things, we just heard a bill with just earlier with technology with regards to speed light cameras and the like license plate readers that are in abundance throughout this state, technology that can be modified to do what people do today. So really, this bill and this bill kicks off a conversation about I would say, a reimagining of how we deal with traffic offenses on the highways. Second, this legislation also limits the incentives that lead to pretextual traffic stops by implementing an exclusionary rule that applies to evidence obtained in violation of this proposed law. In other words, prosecutors would no longer be permitted to use any evidence in a criminal proceeding that was obtained during a traffic stop that was initiated based on a minor traffic infraction identified in this bill. By shifting police traffic enforcement from making these types of stops to focusing on dangerous driving, jurisdictions can promote road safety and overall public safety while advancing community trust in police. The resources, time, and energy that go into traffic stops for these non-safety reasons present a significant opportunity cost. It's far more important for the safety of our roads for our officers engaged in traffic enforcement to be focusing on dangerous behavior that can be life-threatening, such as reckless driving, excessive speeding, running red lights, and driving while under the influence and tailgating. Furthermore, when an officer pulls over a vehicle on a roadway or highway, they are placed at risk by vehicles traveling at high speeds that are passing by, especially when their vision is obstructed by inclement weather or lack of daylight. Earlier this month, 2 Baltimore City police officers were hospitalized after being struck by a passing vehicle while attempting to conduct a traffic stop in the early morning. In 2021, when the Maryland Chiefs of Police Association and the Maryland Sheriff's Association opposed legislation that I introduced called the Know Your Rights Act, they testified that traffic stops are the most inherently dangerous activities in which police officers are involved. But they can also be inherently dangerous for everyone else, especially black motorists. So again, why don't we reimagine how we go about the state's business of keeping our highways safe? Finally, the legislation would require officers to disclose the reason for a traffic stop before engaging the driver in questioning related to the criminal investigation or traffic violation subject to exigency exceptions. So in conclusion, recategorizing non-safety related traffic stops that are disproportionately enforced on Black and brown Marylanders will enhance public safety by refocusing strained police resources on serious traffic offenses that threaten road safety and rebalancing police workload towards violent crime. So with that, I would urge this committee to take a look. This is the beginning of a conversation, and I urge a favorable report. Now, what I will say before I close, Senator Salling and I were in the same boat, so the video that was showed, the opponents to this legislation, they didn't talk to me, but I had an opportunity to talk to some of them in the hallway. So what I will say, and I'll ask my colleagues, the phenomenon that I'm attempting to address with this legislation, it's been going on for quite a long time. The disparities that are happening need to be addressed. I'm grateful for what we're trying to do in Baltimore County, but if we look at the data doesn't lie. Yet what you're gonna hear is a lot of opposition because people wanna continue doing the same thing that they've been doing that causes these disparities. Again, this is the opening to a conversation about how we can do things differently so that we're not endangering law enforcement or endangering the public. So I would beg you to ensure when they get up here and ask or come and share their opposition, you ask them about the data. You ask them how they intend to deal with the disparities. And I guarantee you, they won't have an answer. Thank you.
Good afternoon, Mr. Chair, Vice Chair, Committee members, I am Natasha Dartigue, Maryland Public Defender, and the Office of the Public Defender strongly supports Senate Bill 292. Thank you to Senator Sidnor for his leadership and sponsorship of the bill. Truth is, almost every American, African-American, or Latino Marylander can tell a story about being pulled over by the police for no apparent reason other than the color of their skin, especially if they happen to be driving in the wrong place, at the wrong time, or even driving the wrong car. Victims of these racially motivated traffic stops find themselves in situations called driving while black. The racial disparity is evident in traffic enforcement. 2023 data revealed that police stopped Black Marylanders, Black drivers at rates 10% higher than those of white drivers, and this is across the state. We are asking that you enter a favorable report. Thank you.
Good evening, Mr. Chair, Vice Chair, and members of the committee. My name is Tia Holmes, and I'm an appellate attorney at the Office of the Public Defender. Time and time again, I watch body-worn camera footage of dangerous traffic stops. And those traffic stops usually begin with some low-level traffic violations, such as driving in a bus-only lane, or momentarily, or driving with an expired registration, for example. Examples of that in Maryland, I can say their names. DeMonte Ward Blake was brutally beaten and ultimately died after being pulled over by a police for driving with expired tags. Tyrone West and Sean Dean also died at the hands of police after being pulled over for low-level violations. Considering alternative methods for traffic enforcement that I've researched, those traffic stops should have never happened. Now, we've looked at other jurisdictions and what they're doing, such as Philadelphia and Virginia. They've addressed this traffic stop issue to improve public safety, and I urge that Maryland should follow suit. And for those reasons, we ask for a favorable report on Senate Bill 292.
Excellent. Thank you very much. Questions from the committee? All right, Senator West and Senator Folden.
Okay, Senator Sidner, so as I read the bill, what the bill seems to say is if a policeman is driving in a marked police car and sees another car on the road and runs the license plate and realizes that the car is not registered and also realizes that it doesn't have the 2 license plates required and realizes, and sees the car make an unsafe turn, illegal turn, and that there are no stop or turn signals working on the car, and the people in the car are throwing litter out on the road, and the car then stops in a bus lane illegally, and then there are no lights on the car, either on the front lights or the back lights. I think I've run through the list.
That sounds like the Harford County video.
And there are no mirrors on the car,
Yeah.
that the policeman is not permitted to stop the car, but allow the car to just go on
Right.
with all of these violations. Is that what your bill provides?
No, it doesn't. It does not. And in fact, I'll let Ms. Tia answer that.
So we, as Senator Sidnor suggested, are open to having conversations about this bill. And the first is that there was some confusion about the headlights and what that concerns. The intent was never to allow someone to drive with non-functioning headlights, for example.
How about taillights? Taillight, you know, when somebody puts on their brakes, the taillight gets real red, and it tells me, as the car behind them, that I better put on my brakes. If the taillights aren't working, I don't know the car ahead of me is braking, especially at night, until maybe it's too late, and I've crashed into their rear.
Well, my understanding of the law as it's currently written is one non-functioning taillight. And so you would need to have one that functions in order to be in compliance with the law. So what we would do is make secondary no functioning lights, not one non-functioning light, if that makes sense.
What about throwing litter out of the car? If the policeman sees a car up ahead and they're just throwing bottles and cans and things out on the highway, should the policeman have no ability to stop the car? Just let them go?
We're going to hear a bill that addresses that this session, where essentially drivers will be able to be be deputized in a sense, and take photos, and that those photos will be able to be used as evidence against those folk who are littering. Again, just to take a step back.
It's unlikely that they get a photograph of the person throwing the litter out, because it's already done by the time you realize the problem.
Just to take a step back, again, many of these things that have been identified are laws that have been misused by law enforcement, and
I fully accept that.
Gotcha.
There's no question. That's correct.
All right. So
the question is, what do we do about it?
So exactly. So when you do this, so then, as I mentioned, for many of these offenses, you have technology that can be used and adapted to address many of these issues.
But can't you take this argument, continue to take it? You know, there are probably more people in jail who are black who have been found guilty of rape as a percentage of the population than white. There are probably more people in jail who burglary who are black. I'm just guessing, but since the population of the jails is very heavily African American, much more so than the population, and they're in there for a reason. You've got all these crimes. So we can't simply say, well, you committed that crime, but you're black, and therefore we're not going to prosecute you. That doesn't work.
But when you're having enforcement that's done in a manner that's causing these disparities, then you have to figure out ways of addressing. And again, this bill, I could, to some people, it's not the answer, but it's a start in conversations, because who's going to have to figure it out? If law enforcement is given a tool and they continue to misuse it, and people's lives are put in danger, it's up to us to try to figure out how to better address it, to make certain that laws are enforced, but done so in a lawful and a fair manner.
Well, let me just finish with one last observation and ask you to comment. A couple of years ago, we passed a law requiring the police to have the cameras on them. Every time they have an interaction with a civilian, the camera has to be on, and if they don't, they can be disciplined for not having their camera on. So in the case of your awful situation when you were with your family, if they'd had the camera on, couldn't you have filed a complaint against the police officer that treated you in that way?
I'm glad you raised that question, because that officer did have body camera.
He did?
He did.
Did you file a complaint?
I filed a complaint, and I also asked for a copy of that video. And it's funny, although I have that video, and I've had it probably for a good 7 or 8 years, I have been unable to open it and watch it.
Okay, you've got me. Why?
Too painful? Thank you. It was. I have it, so I feel good that I have it, but I can't watch it.
What happened to your complaint?
I don't know.
Oh.
They don't tell you. I have no idea. I mean, again, one time I was pulled over in Baltimore City. I was leaving a friend's house. It was probably about just after midnight, and I'm going up Edmondson Avenue towards Baltimore County, and officers pulled me over in Edmondson Village. After they did whatever they needed to do, they came back and they said, the reason we stopped you was because you went through a yellow light. And I'm sure the thought that went through my mind probably went through all of yours. When is going through a yellow light a problem? There's no reason you should be stopping me.
Right.
I filed a complaint. Called to try to figure out what was going on with that complaint. The woman who answered the phone was real nasty, so I asked her supervisor, filed a complaint against her. Don't know what happened to those complaints. You don't know. At least back then you didn't know.
I'm thinking maybe the way to get at this problem would be to do more with the cop cameras and to require much more intensive review of complaints filed against police where there is camera footage that could verify the complaints rather than stopping the police from prosecuting crimes.
And this is where I want to make certain that we're not mischaracterizing what the bill does. So it's not stopping people from enforcing the law and stopping crime. What it is it's recategorizing with the idea that we're going to be able to enforce the law, not necessarily the way we're doing it today, but something different. We're reimagining how to enforce traffic laws differently that aren't putting people's lives in danger, nor law enforcement officers' lives in danger.
Okay. I appreciate.
And again, I'll be. The bill is not perfect.
Yeah.
I even had questions when certain things were in it, but we went ahead forward with it because we wanted to start this conversation.
I appreciate your answers. Thank you.
Thank you.
Thank you, Mr. Chair.
I appreciate you. I know, and look, I saw you loved that video.
I did. I like that video.
It was good.
It was a good one.
It was.
Sheriff Gaylor, I'm going to give you a shout out right now. Good job. So thanks for bringing the bill. I know you're trying to start a conversation here.
Yes,
I'm just
sir.
not sure that this was the way. It has really kind of had some polarizing feelings. It has raised a lot of concerns amongst law enforcement that here we are again with another legislative action against law enforcement. So I'll just say, like, you said it a couple times that, try to reimagine law enforcement. We reimagined law enforcement a few years ago. We went pretty decisively in how we did it. And there's things that I'm going to even throw the chairman's name out there and say that we've had discussions on things that need to be fixed in it, but there is no appetite in this body to fix it, even though we know it's wrong. That's not reimagining law enforcement. That's persecuting law enforcement for the actions of a few and holding everyone available that believes in a better tomorrow. So, and what has been the direct result of that villainization of law enforcement? We now have law enforcement officers that were hemorrhaging bodies. They're either retiring or leaving. We have people not coming into positions. We are now in the state paying $20,000 bonuses to become a police officer. Just a bonus. Because people have now been subjected to the idea that it's okay to be human and make an error, right? I get it. Officers are not infallible. Hold them accountable. But to constantly have another piece of legislation that affects the entire body as a whole, as though they've done something wrong, is not the answer. And when, my son came to me and was like, hey, Dad, I think I'm gonna be a police officer. I just finished my 30th year in police work in December. I'm done. I told my son, don't do it. Not in this state. Go be an attorney. So he's taking his LSATs. Because I specifically told him, he's like, yeah, but I'm looking at the long term for, you've been able to have a good career and have, we didn't make a whole lot. We lived good, but comfortable, but the defined pension plan, he's looking at it through that lens. I'm like, it's not worth it. You can make one split-second decision that is going to be criticized and analyzed for days, months, years later. And we're not infallible in the law enforcement rank and file. So I wish that we would look at things through the lens of understanding that there are people that are going to be mistakes and hold them accountable and move them out of the profession, period. But overwhelmingly, I would put law enforcement up with one of the most honorable positions that people want to serve, because are there bad cops? You're daggone right there are. But there's a method in place to get rid of them. Are there bad clergy? There are. A little more difficult to get rid of than cops. Are there bad legislators? Yep. I'm telling you that. Are there bad judges? Are there bad doctors? Are there bad actors and lawyers? And who reviews lawyers when they do something wrong? Your peers. Who reviews doctors when they do something wrong? Their peers. No one else gets the scrutiny that law enforcement gets subjected to in this state and continues to be faced with because of the actions of this body. We're not handling it like we do every other profession. We're saying you better be infallible, and if you're not, you better be robotic. And if you're not robotic, we're going to get robots to do it. Because you're not allowed to have emotions, you're not allowed to cry, you're not allowed to get upset, you're not allowed to do any of those. You're supposed to be straight line, flat line, infallible. And that is an unfair standard. So when I'm looking at this and you're talking about some of the legislative pieces, when I'm looking at the transportation article, you got Section 13, registration, 411, registrations, 13703, tags issued to another, 21604, unsafe turn, 21605, turn signals, 21111, dropping refuse on the highway, 22203, headlights, 22206, taillights, 22406, window tint. Do you know the breakdown of those, Senator? Do you understand that the 21 are actually offenses that are moving violations?
All right, let's get a pause so that the senator can respond, because I want to hear.
I did. I just said those are moving. I'm separating it out. I'm showing him the difference.
I know. Let's give the senator a chance to respond.
And I appreciate that. You threw a lot there. And to address your soliloquy, and I think most of you know, I have a lot of law enforcement in my family.
Yes, sir.
My uncle was a retired Baltimore City homicide detective. My aunt, retired FBI agent. I have family that have worked in the Department of Corrections. My father was a parole and probation officer. So this bill has absolutely nothing to do in terms of castigating or demeaning men and women who are involved in law enforcement. The sole thing that I did in this testimony was talked about data and what the data is showing. I cannot get in the mind of the officers who pulled over people and caused the statistics to look as they do, but I know there's a problem. And just as you believe that law enforcement has been put upon, black folk like me feel that same way when it comes to being in this country.
And I appreciate that.
So, again, you try to think about ways of making things, bringing down the temperature, because again, although the video was funny, it raised this temperature where I'm getting emails now and being called everything, again, but a son of God. What I would like to point out, and what we're trying to do is not unique in this country. The Office of Public Defenders, they've looked around, and there are at least 12 state and local governments that have passed policies to limit non-safety related stops. California, Illinois, New York, Oregon, Virginia, certainly not a bastion of Democrats, Ann Arbor, Michigan, Chapel Hill, North Carolina, Memphis, Tennessee, Philadelphia, Pittsburgh, Shaker Heights, Ohio, West Hollywood, California. These are places that saw that there was an issue, and they came up with a solution to attempt to deal with what the data was showing and with the risks that were out there for its black and brown citizens. To your point, because I know in terms of traffic law, you know this stuff a whole lot better than I do. So if you want to respond to that, I would really rather them answer.
I understand the nobility of what you're trying to do, and I appreciate that. I wish you would have talked to me, because you do know that, I don't know, I mean.
And I appreciate your line of questioning.
I've done it for a couple weeks, and I'm happy to share a differing perspective that even you may have, right? So I just want to, I'm pointing out that the titles that you're pulling out to say that, oh, these can be done, they're not just, it's not that not only are they not unsafe, or that they're not safe.
Right, and I'm not saying that.
Because, you know, driving without your taillights or headlights on in the dark, did you realize that somebody driving at nighttime without their headlights on, especially with automatic headlights that we have now, there's like a 60% probability that they're under the influence.
And that was something that was, like I said, in the video, where you showed the car with no lights on.
Yeah.
No, this bill is not intended to stop law enforcement from pulling over that violation. You're talking about one light out, not both. That is dangerous. I get that.
Well, but even if it's one light out, I understand what you're saying, but it's still a violation of the law.
Correct.
And what if the second light goes out? Then they have nothing there. That's why you have to notify them of their bediddle ahead of time.
Which is why, again, you could use your license plate readers.
Not all cars have them. Not all cars have them.
If we were to look at, I think the Department of Legislative Services, there's a report that law enforcement agencies that use them, they have to put their reports out. They're throughout this state. There's a lot of them.
Yeah, there are some, but not every cruiser has them. What I'm saying is like, if you want to change the window tint law, then change the window tint law. Make it legal. I don't care. My windows are tinted. I got a doctor's note. I don't care. Change them. But if you're going to do it with the intent of safety, right, under the guise of safety, but then you're requiring that a police officer shall document all reasons for the stop and other stop on any citation. Listen, they already do. It's called the citation. That's what we in police work call a clue. Here's your ticket. This is why you got stopped.
Gotcha.
Like that is the documentation. Then they go back and they write notes on the reasons behind the stop. You're asking for yet another justification, another element. That's more on the law enforcement, unnecessarily, especially in the time because we reimagine law enforcement where we have the body cameras and I would like to think that there has been immense changes in the way that people interact with law enforcement now. Everybody was videoing and everybody's just waiting to find that next, hot button item to put on the internet, right?
Right. In fact, in Baltimore County, they're now talking about looking at using drones in enforcement.
Oh, that'd be interesting. But anyways, so what I wanted to get at is, one of the things he brought up, and I apologize, Mr. Chairman, one of the things you brought up was the registration. And I'll say that everything under 21 is a movie violation. The 2200 series are like equipment violation, those type of things, where it would be an equipment repair order, which is still another reason for a stop. The 13 series is registration. That deals, and what I wanted to point out is just yesterday, one of the FBI's top 10 most wanted in Florida was stopped and arrested for sex trafficking. He's been wanted for several years for child sex trafficking and child rape. He was stopped because he had tags on his vehicle that were issued to another.
And we, if you don't mind, since you brought up registration, I wanted to bring up the public defender because we had a conversation about that portion of the legislation.
And then after this colloquy, I want to make sure the public defender has an opportunity, and I want to move on. We have other senators who have questions.
Thank you. I just wanted to take the opportunity to highlight that we have been engaging in conversations and there are amendments. So when we speak about unregistered vehicle, yes, the car can be stopped. When we talk about expired tags, we're talking about moving it to a secondary offense. So you were given a 90-day grace period. When we talk about
on that one.
So I'm just speaking that there are amendments because there seems to be some dispute in terms of the bill as is written, but there are in fact amendments. So we're not talking about all lights, we're talking about one light. And I also highlight that when we talk about the non-safety stops, we have currently for red light violations and speeding that we essentially are using electronic means to notify drivers. So similarly, if someone is littering, it seems reasonable that we can notify them in the same way so that the officers can spend time in terms of dealing with things that are truly dealing with public safety.
So, okay, let's just start with littering.
All right, one second. Let's go. I want to give Senator Muse and then we're going to go to Senator Henson and then James, and we'll come back to Senator Folden.
Oh, I'm sorry. I was going to ask you, I was going to ask, Again, I was going to be specific. I see that you are about the amendments. It's difficult in a situation sometimes to talk about the racial impact of it because we're not damning everybody to hell. But 70% of black people don't trust police officers. And it's only because of our experience, and our experience is because of color, and we don't ever want to talk about that. No, it's not gotten better. It's gotten worse, and the stats show that. And I think when we talk about somebody throwing litter out of the window, and as a response or as a result of that, they're maimed or killed, it happens for the very simplest things. And if we could save one life, in my county alone, in a 6-month period, we've had close to $100 million that the county paid out because of officers' treatment of citizens. That's a lot of money, right? The problem is nothing ever happens to the police officers. So it's got to be some discipline on both sides, and that's broad. That's broader than what this bill is. But let me just say it is a reality. And the reason the stats say it's happening more is because we're not trying, we can't just address it overall. Got to address it specifically. Having said that, and thank you for letting me say that, but it's true. I have an older car that I like. It's a classic, right? I don't drive it much. But 1 out of every 2 or 3 times that I drive it, I'm pulled over by a police officer. 1 out of every 3. I don't even hardly drive it anymore. And some days I've been pulled over twice. And they ask silly questions. I just know how to respond to them because I know what's going on. I want to see it, well, anyway. In terms of your amendments, can you be more specific about any other amendments in the bill so that we have a clear understanding?
Thank you for your question, Senator Muse. So specifically, Section 13401, that is the provision that deals with unregistered vehicles. It was never the intent to capture that as a secondary violation. So that would be removed in an amendment. Section 134-11 would be a technical amendment to make the secondary violation applicable to that entire section. Right now, placement of an object, frame, or bordering edges of a registration plate is already a secondary violation. That's one thing I want to make clear. This just adds to the list of laws that Maryland has already delegated to secondary violations. So we're not doing anything that's crazy. We're just saying maybe we can use our resources more effectively.
Try something differently.
Section 22-101 deals with taillights, headlamps, which are broken or non-functioning. We just wanted that to apply to Section A1 II, which would deal with one broken taillight or headlight. And what that would do is allow someone time to fix that, right? As the public defender said, we have mechanisms to enforce this already. And based on our research, there's other jurisdictions that will send a repair notice in the mail for people as a notification. And they take it a step further to improve community relations with police by issuing a repair voucher, right? It's called the Lights On program. I think there was a bill last year that failed here in Annapolis, but I would encourage you all to take another look at that because if Maryland wants to improve those community relations with respect to traffic stops, that would be a great starting place. Section 2-203 is the one that caused a lot of confusion, and that deals with whether there was supposed to be secondary enforcement for 2 headlights out or 1 headlight out. So we have an amendment to make it crystal clear that a police officer may stop a motor vehicle if it displays no lighted headlamps. When a motor vehicle displays only one lighted headlamp, that would now be a secondary violation. And so that's all of the amendments that we've gotten to so far, but this is an open conversation. As Senator Folden said, you're very well versed in this. Much respect to you for the work that you do, and your input would be valuable in crafting this. As you know, the traffic code is very convoluted, and there are many provisions. What we tried to do was look at Maryland's code and marry it with what's been done in other jurisdictions. And so those that we pulled out are common among the jurisdictions that have addressed this issue. Thank you.
And thank you to the bill sponsor for bringing the bill and for also sharing your personal experience and what led you to the bill. I found that incredibly impactful. So I too got contacted by my county's police department, my city police department here in the city of Annapolis regarding the bill. So I want to make sure that the intent of it is clear so that whatever direction I go on the bill, people will understand what my understanding was of the intent of the bill. By way of question, do you know if there is a cure to implicit bias?
No.
Yeah, we can do training on implicit bias. We can learn how to identify it. We can develop different responses that we choose to deploy. But in terms of curing the implicit bias that exists in all of us, we're not there yet, right?
It's in us.
It's in us. And when we look at terms de facto and de jure, sometimes you look at something based on the intent when you go into it. You want to isolate a particular group. Your goal is to harm someone or to have a particular effect. And sometimes you get to a result based on what the actual data tells you and what the results are. It's similar to if there's a drug that they're testing for medical purposes, and they realize, oh, the people on this trial, they all lost a bunch of weight. So now it's a weight loss drug. Or, you know, all the people on this trial had this effect, so now we'll use it for that purpose. I think of de facto in the same way, that if we look at the results and the results tell us one thing, then we must be guided by those results and we must take action based on what the results say. Is that kind of your concept as well?
That is the concept. The data is showing that what we're doing is not working for a part of this community. And again, this is a response. This is a way that we're feeling that we can chip at making these, dealing with these offenses safer for the community. And again, given the communications that you've received, that I know many of you have received, generally speaking, law enforcement doesn't think that this is the answer. So then I think the question, the relevant question to them is, then what do you believe is the answer?
I appreciate that. And as a legislator, I think that sometimes our job comes down to balancing risks. We can't take away all the risk of any situation. We can't make the situation perfect. I believe every person in this General Assembly, if we could, we would make it perfect. But sometimes we have what we have, and we have to decide when there are risk factors on both sides, what risk outweigh what other risk. And what I'm hearing is that there are legitimate law enforcement benefits for being able to stop people for these offenses.
Absolutely.
There are opportunities to make initial points of contact where sometimes larger crimes are discovered. Absolutely. Where law enforcement can do things to intervene, to make sure that, you know, meaningful things happen in the course of that discovery.
That's correct.
But what I'm hearing on the other side is that there are really, really great risks to certain communities who the data tells us are at risk more than others.
Absolutely.
I'll tell you as a mom, the day that I handed my son the keys to his car was one of the most terrifying days of my life. And every time he calls me and his name flashes across my phone, I have a fleeting thought of, dear God, I hope he's safe. And when I think about I hope he's safe, I think I hope he's not on the side of a road. I hope he hasn't been pulled over. I hope he's okay. And that happens every single time I see his name. The joy you should have of seeing your son's name who calls you, you know, because he called his mom. That's pretty cool. But it's also tempered by the fleeting thought of, I hope everything's okay. And one of those series of thoughts deals with his engagement and interaction with law enforcement. So in the role of balancing risk, when you look at the risk of perhaps not getting that other benefit of having a person stopped by an officer, and maybe you don't get that opportunity to discover a larger crime. But when you look at the other risks that you could avoid, perhaps that person does make it home safe. Perhaps that driver isn't unfairly targeted. Perhaps Senator Muse can drive his very nice car and be uninterrupted and enjoy the leisure that he's worked hard for. When you think about the risks that you're balancing, do you come down on the side of saying, I have to make sure that a community that's being disproportionately impacted, that I'm blunting some of those risks?
Absolutely. And again, I'll be honest with this group. I've never been a big fan, and Senator Folden and I, we've been able to kumbaya. I've never been a big fan of the automated speed cameras and things, but there are benefits to bringing them in if you don't have to have that risk of those interactions where someone mistakenly going to scratch themselves might scare an officer who they don't know you. You're a stranger to them. They may feel their life is at risk, thereby doing something that is irreversible. So again, we're in the 21st century. Law enforcement is using all types of technologies. And all I'm saying is maybe we need to look at some of these technologies and figure out how we can redeploy our shrinking police staffs to deal with crime that really, really matters rather than bogging them down with these types of offenses and making them, again, secondary offenses. No one is getting rid of any laws that are already on the book. It's a reclassification.
Thank you for your response. Thank you, Mr. Chair.
Thank you, Mr. Chairman, and thank you for bringing this bill. And thank you for sort of saying, I want to start a conversation as opposed to this is the absolute, because it's such a good thing to have. Yeah, I know.
It's not.
Just to clarify, you're going to revisit some of the ones that are more really safety, because I can just tell you that because I've had a lot of eye surgery, my vision at night, even though I don't have to wear glasses, is challenging. And I desperately need people to have their headlights on and their taillights working, because I can be, half a second slower than most drivers. So, you know what I mean? That's the kind of thing where I don't want anybody to, get into trouble, but I also don't want to ram into somebody because their lights aren't working.
Senator, it's funny. Amongst our colleagues, I'm one who goes home every night. And when we leave this committee, I'm going home up 97 in the dark.
Yeah, right.
But one of the nice things about what I've noticed about some of our highways is they use these reflectors. So you will always
really like
see.
those.
Mm-hmm. And they're not throughout the state. No, and I've always wondered why we don't have those kind of things to kind of help with the vision.
More light is better.
Things. Yes. So I understand.
And then I so apologize that I was not here in the beginning. So if you've already answered this, then we'll follow up with you. I am very intrigued in your own testimony, right on in like the third paragraph or second. You did get some data about drivers 73% more likely stopped at black than stopped.
Right.
So one of the things, I don't know if you got any more data, but because this is a reoccurring issue, and I, think about it often, like how can we solve this without going in circles or getting entrenched, both sides, right?
Right.
I kind of wonder, like, how does it break down on men and women, age group, reasons for the stop, and now this one's thorny, but economic factors, because I began to think, sometimes, poverty or having less money means you're not fixing a problem in your car, like a tail light, right? And then if you have a disproportionate number of African Americans who are in that economic situation, it can feel like it's racial, but really it is that there are not as many people in that category that are fixing things that others might. Did you get it? I would love to get this kind of information. I think it would be so helpful. And then I have one more question.
Sure.
But I'd love to get that kind of level of detail as we try to figure out how to, both respect both sides of this this issue. So did you get anything like that, or do you think we could get information like that over time?
Okay, so I was told that there is the traffic stop dashboard that has a breakdown by race. The information that the information that I was talking about, though, it came from a study that Baltimore County put together using UMBC to pull this information together. So.
And it's just not helpful because it may very well be exactly what you are claiming it is, which is disparity based just on race. But I'm wondering if it's more nuanced because it's based between men and women. May not be. Age maybe, younger, I have no idea. The reason for the stop. And then again, wondering again, not that you would capture it in this data, but if you knew the economic strata of people and realized that because you knew why they were stopped, it was, taillights, and a group of people were not fixing because of their economic situation. You don't have to have it. I would really love that kind of deep data for us going forward at some point.
What I can share with you is the report that that Baltimore County has. It looks over, I think, about 5 years of data. I can share that with you.
Yeah, okay, great. So, and here's my last thing. When I began to read your testimony about you getting pulled over with your family, and then I remembered an NPR article where I was listening to an African-American woman telling a story about when her father was pulled over and having the same feeling of being disrespected and, the officer being condescending. And I remember when I listened to the NPR article, I said, I wonder, don't shoot me anybody, I wonder if this has to do with some culture or male versus female, because here's my reaction. I got pulled over more than once with my family in the car. I am absolutely mortified. I am, right? At least once the officer was not very nice. But and my kids were going, are you going to jail? Are you in trouble? All of that, right? But I felt like it was a teachable moment for my children anyway. But my reaction to the officer in each instance, and almost always, regardless of how he is speaking to me or treating me, is to be extraordinarily polite and apologetic. And what is the problem? I'm very sorry. Whatever I did, I'm sorry. Partly because I'm scared a little bit. It's not like everyone's the only people that are scared when they get pulled over, right?
It's uneasy.
I'm mortified and embarrassed and scared. I don't know what I've just done. So I wish I could kind of get to a way we could study the perhaps cultural difference between men and women in reacting to this. That might be helpful to us in understanding this. And I understand men having more pride and, I understand men, being masculine between each other where women don't have that particular need to do that. You know what I mean? And there are all kinds of words and jokes about this, but it's also serious and it can seep into traffic stops or any interaction. And then just generally wish we could study that more to see if that too plays into, because I think it's a complex issue. Race is certainly part of it, but I think it's so complex that we do a disservice if we don't get into the really deep data to figure out meaningful solutions that keep law enforcement, doing their job and doing it well and making sure people aren't truly being disrespected versus perceiving that disrespect.
And Senator James, one of the other things that I mentioned while you were out, all traffic stops that I've been involved in have not been like that one in Virginia. There have been some, and I mentioned being pulled over by the Maryland State Police, and totally respectful. I did not feel it was a good feeling. I mean, not that you feel good being pulled over, but he did not make me feel awful.
I wasn't in Maryland when I was not treated too well, so I can appreciate that.
I understand you.
Right. So anyway, I'd love to see if we could get more information on that over time, or even if anybody is studying it. You never know across the country, people are looking at these issues, not so much for a bill, but just because they're studying it and because it's important.
Yes, ma'am.
All right, thank you.
Thank you.
Thank you, Mr. Chair. Thank you for bringing this bill, sir. My question has to do with, the basis of the bill is data-driven, and the basis of the bill, and so my question has to do with data-driven. In 2021, we established the Maryland Police Accountability Act. Why wouldn't this address through data that was being drilled down to the individual counties and then being reviewed, why wouldn't this have been a way to genesis technology, as you have said, to be able to come up with ideas? Hindsight being 2020, it just seems to me if we had asked these boards or put a more directive to come up with other technology opportunities, that may have been, granted hindsight being 2020, instead of putting in this bill that has been requested, we may have not gotten the response that we got from law enforcement, because while pulling somebody over for the color, the pigment of their skin, their gender, whatever the case may be, is 100% wrong, also putting in a bill that while it may not have been pitched this way, but I can imagine that it was received, that it was you're accusing somebody of the pigment of their skin. And so if we can work on the data-driven, and I know you to be a good, honorable man, and I truly mean that.
I know you do.
And so, yeah.
Thank you.
Thank you, sir.
Thank you, Mr. Chair. Okay, so just to round this out, I get to close it out.
All right.
So, look, I hear what you're saying about some of the disproportionate data that you're seeing in the traffic stop data. Can we agree that there may be that communities of color may be disproportionately impacted by violent crime?
Yes.
Okay. So recognizing that, I'm going to go to also a part of this, which is from the Maryland State Police, Maryland Gun Center thing that they just put out.
Okay. And I'm not familiar with it.
That's fine. I'm just going to let you know. Last year, we got over 1,600 guns out of motor vehicles on traffic stops. Okay? Those are, now, when you drill down a little further into that data, out of vehicles, but then we had subjects that were encountered by police as well. So this next slide deals with subjects that are actually illegally armed, okay? Not just the data in the car. And what I'm going to tell you is that Baltimore City had 1,655 instances either in traffic stops or dealing with an individual that was armed. The next closest was Prince George's at 1,511. After that, it drops off dramatically down to 843 in Baltimore County. Then it drops down to 420 in Anne Arundel, 331 in Montgomery. And then the rest of the state is well below 200. So when we're talking about things and we're talking about disproportionate things impacting our different communities, we've really got to look at this as a greater, broader lens. Because the numbers I'm giving you are not, that's factual data. Right. And it's in 3 major communities. You know, it's either Baltimore City and 2 major counties that all these guns are coming from. When we take away the opportunity to stop somebody for a tag, which you can't really, we don't have any idea if that tag even belongs to that vehicle. We don't have any, and if it's a tag issue to another, the automation can't determine that by looking in real time to say, well, that tag says it's registered to a Hyundai, but it's coming back on a Mercedes.
And and correct me if I'm wrong, I think what you're saying is these traffic stops are an important tool to ensure, and if we're thinking about
they're a public safety tool.
Disproportionate impact on community, you need the traffic stops in order to find the guns so that the guns aren't used to disproportionate.
That's not what what I'm saying is that, I mean, that may be, what I'm saying is that there's another tool. These are a tool that are utilized to say, look, this is an illegal action, and then as a result of that, there are other things that are coming from this, whether it be guns or other illicit material or items. But the reality is that, you know, there's actions and there's consequences, and people are changing tags. I go right around Baltimore City. You know how many Virginians live in Baltimore City?
You know, it's funny because that's a pet peeve that our county chief has.
They don't have to register.
That issue.
So in that instance, how it is this, it's going to someplace in Virginia, and there's zero reciprocity on that type of, on that type of, on that arrangement. We're going to send it off. It's a civil violation. There's no requirement for them to pay, and there's no consequences if they don't.
So it's the public defender had a response to that.
I just want to clarify, in this bill, if it's unregistered vehicle, the officers may stop. So in your example,
if it's what?
In your example, you are able to stop the vehicle. So the switching of the tags, this bill does not say that you cannot stop vehicles. So your example,
but if it's unregistered, we can't.
Unregistered, you can stop it as well. That is we talked about their amendments. Those are part of the amendments.
Oh, okay.
Yes, those are part of the amendments.
The last thing I want to get on, and you can answer maybe better, is the littering. How the heck are we going to enforce littering when we can't do it now? There's not cameras on every road. And this has a very negative impact on the State Highway Administration, who's already struggling to clean the roadways up. And then you're going to pass this along because a lot of people in these rural counties are going on these back roads and they're dumping all their stuff. And if you see them doing this, by this bill, we're going to be like, oh yeah, that's a nice couch. Maybe you should have took that to Goodwill instead, but you leave it there. I'll clean it up after you leave. That just doesn't hold water.
We're not referring to the dumping of couches or mattresses.
It's
that would
littering.
speak to, but the instances that we're talking about is, for example, someone is discarding a cup or a bag. But when we speak about moving it to a secondary stop, it is limiting the encounters, and it allows officers the ability to spend their time and their resources in terms of safety-related
But these are
stops.
safety-related, and that's my point.
But I would also say that, in fact, what is safety-related is red light, those individuals running red lights. What is also safety-related, we think about on 695, excessive speed. Those are all instances in which we use technology. And essentially, quite frankly, the reality is you cannot be on any corner in any place without being captured on some sort of camera. So it's a matter of using the resources that we currently have to limit, especially negative interaction with people of color.
Well, and I mean, look, I'm not going to be able to sit here and argue, because if you're going to make this solely that it's about race, I can't make that argument because the data with the guns doesn't have anything to do with race, but it's in the 3 largest jurisdictions that are probably the most heavily hit and disproportionately impacted by violence. If I take violence across the state and I say this community is disproportionately impacted by violent gun crime, and I blanket it over top of this, I'm going to bet you that it's going to be the same.
I will tell you that the data and the research does not support that traffic stops are an objective crime-fighting tool. The
You don't
best
think
way
getting
to use-
1,600 guns off the road is a crime-fighting tool?
Essentially, in terms of this, that is one of the false arguments, I would say, that are made as to why traffic stops are necessary, is in terms of getting guns off the streets. In fact, non-safety related traffic stops rarely result in the recovery of guns or other contraband. And unfortunately, the reality of it is that for Black Marylanders, they are more likely, once they are stopped by police, they're more likely to be arrested and be the victims of negative police conduct.
I understand that's what this bill is about, but we can't keep taking it back there only.
I'm only speaking what the data shows, that
And I'm
Black
showing you
Marylanders
what the
make up
data shows, and you've
30%
gone
of the
somewhere else.
population, but over 70% in terms of those individuals that are arrested and incarcerated. There is a problem, and it starts with pretextual stops.
We have data that's been required from the Police Accountability Act that this body passed. I don't see any of that data here as a part of this. How is that data not a part of this? That data includes investigations, the race profiles of those that are filing complaints against officers, the dispositions of those outcomes. We can't even get justified. It took 2 years for this body to allow an officer to receive a positive counseling and leave it in their file. How are we not able to drill down and get the data that you're suggesting is out there?
I'm not clear in terms of I'm not clear in terms of your question, in terms of the correlation, because this is simply moving non-safety to a secondary stop to limit negative encounters between police and Marylanders.
And what I'm saying is it still has an impact. There are still safety things that you cannot substitute. Unsafe lane change, doing a U-turn in front of people, that's an unsafe act. That should require immediate attention. There's not cameras at every time when someone does an unsafe lane change like that. You're talking about finite areas that you would have these enforcement things. That's not the reality of the world we live in. We live in a fluid society where no matter where you go, there is an ever-evolving, changing environment. That's what police live in every day. Have you gone on ride-alongs with your local PDs to see that?
I have, as a public defender of over 28 years, yes.
That's wonderful. And I encourage everybody to do that. But in a hyper-changing environment like that, this bill just doesn't go far enough for what you're saying to be in every place because it's not possible.
It does not
and financially to cover the littering on what it would cost for us not being able to, law enforcement to not be able to have a stop it's an unjustified burden on taxpayers. It's another thing that taxpayers have to pay for bad actors.
We've burned this candle for long enough. I appreciate that. And I think the point's been made.
Well, I have one last thing, Mr. Chairman, and that's on the window tint. And the window tint, I want to know about that because I see a lot of front windows tinted. And the allegations you're making is that it's done, that this is a race-based thing. And I see a lot of people with tinted windows, and there's no way for an officer to tell how many are in there or what color they are, period.
If I may, and again, it goes back to what I'm saying. I'm just talking about the data. I have not said anything about the officers pulling the people over. Me as a driver.
But these are the things you targeted. I get it.
No,
so
but right,
we can have that discussion.
Just strictly talking about the data. I have no idea why police. I'm not talking about the intent or anything like that. What's in the mind of the officer when they're pulling over or not. I'm just strictly talking about the numbers.
Yeah, no, and I appreciate. That's why I thought Senator Henson's point on, the bias training was an excellent point. I mean, it's a very implicit bias is something that's not overcome easily.
And if I may say so, Mr. Chair, I appreciate everybody's questions this evening and the conversations around this bill. So thank you all.
No, Senator, I echo your sentiments. And I couldn't have said this better than Senator Henson. But this is tough, and this is why. Look, we're not advocates or activists. We're lawmakers, and we have to balance equities. We have to understand systemic, built-in, racial justice problems in our society, while also understanding that we have a responsibility and obligation to keep the public safe, and that this balance is, this is why this is a tough conversation. So I appreciate that. And we talked about this earlier in the morning, and I know we're not supposed to talk about caucus, but we talked to the Democratic colleagues about the disparities that exist not only here, but in juvenile justice and the criminal justice system at large. So look, I appreciate the dialogue. Senator, thank you for bringing the bill, and senators, thank you for engaging, and to our public defender, thank you. For public defenders, thank you very much for being here. That will end the questioning for this panel.
Thank you very much.
We're going to move on. Let's see who's next. So we're still on folks who are here to testify in favor.
So Maryland State Police gun gets their gun.
So that was Tia Holmes is here, Natasha Darty. Is Edward Jackson still here? Okay. Do you want to come on up? Sure. Come on up. And then who else is here? That's right. That's virtual. Ruth Noel. Scarlett. That's virtual as well. Hold on. These are all virtual. In person. Edward Jackson's not here. Is Heather Warkin still here?
She had to leave as well.
Got it.
I believe. She texted me. She had it.
What about Zemer? Matt and Zemer? Still here? Come on up. That's virtual. Where is that? Is this one? Who? Jordy Diaz. Is anyone else, Joanna Silver? Is anyone else here? Did I miss anyone? Is here to testify in person? Excellent.
Thank you. I know I only have a minute, so pardon me for speaking fast. My name is Debbie Levy. I'm with the Office of the Public Defender. There's an additional point that our office wanted to make today. First, I wanted to reiterate the point that this bill does not remove crimes. It only removes certain violations as primary enforcement mechanisms, and Maryland already has several violations that already are secondary enforcement stops. This bill is just adding a few more: driving with expired tags for less than 3 months, driving with a single functioning taillight, window tint, excessive noise, driving in a dedicated bus lane are some of them. One of the things to think about is that this changing enforcement methods just frees up valuable resources. I think that Senator Folden was talking about hemorrhaging of law enforcement, and this would allow law enforcement to focus on reckless driving, on DUIs, on speeding, on actual things that impact public safety, and look at alternative means of enforcement. So you can send a letter home, you can send a notice, you can capture a license plate issue and send a letter. So we're still enforcing these, but we're just not enforcing things that don't make the communities unsafe. We're only focusing on things that make the communities unsafe. And there's no impact or correlation between these and safety. Thank you. Urge a favorable report on 292.
Mr. Diaz?
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the committee. My name is Jordy Diaz, and I'm an organizer with Young People for Progress in Montgomery County. We strongly support SB 292. In 2023, we backed the STEP Act, a similar bill to SB 292, aiming to reduce unnecessary traffic stops during During those hearings, we heard powerful testimony about the harm these stops cause. One testimony shared how a student was surrounded by police over a broken taillight, leaving him humiliated. Another driver, a young Haitian immigrant, was stopped and searched without consent over a temporary tag mistake. These experiences highlight the trauma caused by such stops, especially for young and undocumented individuals. SB 292 addresses these issues by limiting police authority for minor offenses and ensuring evidence from such stops isn't admissible in court. It will help prevent escalations, reduce racial disparities, and build trust between law enforcement and communities. We urge the committee to issue a favorable report on SB 292. Thank you.
Thank you. Hit the mark. Ms. Silver?
Thank you. My name is Joanna Silver, and I'm testifying on behalf of the Silver Spring Justice Coalition in support of SB 292. In 2023, we also supported a similar bill in Montgomery County that was unfortunately preempted by state law, so we are grateful to Senator Sidner for sponsoring this bill. In our county, Black and brown drivers are stopped at far higher rates than white and Asian drivers. A recent report revealed that the greatest racial disparities are seen in stops for non-safety-related traffic violations, like equipment violations. That same report revealed that 74% of all searches during stops were of Black and Hispanic drivers. Despite claims that these searches are necessary to fight crime, they reflect a needle-in-a-haystack approach. In 2022, less than 1/2% of all traffic stops in our county resulted in gun seizures. I want to share a final data point, that in 2023, our county lost 45 people in car crashes, and 3,900 crashes resulted in injuries. We don't need racially biased fishing expeditions to keep us safe. We need equitable traffic enforcement that focuses on dangerous driving.
Thank you so much. Mr. Zeimer?
Good evening, Vice Chair Waldstreicher, members of the committee. My name is Matan Zemmer. I'm here as the Maryland Policy Director at Jews United for Justice, which organizes over 6,000 Jewish Marylanders and allies across the state for racial, social, and economic justice. Senator Sidner, thank you so much for bringing this bill. We're here testifying in full support of the legislation. I won't repeat what you've heard already, but clearly the data shows that we have a big issue in our state, and the racial disparities in these non-safety related traffic stops needs to be addressed. And we have an opportunity in front of us to take a real look at how we adjust our approach to public safety. This bill offers that roadmap and a real opportunity to have a serious conversation and move our state forward. not only do these stops not improve public safety, they also pull resources away from other efforts to reduce dangerous driving that actually drives the rates of injuries and fatalities that we see on our roadways in Maryland. So that's just one other point I wanted to throw into there for what you've already heard, but I urge the committee to issue a favorable report, and thank you for your time.
Thank you for your testimony. Seeing no questions for this panel, we'll move on to our virtual witnesses. Our technology here has become so sophisticated, it actually is starting to overlap each other, so it's hard to see all the names here. So I'm going to take them in order that I see them here. Chris Burbank, you are first. Chris, if you're on, please unmute and go for it.
Thank you very much. My name is Chris Burbank. I'm the former chief of police in Salt Lake City, as well as vice president of the Major Cities Chiefs, the 70 largest agencies in the U.S. and Canada. One of the things I think is most important here is it's been alluded to that Black and brown people are more criminal or drive more poor than white people. Study after study has demonstrated that that is not true. When we look, the responsibility of administrators and legislative bodies across the country is to minimize the risk to our officers, and that includes liability and wrongdoing. It is our responsibility to look at these. You can evaluate what traffic stops cause accidents. NHTSA has these numbers, and the violations referred to in this are not causing safety concerns on our roadways. They are also not resulting in the legend and lore of policing that we are getting guns every single day off the street. As was stated, less than 1% of the time is this accurate. It is absolutely a fishing expedition, and we can do better and should. Thank you.
Thank you, Mr. Burbank. Charmin Leon. Is Charmin with us? All right, we'll go back to Charmin at some later point. Daniel Boda. Daniel, if you're with us, please unmute.
Yes, hi, thank you very much. I'm Daniel Boda. I'm from the Vera Institute of Justice. We are a national policy and research organization, and we support SB 292 because we see it as promoting traffic safety and keeping communities safe. So I just want to highlight those 2 points. I want to refer you to our written testimony for additional details. So over a third of Maryland's traffic stops in 2023 were for equipment and registration defects that are not connected to crashes. And that's referring again to the same NHTSA data that Chief Burbank mentioned. Injuries and deaths, meanwhile, have been increasing on Maryland roads over the last few years. SB 292 would free police up to focus on high-risk driving and would advance Maryland's highway safety goals. The second thing I want to say is that traffic stops are dangerous for both drivers and police. And I know this has been alluded to, but the 5th most common cause of police deaths while on duty is being hit by a passing car during a stop. Everybody in Maryland deserves to be safe behind the wheel, so we urge you to give a favorable report on 292. Thank you.
Thank you for your testimony. Ruth Noel, please.
My name is Ruth Knoll, and I am testifying on behalf of Presbyterians for Police Transformation, the ministry of Tacoma Park Presbyterian Church, in strong support of SB 292. Fellow congregants have shared stories of personal and family trauma resulting from pretextual and racial profiled traffic stops. While we're motivated by these experiences, our advocacy is guided by the data and research that reveals states and cities with similar policies see increases in both public safety and racial equity. SB 292 is based on this outcome-based evidence and not on anecdotes. The data collection and reporting provision is also important. Without it, there will be less transparency and public accountability, both of which are vital to future reform efforts. In sum, we urge you to issue a favorable report and to continue to work for this legislation becomes law this year. Thank you for the opportunity to testify, and you can also look at our written testimony.
Thanks, Ms. Noel. Next will be Scarlett Neath.
Thank you so much. I'm Scarlett Neath. I'm with the Policing Project at NYU Law School, a national organization dedicated to supporting more effective and equitable policing, testifying in strong support of SB 292. As is described further in our written testimony, this is a really common sense measure enacted by several other jurisdictions to help align traffic enforcement with actual safety issues. Speed, aggressive driving, distracted driving, and impaired driving are by far the major contributors to crashes and fatalities in Maryland as in the rest of the country. But as has been stated, 3 times more traffic stops in Maryland are for equipment, license, or registration violations rather than the sources of these actual crashes. National data shows that of all the vehicles involved in fatal crashes, only 0.2% had any equipment-related issues attributed to them. And I think we need to follow that data when we're looking at what is actually causing safety problems on our roads. Thank you.
Thank you so much. Catherine Head. Ms. Head, please go ahead.
Thank you. Good afternoon, Mr. Chairman, Mr. Vice Chairman, and members of the committee. My name is Catherine Head, and I am a student at Montgomery College. I am testifying today in support of SB 292. Traffic stops disproportionately affect people of color. Scientific studies and official Maryland traffic stop data show that drivers of color are stopped at significantly higher rates than white drivers and are then more likely to be searched or have force used against them. In limiting non-safety related traffic offenses, this important bill will eliminate the type of stops with the most racial disparities, thereby reducing harm to Maryland drivers. Passing this bill will also improve public safety by allowing police to focus their limited resources on more serious safety-related issues. This bill is particularly important to me because my family is multiracial and I want my siblings to be safe as they learn to drive and treated with fairness and respect on the roads. I urge you to give a favorable report on this bill. Thank you for your time.
Thank you so much. We'll now go back to Charmin Leon for our final online testimony.
Thank you so much. Apologies about that. Thank you, Chair and members of the committee. My name is Charmin Leon, and I serve with the Cleveland Division of Police in Ohio for nearly 13 years and in law enforcement for over 30. I'm currently the Director of Law Enforcement Initiatives at the Center for Policing Equity, a research and action organization made up of former law enforcement, community engagement specialists, and academics. And I wish a Form SB 292 was in place when I worked patrol in the busiest district in the city of Cleveland. Officers who focus on non-safety related stops, oftentimes as a means to show productivity, weren't focusing on driver behavior that actually endangers public safety. It's not an effective crime-fighting strategy. It also produced animosity amongst officers who would have to pick up additional calls for service while their coworkers were on what was effectively fishing expeditions that did not often yield contraband or guns, but instead it contributes to the economic hardship of our most vulnerable community members. I thank you for your time.
All right, thank you very much. Senator Sidnor has a question for you.
I had a question for Chief Burbank, if is he still available?
Yes, sir.
Thank you. I'm assuming you said you're in Utah?
I am.
Did you have an opportunity to implement a similar law in Utah, and if so, how did it end up working?
So I actually implemented this regarding jaywalking citations in Utah when I realized that we were issuing Black and brown people primarily in and around our homeless shelter citations, that we were not issuing the same number. And what I saw was a change in the disparity associated with those, but I actually prohibited our officers from stopping people from that. And I got a large kickback that we wouldn't be able to get dope out of people's pockets and those sort of things. But did not see that happen. In fact, what we've seen and what we've seen across the country that has implemented this is officers spend a little bit more time, develop probable cause, good reason to stop vehicles or stop people that are lawful, and actually create good cases so that they stand up in court in the long run. And you've seen agencies throughout Connecticut who have done more DUIs since implementing this law.
Thank you very much.
Thank you very much, Senator. Further questions from the committee? All right, great. That'll end the testimony for the proponents of the bill. We'll now switch to the opposition. And we'll start off with Mr. Boatwright, Mr. Cohen, Schellenberger's there. It's Eric Brandt. Mr. Jordan, Jeremy Jordan here.
That's the way it is.
tonight.
All right, excellent. And then Mr. Rodriguez wants to come up. We'll keep it going.
So, Mr. Chairman, members of the committee, quickly, I really appreciate what the police officer from, or the commander from Utah is telling us, but I'd much rather listen to these folks who are here in the state of Maryland, and they tell us what they think is right and what's wrong. Somebody look at me and tell me not having a headlight is not a public safety danger, particularly if it's a left headlight and you're making a turn into another street. That is a safety danger, and you're taking that away. And one thing that no one has mentioned, no one, is this long list of things that you're not allowed to stop anybody for. Not only can't you stop them, not only can't you then go to the next phase and search, but now it can be a statutory basis for administrative proceedings. Somebody tell me where else in Maryland law we say that you have made a mistake and we're going to bring disciplinary actions against you. That's not the way it should work. I'm telling you, this is not a law that we need. It's going to be a danger to the public, and I urge an unfavorable report. And please listen to my law enforcement friends.
Good afternoon, Mr. Chair, members of the committee. My name is Clyde Boatwright, President of Maryland State Fraternal Order of Police, and we are totally opposed to this piece of legislation. To quote the songwriter from the Osley Brothers, here we go again. We back to police reform again. I've been fielding calls for the last week or so from our police officers all across the state saying we're back again. And the police officers are all wrong, and we need to find a way to discipline them. Again, never before in American policing have we been under more surveillance. We have poll cameras, body cameras, in-car cameras, all of these other tools and mechanisms to track the interactions between police and communities. And now we want to use another piece of technology. Let's just mail people a ticket. I don't know if you've driven around the city of Baltimore, but nobody stops for red lights and nobody stops for police. So this is another thing right now where our police officers feel like it's about us and not about the people breaking the law.
Good evening, Chairman, good evening, committee members. My name is Lieutenant Elliot Cohen. I'm testifying on behalf of Baltimore City FOP Lodge Number 3. My biggest concern about this bill is it also degrades police and community relations. The community in Baltimore is already frustrated by improperly registered vehicles and unsafe driving. And what they'll see is that they'll witness these infractions with an officer next to them, and the officer won't take any action. And then the citizen will be frustrated that that officer is not enforcing the law. They won't be hearing any of these arguments. They won't be seeing the data, right? They see an unsafe driver and they want the police to do something about it. And not only would they not be able to do anything about it, they would be disciplined if they did. So you could picture a driver, a police officer next to another driver in front of them drops a bucket of nails on the road in front of them, and the person just drives away. Citizen asks, officer, why didn't you stop them? They say, I can't, I'd be disciplined if I did. So thank you for your time. We oppose this bill.
Good evening, Mr. Chair, members of the committee. I'm Jeremy Jordan, member of the Fraternal Order of Police and an active law enforcement officer in Maryland. My testimony today is in opposition to Senate Bill 292. While the intent to increase accountability and transparency during traffic stop is commendable, the proposed legislation introduces significant concerns that could undermine public safety and effective law enforcement. Limiting certain traffic offenses to secondary enforcement hampers an officer's ability to address violations proactively. Many seemingly minor infractions, such as improper signaling or expired registration, often lead to uncovering more serious offenses, including impaired driving or stolen vehicles. By restricting enforcement to secondary actions, the bill removes critical tools officers use to ensure safety on the roads. The mandatory exclusion of evidence obtained in violation of procedural requirements risks creating loopholes that could allow serious offenders to escape accountability. For instance, evidence of illegal weapons or drugs discovered during traffic stops for an infraction could be rendered inadmissible, weakening the efforts to combat crime. For these reasons, we urge an unfavorable vote.
Good evening, Senator Smith, Chair, and members of the Judicial Proceedings Committee. Thank you for once again allowing me to come down and speak on proposed legislation. The Anne Arundel County Police Department stands in opposition to Senate Bill 292 as written. I'm not going to go back over all of the things that have been stated about it, but if enacted as written, it's going to have the unintended consequences of undermining police enforcement of criminal vehicle theft laws, not authorizing things for primary traffic stops such as not having tags. Criminal offenders, as we all know, they often steal vehicle tags and place them onto other vehicles, and they use tags that are legally registered to other vehicles. It would also limit police officers' ability to mitigate the dangerous car club rallies that we've come and talked about many, many times that occur on our roadways, because nearly all of these violations are often observed as primary violation by the initial responding officers. So with these things being stated, and as everybody else would say, we stand strongly in opposition to Senate Bill 292 as it is written.
Thank you, Mr. Chair. Mr. Schellenberger, you're still here?
Yes.
Great. So I've listened to this very long hearing, and I come back to a point I tried to make early on what I want to ask you about. 10 years ago, I would have paid a lot of attention to this bill and thought it's something we should deal with. But in the meantime, something's happened. We have these body cameras. And as I recall, every single time a policeman has an interaction with a member of the public, he has to turn on the body camera, correct?
That's correct. Every time that they are actually turning their lights on to make a pullover, bang, they have to hit that button and turn that body camera on.
And if a policeman doesn't turn on the body camera, I assume there's some sort of administrative sanction?
That's correct. They could be subject to disciplinary action.
So
it's not in the statute, but they could be subject to the disciplinary statute sanction.
So every time there's one of these traffic stops, when the policeman gets out of his car to go up to the car of the person he has stopped, his body camera has been turned on and the whole thing is recorded, right?
Right.
Okay. So now Senator Sidner said in connection with his stop that he made some complaints and nothing ever happened. Do we have a problem with dealing with complaints made by citizens about improper stops, unacceptable conduct of the police? Should we be looking, instead of this bill, at another bill which would set up a better system for dealing with complaints like that when they come to your offices, so we can make sure that if police are bad apples, they're caught and they're properly disciplined and maybe discharged?
Well, I do feel bad for Senator Sidnor and what happened to his family in Virginia, but that's not Maryland. I know that it can happen. I can tell you in Baltimore County.
Well, what do you do in Baltimore County?
We have a very robust internal affairs complaint system. I have seen internal affairs complaints that I've wanted to say, just throw them out because that's the stupidest thing I've ever read. But our police departments, and I think some of these other folks can probably back me, our police departments take all internal affairs complaints seriously, and they see them through to the end. So I think we have a system where if someone is doing something wrong like that, we have a way to discipline them or correct it.
Thank you.
Thank you, Mr. Chair. Thanks for all of you. Thank you all for coming and testifying. I didn't really get a chance to get to that point, so I'm glad it was brought up. But the part about the administrative sanctions that could be brought against someone for doing what would otherwise be a safety act, that element is true, is it not?
Oh, yeah.
By the way it's written?
So a left headlight is out. You pull them over, you find a gun. Not only can't we use the gun,
right,
but now this officer can be brought up on administrative sanctions for trying to keep the public safe.
Yeah, that was where I was going to bring my next point, which was very specifically, they bracketed out that it may not serve as a basis for the exclusionary, for the exclusion of evidence under the exclusionary rule, which I found interesting because, the fruits of a poisonous tree usually result in a bad act, like an initial purposeful, malicious bad act. But if you do something and you're doing it in good faith, which is always, unless something's changed dramatically, as long as you're acting in good faith, that you were always, there was a little bit more, and you're attempting to act within good faith and in the spirit of the law, that was not an exclusionary.
That's correct. Under the Constitution of the Bill of Rights, good faith can always come into play when you're dealing with that, but there's no good faith in this statute,
And
none.
there's none at all, and that's the other point I want to bring up. So I appreciate y'all being here, and thank you.
Thank you. And this would be to any and all of you on the panel, sort of similar to what I was asking the sponsor of the bill, which is, I feel like the bill, the basis of the bill, we don't have a lot of data in front of us. So I do understand, and I appreciate, I'm going to read the Baltimore, you might even be familiar with it, Mr. Schellenberg, the traffic stop deep dive report out of Baltimore County. Are you familiar with that report?
I'm vaguely familiar with it. It's been a little bit.
Right. Well, what I was asking the sponsor, and he's going to share the report, is that, you know, when you look at data or you look at statistics and someone says, you know, 73% of traffic stops were of African American and they make up, you know, a third of the population. I get that, you know, and a reaction could be that is prompted by racial, you know, improper racial bias. But what would help me is if we had more information about, you know, why these traffic stops happen, the breakdown between men and women, the age groups, economic status, reason for the stop, and obviously, my colleague over here, really important to see if it led to other charges, more serious ones. My point is, where would someone like me go to get more information? Or is it so early after police reform, you know, body cameras and things like that, that, you know, we haven't collected enough data, like even the camera, even the videos, and looking at them, collecting them, and, you know, getting important information out of them to discern whether you do have trends in improper traffic stops that have racial bias. Where are we in this?
So I will attempt to dig down deeper into the reports that Senator Sidnor mentioned. But let me just say this. I have when you talk about looking at body cameras, I have 17 full-time staff people who do nothing but 7 hours every day, watch videos, and get them ready for court.
Okay.
I understand the need and the desire to have statistics. I understand the need and desire to want to review this evidence, but you just get to a point where it's impossible.
Oh, it sounds like a horrible job unless you could get AI to do it for you, right? I mean, can't imagine.
We haven't gone there yet, but those folks get to work from home every day, so I haven't really lost many people to that in that job.
We do develop AI that would, not for court, but for data analysis, because I don't think you should punish even a new employee with such a job as looking at those videos hour after hour. But it would be helpful if we could analyze or have more data about these traffic stops, particularly more recently. I get looking in the past, but really, I feel like I have no information to understand the context of what's going on now and whether these disparities that look like race could be other things or not completely racially based.
I will try and get you more stats. Right. The problem is every traffic stop is an individual moment.
Right.
And it can just take one little difference in the facts that makes it different than the other one. And so it's really hard to dig down into that. I think continuing with the training that we were discussing earlier is important, and we're going to always continue that.
Well, I guess what I'm struggling with is I'm hearing from members of the Black community that they feel that the people they represent are still experiencing this problem. I'm hearing from law enforcement saying, you know, a lot of improvement, very few and I think that's probably true, very few police are bad actors. And we have body cameras and we have a bill like this, so it just seems to me it's very frustrating that we don't have a better sense of whether or not this is a perception issue, a cultural issue, or flat out no other explanation but the legacy of racial discrimination, bias, and hatred. Right?
And I think one of our senators over on this side mentioned the poverty issue, and that is.
I brought it up a little, just because sometimes they intersect some.
They do. If you can't afford to get this fixed,
Right.
then that's what the problem's going to be. So, but I will try and dig into some of those stats for you.
Thank you.
Thank you. And good evening. I believe it was the officer from Baltimore City mentioned about degrading policing, and he gave an example of dropping nails and not being able to do anything. I would like to ask our attorney, if the police officer saw someone dropping nails, that police officer hypothetically should be able to make a stop, because you should hypothetically be able to charge them with reckless endangerment, right? For something like that being dropped?
It would have to be more factually developed as to, how they dropped them and what the road was like and whether there were other cars around. Everything turns on the individual details and facts. But, let's just keep it simple. A headlight. And I understand that, some amendments have been put in, and I understand that you have started this process to have conversations. I would have happily had conversations with you this summer to talk about, what a structure could be for this kind of thing. And certainly I'm happy to see what the amendments are, the ones that are switching and taking out. What I'm here to say is this bill as written is very dangerous to public safety and very dangerous to our society.
So the next question is for our law enforcement officers. And I've said to our colleagues that it should be asked, so I'm going to ask you, what is the solution to these disparities that we see in the traffic stops that are happening to the non-white community and throughout? I can speak for Baltimore County, and again, as I mentioned, I know what Baltimore County is attempting to do, but I don't think that Baltimore County is any different than Anne Arundel. I know it's not any different than Baltimore City. What is it that you all are doing to try to bring down these disparate numbers?
I'll let one of my folks.
Thank you.
Respond.
And I'll allow the others to come up also, but to Senator James' question about the data is, I think the important thing that with the data that we have to realize is there is existing data that's out there through the dashboards, and most agencies in Maryland, our data is publicly available. And if it's not publicly available, it can be obtained through Freedom of Information. So the actual data that we have from these stops, I will say, might be a little bit different, Senator, than the data that you gave, but it gets back to the point that you are correct, and I'll agree 100% that the discussions need to be had, and the discussions are important, because probably in every one of our communities here in the county, we have the same concerns from our minority, our communities of black and brown color, like you said, of the same concerns that do get brought up. So perception becomes reality, right? That if the community feels that that's happening, then it really is. So the discussions are important. And to the question of this bill, like the state's attorney just stated, is as written, it would be opposed. It's not acceptable.
But I could appreciate, and I heard when you were testifying, you kept saying as written, as written.
Right,
So
but to have the conversations to where we can find places to where we can come to agreement that, yes, that does make sense for the concerns that rightfully have been brought up, I think that makes sense. But the solution is just that we have to have honest conversations where that there is disagreement, but that we understand that there's differing sides and opinions to this issue, but it has to be that there's open minds with everybody that's going to be part of these discussions and committees that could be formed. So that's what I would say is the discussions need to happen, but they need to be all inclusive of everybody that's going to be affected by any of this potential legislation.
Are those conversations happening in Anne Arundel County?
I believe they are. I know we have a robust community engagement piece that we utilize. All of our district commanders and districts meet regularly with our community associations. We're out in the communities dealing with our with our constituents, but I'm not going to stand here and tell you that there's not some of the same concerns in our county, because they are there. So how do we get better? We have to keep having the conversations, but then we have to have action. But the action has to be something that's acceptable to everybody and that it makes sense. And I think that's the problem with this legislation, is that as it is written, it really does not get to the problem that we're trying to solve.
And if I might ask, are you aware of your data in Anne Arundel County?
Yes, our data is available, and we can provide all of the data on our traffic stops.
Are there disparities that would be glaring?
I would say that there are disparities. I'm not going to cite numbers off the top of my head, but I would say that they're different than the data that you provided.
If you could provide it to the committee, I would certainly
Absolutely.
appreciate it. Thank you very much.
No, that's the question.
Thank you, Mr. Chairman. My question is for Mr. Boatwright. And as you're coming up, Mr. Boatwright, just, I was so moved by my colleagues' testimony here, and no one should be treated the way you were treated. I went to high school in Silver Spring, so I grew up in a diverse area, and I've heard the same story from friends and people I grew up with. And a lot of them, it was when they were teenagers or in their 20s, but I keep in touch. A lot of them, it's still happening. And these are accomplished men in their 40s. And so I kind of want to re-ask Senator Sidnor's question, but on a more personal basis, if that's okay. I mean, you were Black before you were police.
Yes.
Your family is not police. You have sons, nephews, uncles who have been impacted by this. So I guess I want to hear more personally how this issue has impacted your family, and then how you see what the path forward is on that based on your personal experience.
Senator Walsh-Reicher, well, Vice Chair, thanks for that question. My history is I grew up in the 21217 zip code, which is historically one of the worst zip codes in the country for crime and violence against African Americans. And that is the Sandtown Winchester community of West Baltimore. And so Senator Henson raised a great point when she asked Senator Sidnor, is implicit bias, can it be cured? And that's because based on my lived experience as a young Black man, we were told that all white cops were racist. All white cops were racist. That's what we were taught in our community. And I can tell you that as a 25-year veteran law enforcement officer, I can say that that is not true. And so my perception as a young person has changed. And I can tell you that when we start educating our communities and giving PSAs and spending time on developing that relationship between communities and police, then I think that we'll see some of the perception of both law enforcement and both members of the public that have bad perceptions of law enforcement. I think that will start to change. The Maryland Police Training Commission forces us to have implicit bias training during in-service each year. And so I think we're starting to have those conversations, and I would have loved to have sat with Senator Sidnor as we developed this. I've had conversations with one of the panelists in support, and Mrs. Levy, as we talked about, we from the FOP, we want to see the disproportionate numbers of traffic and bad interactions decrease. We want to see that. But as a career law enforcement officer, we're not actually out there stopping cars like we used to. We're just not. We just don't have the people to do it because we're focusing on real crime. And so I get it that we want to see these offenses as a secondary offense. However, I think that it takes a tool out of the tool belt of our men and women that are trying to make our community safe.
All right. Thank you very much for that reflection and insight. Any other questions from the committee? All right, thank you very much. Thank you.
Thank you.
All right, we'll now hear from, is Chief Morris still here? Chief Morris, Angelo Consoli, Marriott Williamson, Grant. Okay, come on up then. And it's, I guess, Steve Kroll, here you are. Steve's here. I think Grant's gonna. Chief.
Good evening, Mr. Chairman, Mr. Vice Chair, members of the committee. David Morrison, Chief of Police for Town of Cheverly, testifying in opposition to this bill on behalf of the Maryland Chiefs and Maryland Sheriff's Association. You have our written statement. It's very detailed. I just want to address a couple of very brief issues. One is the revenue that's being stolen by the state by Marylanders that flagrantly disregard our laws as it relates to vehicle registrations, vehicle inspections, emission requirements, insurance requirements, et cetera. I would refer the committee to the out-of-state motor vehicle improper registrations report that was provided to the governor by the Maryland Department of Transportation dated January of 2025, where it denotes nearly $12 million in lost revenue to the state as a result of these flagrant violations. I'll just close briefly because I know we're limited in time. The idea that we're going to penalize police officers, as been stated by Mr. Schellenberger, is just outright disgraceful. Only the NFL has more armchair quarterbacks than our law enforcement agency. Thank you.
Good evening. I'm Lieutenant Aaron Brandt with the Anne Arundel County Police Department, Section Commander for the Traffic Safety Section in our Special Operations Division. I stand before you today to represent Anne Arundel County in our opposition to Senate Bill 292. In our partnership with Zero Death Maryland, we are constantly assessing ways that we can prevent fatal crashes. I can only imagine the heartbreak of a family whose child was struck by a motor vehicle who had no headlights or one headlight because that child could not be seen while they were crossing the road, because it is very difficult to see small children in the roadway as it is. Reduce that lighting. I can only imagine how much worse it could be if you couldn't see a vehicle and you merged into it, causing a fatal traffic accident or crash on 97 because you didn't have mirrors on the side of your car or rear view mirror, and perhaps you moved into the oncoming lane of a vehicle. This also talks about the fact that officers shall document all reasons for traffic stops and any other citation and report resulting from that stop. The ambiguous language of this may suggest to officers that they need to cite every single violation instead of having a constructive conversation on traffic safety laws when they do in fact pull a vehicle over, resulting in multiple citations being written in instances that could have had constructive conversations. I urge you to vote against this. Thank you.
My name is Angelo Consoli. I'm the second vice president for the Maryland Fraternal Order of Police and the president of Prince George's County FOP. I'm going to alter my testimony because I think everything I was going to say has already been said 1,000 times, and just address a couple of the things. There is the race-based dashboard for the state of Maryland that exists. Going over the last 5 years looking at it, it's got the statistics sitting at 40, 43, floating between there. White versus black and black versus white. It actually flipped in those 3 years. It's not as high as the numbers that you provided. And if you actually look in and drill down, and you can actually go in county by county, look at the different charges, pull out even the equipment stuff, you'll see that a lot of that's driven by Prince George's County, Baltimore City, and Montgomery County, and Baltimore County, because we have a high black population. We are also over 1/4 of the stops in the state of Maryland. And so statistically, if you look at things, you just have that. If you have a high number here, lower numbers here, it's going to drive the overall number. So you can't use the overall state number. You have to look at the individual counties, the individual areas to see what's what. We've also said we're willing to work with people and on this, and we've always made that clear, and we're still here for that. But I do say go against this, please.
Good evening. Mr. Chair, Mr. Vice Chair, distinguished members of JPR. I'm Jamie Dykes, State's Attorney for Wicomico County. I don't get up here much, but I appreciate you hearing from me today. I urge an unfavorable report as to Senate Bill 292. I'm going to try not to repeat what's already been said. By removing the ability to enforce the law, we remove any reason for nefarious actors to comply with it. Make no mistake, Senate Bill 292 will make driving in Maryland much less safe and will cost our law-abiding citizens more. The predictably tragic consequences of this bill are almost unlimited. It promotes a general sense of lawlessness, which feeds on itself to the detriment of our society. Talk about the exclusionary rule. If an officer fails to notify the driver of the agency that he or she works for, not only is he or she subject to discipline, that evidence, any evidence from that stop, will be excluded. As the Supreme Court wrote in Hudson v. Michigan, the substantial social cost, setting the guilty free and the dangerous at large, is what happens when the exclusionary rule is generated. It imposes a significant toll on truth-telling, and it is not appropriate whatsoever. I understand this bill is a product of one of the Maryland Equitable Justice Collaborative's recommendations. Maryland state's attorneys are always open to engaging in dialogue about ways to balance issues, the issues we are talking about today, but we need a seat at the table. This bill makes us less safe. It's for these reasons that we oppose. Thank you.
Mr. Chairman, Mr. Vice Chair, members of the committee, I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, the Executive Director of the Maryland State's Attorneys Association. I've been prosecuting cases now since 1984. And I've waited 6 hours to say the following. Senator Sidnor, I'm ready to work and communicate with you to find an answer to this problem. That's about all I have to say since everything else has already been said. So I look forward to that. 6 hours I waited to tell you that.
I'm not going to make any jokes about 1984 and how many members on the committee might be younger than that. I don't know. All right. 6 hours, that was worth it. All right. Questions from the committee? Senator Sidnor.
Just one question for our officer from Prince George's. Is Prince George's County attempting to deal with the disparities? And if so, I mean, what is your county doing?
I missed the first part of what you said.
Is Prince George's County, do you have any types of programs to deal with the disparities that are within the data that you have?
Well, I mean, our department takes a very proactive view for all the policing it does. I mean, I think we have one of the finest police academies that are out there. We get trained in all sorts of positions, especially the bias training that was mentioned before. But we have the community policing section that looks into things. We also are statistic driven as well, and with a comp center that I can't speak 100% to what the chief's done on it, but from what I've seen from the outside, I know they look at all these different statistics. And just like I'd say, and I would hope that like all these other reports that get generated based on law, that people are looking at this dashboard. Like you mentioned, it was created because of the MSP incident up in, I forget the county, way up top of the state. And what you're supposed to do is look at it year after year after year for disparities. And no one's came and said anything or come and filed any lawsuits locally saying that we're improperly doing anything. But a lot of that is because the statistics that are within it, I think, fall within some of the norms and or have justifications as to why they're outside the norms when you look at why the person was charged or pulled over or had the incident that goes with them. But the other issue within Prince George's County as well is we do have specific units that gear towards targeted stuff, and we're so busy with other crime, like they mentioned before. I think our traffic stops are probably down well over 50%. Just because we don't have the time to do it. And for the highway stuff, we don't do highways. That's what MSP is for, so we're only on the local roads.
Thank you.
Sure.
Thank you, Mr. Chair. If Chief, if you want to answer, or one of the traffic or the traffic personnel from Anne Arundel, I used to be deeply involved in traffic enforcement. I ran the traffic unit as well, and I'm just curious. Are your agencies experiencing, like, since the police reform, are we experiencing like less people calling in what usually is like the #1 complaint, I think, that we usually hear about, which is traffic-related issues, traffic complaints, speeding, those type of things? Are those things down, or do they just disappear? Or are we still, in law enforcement, are you all still receiving those complaints?
To the contrary, Senator. The #1 complaint that I've received as chief of police from our community is traffic, speeding, stop signs, just flagrant disregard. We've had a number of pop-up rallies in the Chevrolet area. Obviously, we have to rely on the county police for their assistance. That oftentimes takes as many as 50 to 100 officers to try to disperse those pop-up rallies. So, no, to the contrary, what I hear from my community is they want more traffic stops. They want more enforcement. Public safety issues addressed as it relates to the traffic stops. And equally important is my community fully understands that that a lot of criminal behavior is interrupted with these traffic stops. In particular, has been pointed out just simply the number of illegal firearms and drugs that we take off traffic stops.
Thank you, Chief. Anne Arundel, or someone, one of you, can you answer? I mean, is that consistent at your department as well?
I would say. I would say that that's pretty consistent with what we're seeing. We do have an increased complaint of speeding violations, unsafe driving, general observations of what you can see just driving up the roadways. We instituted the speed cameras in the previous summer, so in July of '24. We initiated our speed camera program in the school zone areas, but we also are starting it into the residential areas driven by community complaints. So we are receiving a lot of the complaints for speeding, and I can tell you that the fatal crashes in Anne Arundel County, unfortunately, were up for the year of 2024. So that is a concern. And for this year, our serious and fatal crash investigations are largely driven by pedestrian, which would fall right into the headlight problem that we're experiencing. Speed, of course, is a factor, but the headlights are definitely a concern from my office.
Yeah, no, I appreciate it. Thank you. Thank you. Thanks.
Thank you. And I apologize for but the testimony just raised a couple more questions. For the chief, you had talked about the general public wanting more stops, and I'm just wondering if the public understands this distinction between stops for what I'm believing is likely reckless driving and the speeding versus they want more stops because of the types of offenses that we're talking about in these bills.
So, Senator, what I hear from my community is they want us to make traffic stops, that they want us to find those that violate the law, to include these vehicle registrations. 21% of our traffic citations that we, on automated enforcement in the town of Chevrolet, we're talking 1.1 square miles with 3 automated enforcement cameras, and 21% of those violations are Virginia tags with Maryland residents, and there's no way to hold those individuals accountable. So what I hear from my community is they expect their police officers to take a proactive enforcement effort as it relates to traffic and public safety.
And I've heard a similar comment from, I guess, our chief of police talking about that same issue. So the question I have, I'm assuming that would be a legislative fix for that issue?
Senator, I'm having a difficult time hearing.
Would that be a legislative fix for that issue that you're talking about with the Virginia tags?
Well, again, I would refer the committee to the report that was just submitted to the governor from the Maryland Department of Transportation as it relates to the issues with those scofflaws in our community that flagrantly,
right. So what I'm asking
violate the law.
Is does the law need to be changed to address that?
Again, Senator, I got to apologize. I'm having difficulty.
Does the law need to be changed to address that?
Well, I think the laws are in place. I think the enforcement mechanism needs to come from our Motor Vehicle Administration. And yes, sir, if you're asking my opinion, I think that the laws need to be tightened up as it relates to that.
Thank you.
Yes, sir.
And the second question was for our state's attorney from the Eastern Shore. I think you had made mention that we talked about the MEJC, and I think, did you mention it about having a seat at the table?
Yes.
Didn't the MSAA didn't have a seat at the table on the MEJC?
Let me consult with.
We had one seat at the table. It was 35-1.
Okay. Thank you. Thank you.
All right, further questions from the committee? You guys are locked in tonight, my God. All right. We have Grant Kurlock. Is Grant here? And then I called Daniel Rodriguez. Have I missed anyone? Say what?
I'll go if you want.
Sir, thank you very much.
I would say good afternoon, but good evening, Mr. Chair, Chairman, and members of the committee. My name is Captain Grant Krulak with Harford County Sheriff's Office Special Operations Division. I'm here in front of this committee to ask for an unfavorable recommendation for Senate Bill 292. As a 23-year law enforcement officer here in Maryland, I take pride in enforcement efforts I and our members of our traffic division undertake each day to keep our roadways safe. To me, this bill is tying the hands of law enforcement and aiming to reduce the current primary offense violations that we have and making them secondary violations. Based on what everybody has been saying, there's one thing that I've noticed that has been missed. They're talking about the expired registrations, but also the suspended, the canceled, the revoked registrations. There would be no consequences for people not paying red light camera, speed camera tickets, school bus camera violations. No consequences whatsoever if they don't pay these fees. These improperly registered vehicles, not even displaying the tags at all or allowing them to be covered up, this is going to prevent us from actually being able to go out there and detect and to determine these crimes that are being incurred. So we definitely recommend that this bill is an unfavorable recommendation to report on Senate Bill 292. Thank you.
Excellent. Thank you very much, Captain, for sticking in with us. Questions for the Captain? Senator Sidor.
First of all, I'm assuming you're from the sheriff's office, you say,
Yes,
right?
Harford County.
You all produced that video?
Yes, I was part of it, but I was not in the video.
I didn't see you in the video.
No.
Yes. How are Harford County's data when it comes to traffic stops and the disparities?
So if you look at our data, which is every county is published on the Maryland Office of Crime Prevention. The dashboard is right there, and if you look at our county and if you look at our overall stops for Harford County, it's approximately 70% whites and about 19 to 20% blacks are being stopped.
And your population of?
Population is very close to that. If you look at it, it's, I want to say, it's like 60-some% white and about 16 to 17% black.
Mm-hmm. Thank you very much. And again, outside of, I think the portion of the video that had the two lights out, I thought it was hilarious. So.
All right. Thank you, Captain. Thank you very much. You. So was this? I know you were saying the vote was 35-1 from this commission. Was this exact bill the product, like the exact language before us, was the product of that commission? Does anyone know that? I was going to say that would be interesting.
About MEJC.
Yeah.
Yeah.
So this exact bill was the product of that?
No.
Okay.
Hi, sorry. We were trying not to flood you guys tonight.
I just want like a very quick answer because we are late.
The articulation of all of the purposes of this bill and some of the examples that were in it were shared.
Okay.
And I know that the bill language had been drafted and discussed in a particular subcommittee, but it wasn't shared with the entire committee.
Got it.
Yeah.
There were no legislators on that committee, or were there?
No.
Okay. I know because it mentioned legislators, but I don't think anyone was on there. That might be a good idea in the future, but all right. With that, that'll end the hearings for tonight. See you all tomorrow. Oh my God.